Okay, we ready to convene? Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mr. Villalobos, will you make the TV coverage announcement and then follow that with the roll call?
Yes, thank you, Chair Park, and good morning to the Commission. Planning Commission hearings are televised live on County and Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, Santa Ynez Valley, Santa Maria, and Orchid areas. Rebroadcasts of Planning Commission hearings are on Fridays at 5 p.m. on CSB TV, Channel 20. Today's hearing will also be streamed live on the county's website and will be available for download in a day or two. Now for the roll call, Commissioner Bradley. Here. Commissioner Cooney.
Here.
Commissioner Farini.
Here.
Commissioner Blau.
Here.
And Chair Park.
Here.
Thank you.
Mr. Wilson, will you give us the agenda status report?
Good morning, Chair, members of the Commission. In regards to the status of the agenda today, we have one item on consent, and then we have one item listed on our standard agenda, which is the Cannabis Land Use Ordinance and Licensing Program PEIR presentation by staff. And staff's here and ready to present on that today.
Excellent. Will you go ahead with the projection report?
Mr. Chair, members of the Commission, looking at the schedule for the next few months, our next meeting was scheduled for October 9th, and the item that was on there has been moved at the request of the appellant, which was on the Busy Bee cannabis cultivation operation. I'll get to that later on. As of now, there are no items projected on the October 9th hearing date. The next hearing after that is October 30th, and note that Commissioner Bradley will be absent. We are working with the appellant and the applicants to reschedule Busy Bee for that date on October 30th. In addition, on October 30th, we have Halama Beach County Park Improvements Project and the Coswell Appeal of Agriculture. Well, actually, that's going to be moved to, I think, a November date. It's showing up on your projection report. But as of right now, I believe we will have the Halama Beach, and we're working on having the Busy Bee project on the October 30th, and that is a Santa Barbara hearing. Then on November 6th, we have the appeal of the Santa Barbara West Coast Farms and the appeal of the Santa Rita Valley Ag Incorporated Cannabis Cultivation Farms, as well as the another appeal on that day, the Hacienda appeal on November 6th. And on November 7th, which was a special hearing, we had continued the Helistop project to that date for findings for denial. In addition, we have the Cosmoledo appeal coming that time, as well as Long Range Planning is going to be pulling the zoning ordinance package amendment on that date. And talking to staff, they were looking at having the Caswell appeal on the November 7th date as well. So that will be 2 full days. And then moving to the next hearing, which is November 13th, and that is in Santa Maria. We have 3 items on that day. The Herbal Angels cannabis cultivation application, as well as 2 appeals of homestays. And then on November 14th, there are no items projected at this point. However, that could change as we move forward. And then moving down towards the latter part of the year, on December 4th, we have another appeal of a homestay. That's returning. We had heard that appeal already. We're coming back with findings for denial. The McInerney appeal is coming back with findings for denial on December 4th, as well as the CVW Organic Farms Mixed Light Cannabis Cultivation appeal is coming on December 4th. and that is a Santa Barbara hearing. And then the next hearing after that is December 11th. And that's looking at Key Site 21, major track map on that date. And in addition, all other projects that are pending out there is the Strauss Wind. We still don't know if that's going to make it by the end of the year, as well as the Oasis project in North County. So there's other projects that are out there that have not been placed on the projection report. But as of right now, this is the status of the projection report up until December.
Now, on Strauss Wind, that's one where you were thinking that 2 days in a row would work best, right? Or 2 days in a week, which seemed appealing to me. But is there room for that to fit here?
Mr. Chair, that is correct. At our last hearing, we had a brief discussion on when that project comes forward to have that heard over a 2-day period. Looking in December, there's a possibility that could occur in December, doing the same special hearings that we did, having a Wednesday, Thursday. It could be the 4th or 5th or 11th and 12th. That depends on ongoing communications with the applicant and our staff as far as the status of the project. And we'll know more in the upcoming weeks if that's a viable option.
So we'd look to do that in December. Okay. You know, another question, and it's going to make you wince, Mr. Wilson, but I have to ask it for the benefit of my other Planning Commission members. I keep reading the Montecito Planning Commission portion of the report, sort of by accident, and I keep seeing the one item on October 16 for planning and development website demonstration. And I know that they have more lawyers than we do, so they're more trying and more difficult and probably need more tech advice than we do. But I've got to ask my other planning commissioners, would you want to have something like that, a planning and development website demonstration? Just because it will have already been rehearsed for the MPC.
Yeah, I think if they could fit that in, I'd like to see it.
I told you you'd wince, Mr. Wilson. Anyone else? How about you, Mr. Blau? Would that be something you'd like to see?
Actually, I don't have any trouble getting stuff off the website, and if I wanted to do that, I think I would just simply go view the Montecito Planning Commission report. We're going to be busy enough, I think, with this cannabis appeals that I'm not really interested in any more meetings, to tell you the truth. I can get what I need to know if I watch the Montecito hearings.
That's right, we can watch it on
For me,
video.
it's not that.
Well, maybe we'll get together at a bar and watch that. Good. Okay. Good. Any other questions on the projection report of Mr. Wilson? Okay.
So, Mr. Chair, one last thing.
Sure.
We may want to trail this to the end of the meeting today, but being that October 9th has no items projected for it, we could take a motion to cancel that meeting. But depending on the conversation discussion, we want to leave that date open for right now and decide at the end of the presentation today.
Oh, are you thinking that possibly today might push into that? I mean, that's conceivable, I suppose, but yeah. Okay, that makes sense. Well, let's just remember to bring it up. I won't remember, but you will. Okay, good. Do we have any public comment on items that are not on today's agenda?
Yeah, I know. That's
Okay, very good.
today's agenda.
Do we have any planning commissioners' informational reports?
I do have a public comment. If I could make my public.
Okay, and is it on something that's not on the agenda?
Well, it's a threshold issue that needs to be dealt with right at the outset, and won't take very long.
But is it on item number 1 or is it not on item number 1?
No, it's on the cannabis issue.
Oh, item number 2.
It's a threshold issue, whether it should be heard today or not, and this is the only opportunity to present any discussion of it before it's actually dealt with by the commission.
But it's not on the issue of the PEIR, or is it?
Yeah, it's on whether it should be heard today.
But you need to wait till we put it in the record, so I think
Yeah.
it's on today's
I'll wait
agenda.
until later, if I could discuss it before we actually get to the matter. I don't know.
Okay,
It's just
tell me your name so I can kind of slide you in early on the public comment.
Yeah, Dave Clary.
Dave Clary, okay. Why don't you go ahead and take a seat for now, and we'll catch up with you later.
Okay.
All right, thanks. All right, Planning Commissioner's informational reports. Do we have any? I'll make one. We had Santa Barbara County Farm Day on Saturday, and that was sponsored by SEAG. Is that right, Mr. Ferrini? And there were several really wonderful operations available to the public. I only made it to 3, but they were tremendously informational. Especially, I was impressed at Primus Labs, all the work that goes on in testing for our farm products. And it just makes me think that I remember in the old days when the Planning Commission would all troop off together and do site visits and things. I somehow, if we're able to re-engineer that kind of thing where we could take tours and do educational site visits, not for projects, but just to learn something. It disturbs me that we decide so many issues relating to agriculture and maybe we don't know exactly how the process works, and that's probably true of other things. So there you go, that's my musing, but I thought that Farm Day and whoever participated in it did a great job. Okay. We have on our agenda reconsideration of the minutes of August 28 and September 4, but we already approved those. So unless somebody wants to look at them again, let's not. Okay. Then we'll move on to the director's report. And Ms. Plowman will render that on to us. You're up to bat.
Good morning, Mr. Chair, members of the commission. A couple of things to report. Yesterday, the Board of Supervisors heard the knee appeal, which was the appeal regarding the tennis court. And the board denied the appeal and upheld the commission's decision to allow the permit to go forward and be issued. And then also one other item, Mr. Clement and I are currently working on the long-range planning status report that we'll be bringing back to the Planning Commission just for an update on where we are and the priorities that the board gave us in terms of the work program. And we anticipate that'll be coming towards the end of October, beginning of November.
Excellent.
And I don't have much more to report since last week. So I think that sums it up.
Because the Patterson appeal's over, huh?
Patterson, so far.
So far.
So far.
All right. Okay, that's our running joke. So our next item is our consent agenda. And Mr. Villalobos, will you read that into the record?
Thanks. Yes, thank you. The following is a hearing on the request of James Clary, Agent for General Services, Real Property Division, to consider case number 19 GOV 10, application filed on August 30th, 2009, for a determination that the granting of a non-exclusive utility easement to Santa Barbara Preserve LLC for future waterline installation conforms with the comprehensive plan of the County of Santa Barbara pursuant to California Government Code Section 65402A.
Okay. Do any members of the commission want to move this item into the standard agenda?
What do I do here? I have to do that, sorry.
Oh, the silence.
I'm
means
sorry,
that-
Commissioner Park, Chairman Park, I think there's a public comment on that, and I don't know protocol-wise if that requires it to be pulled off the consent, but I was prepared to make a motion to approve it, so I'm not sure what happens if there's a public comment.
Well, if the answer is no, you don't move it into the standard agenda, then I ask for public comment. And if it moves on to the standard agenda, I'll also ask for public comment. So either way, it's going to get public comment.
Okay, would be happy with it not moving to the standard agenda. Oh, so I move to keep this on the consent calendar
Second.
and approve it. Well, why would we do that for public
I
comment?
I don't think we need a motion to keep it on the consent calendar. I think we need a motion to put it on the standard agenda. And I'm seeing a lot of befuddled people at the table in front of me. Is there something we need to address, Ms. Richardson?
Mr. Chair, excuse me, I was talking to Director Plowman and missed some of the discussion, but if there's public comment, I would recommend taking it before voting on the consent item. Whether or not it's removed from consent agenda, since there's only one item, it's
Right.
not a
Right.
big deal.
Yeah. So since there's not a motion at this point, then I'll ask for public comment. And we have public comment, just this one. Mr. Chitillo?
Good morning, Mr. Chair, members of the commission. I'm Mark Chitillo. I'm the former attorney for the San Marcos Preserve, the Coalition to Save the San Marcos Preserve. It's been so long. And I haven't spent a lot of time with this item, but I have to say that I'm concerned when I took a look at the map and realized that what's being proposed is a water pipeline that's traversing the open space area and the park. When I know that this issue was not addressed in the environmental impact report. This was not part of the project description. So I would assume, I wanted to first get up and just flag for staff that we expect that there would be environmental review for any land use permit or other entitlement that's being issued here. With respect to the commission's jurisdiction this morning, general plan conformity determination as to whether to grant this easement, the key issue, several. One is that we haven't looked at what I think we all expected, or at least it's not been part of the discussion of in the staff report and the materials, as to what we thought was going to happen, and that was that water service would be provided to the West Mesa area under the Bridge to Nowhere. That is the utility corridor that would avoid having to traverse what is ESHA in the designated remainder in the park area. When we resolved this case, it was the expectation that 200 acres would be protected as open space lands. And while it's not necessarily in the county code, just by parallel under federal law, one does not put development projects or utility easements corridors through parklands. And I think that's a significant concern with respect to the environmental resources that are present there. And according to the staff report, there are Eastern Goleta Valley Community Plan issues that call for minimum buffer areas and setbacks. And I would it would appear to me that the project here is not only the installation of the pipeline, and the project is granting the easement, but as under the easement, there is both the installation of the pipeline as well as the ongoing maintenance. And so this is an area that the coalition and our successors, Channel Island Preservation, have put a lot of resources into doing habitat restoration. And I think it's important, and I'm not sure, I don't know that we have the information, and this is the challenge of our agendas coming out so late in the process and the cycle, so I didn't have a chance to really dig into this and get a letter to you, but I have this concern, and I think that's appropriate for the commission to know answers to the questions as to whether this pipeline easement is proposed for any of the areas that have been either already restored or proposed for habitat restoration as part of that project. So I appreciate your indulgence and apologize for raising this at the last minute, but it's a significant issue, and I appreciate your consideration. Thank you.
Well, this is the process, so don't apologize. But I take it, Mr. Titillo, you're thinking this should be moved to the standard agenda and explored? Is that the upshot of your comments?
Mr. Chair, I think that would be appropriate, yes.
Okay, let me ask, do we have staff here right now that can respond to Mr. Titillo's comments?
Mr. Chair, we do have the staff planner assigned to this project that is here that could answer some of the questions.
You can do it right now.
Okay. So if we move it to the standard agenda, we can have staff available to answer questions.
Okay, well, the first question is we move it to the standard agenda. And if we have staff here right now that can address whether that's a good idea or not, I'd like to get that. And then since it's in the second district, I'd ask Commissioner Bridley to weigh in on whether she wants to move it to the standard agenda or not. You ready to make a decision on that before you hear from staff?
Yes, first let me do two things. One, I spoke with the agent for the General Services Department, and he informed me that the project would be coming in for a development plan amendment to actually deal with this relocation of the line. So there's going to be a big bite at the apple later, if I have that correct. If that's something that requires further discussion, then okay, then I'll take a motion to, or make a motion to actually move this to the standard agenda.
Okay, so we just heard a motion, if I heard you right, to move this into the standard agenda, and it was seconded by Commissioner Cooney, correct? Okay.
Commissioner Bradley.
Aye.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
And Chair Park.
Aye.
Motion passes 5-0.
Okay, so now the question of when to do this. Are we ready to do it now? You're ready? All right.
Good morning, Chair and Commissioners. Commissioner Bridley is correct. We do have an amendment on file and in process that is analyzing the consistency with applicable policies and associated with the physical development of the water line. The 65402 deals only with the granting of an easement. I can comment on some of the items that Mr. Chatillo brought up briefly, if you wish. The water line is a directional drilled water line, so it's underground. So while there are certain areas that we're analyzing under the amendment that may have biological resources impacts, our findings at this point seem to indicate that the EIR that was completed for the Preserve at San Marcos project is adequate to cover those issues. But again, that's in process, and the 65402 does not involve physical development. That would be analyzed under the amendment that is currently in process.
Do you have anything else to tell us as part of your staff report?
I'm Chair Park, I'm happy to answer any questions that you might have regarding the details of the physical development, but with regard to the 65402, I think I would focus the discussion on the fact that it's for the granting of an easement, that it has been reviewed by Parks and General Services, who have no issue with the granting of the easement, that it's coming at the request of General Services Real Property Division, and that with regard to the easement, we found it in conformance with the general plan.
Let me ask a question before I forget it, then I'll call on other commissioners. Mr. Chatillo made the point, if I heard it correctly, that it was unusual for an easement to be granted over park property. Did you hear that, and can you respond to that?
Chair Park, I don't know that I can, I believe that I happen to know that there's many easements over park property in various areas of the county. I'm not sure if they line up completely, with all of the specifics of this one. But I would say that the important part of this is that we did talk to Parks about it and have their okay, that it's directional drilling. So it for the most part would be involving very little ground disturbance, which again isn't associated with the easement itself. The other piece of information that I think is important, based on Mr. Chatillo's comments, is that this request, the change in the alignment of the water line easement, came because the Gleater Water District indicated that the previously approved alignment was not feasible because it would reduce water pressure to an unacceptable level to their current customers. So the prior alignment is not a feasible option at this point, which is why the applicant and General Services are seeking this this easement from the county.
Well, thank you, and I appreciate you appearing today when you probably didn't think you were going to have to give a staff report. But Commissioner Cooney?
Thank you, Mr. Chair. Ms. Liu, just a question I try and ferret out on these consistency reports is what is the benefit to the public, to the county, and this application flags the provision of water to the park area as all I can see. I don't know if there's consideration beyond that, but let's assume that the county does get a water line that goes to the open area. From what you know of the project, is that benefit to the county something that will be reviewed in some future public hearing based on the application?
Chair and Commissioner Cooney, what I know with regard to the benefit to the county is that under the prior alignment, the county would have been required to, in order to tie into the water line, they would have been required to install a much longer line of their own in order to serve the park. And with this realignment, it comes much closer to the park, so it will reduce the future cost to the county for connecting into that water line for service to the park. That is something that will be addressed, although probably briefly in the amendment that's in process for the water line installation itself.
And final question, with regard to that amendment request, is that reviewable at zoning administrator level? Do you have an idea where that will be heard?
Chair and Commissioner Cooney, we have it identified as a director level amendment request. So the staff report will be available to the public, and public notice will be sent out. It will be a director's level decision, but public comments can still be made on that report, and it can still be reviewed by the public.
And appealed if agreed.
That's correct.
All right, thank you very much.
Do we have any other questions? Commissioner Farini.
Yeah, Ms. Luz, one of the questions that Mr. Sotillo brought up was on the maintenance of the line. So I understand the directional boring and how it won't disturb. How would that be addressed if maintenance were necessary?
Chair Park and Commissioner Farini, first, I again want to make the distinction that this is for the government code consistency determination for the easement and not the physical development. And one thing I didn't state earlier is that the recordation of this easement would not occur until the approval of that amendment was obtained. So we won't be in a situation where there's an easement without the ability to actually construct the water line. That's a bit of an aside, but my understanding is that there will be certain access points that will allow for maintenance of the line, and that that will occur it won't be required at very frequent intervals. The agent for the project is also here today. He might be able to provide a little bit more detail on the of the maintenance process for the line.
Okay, thank you.
Any other questions of staff? Mr. Cleary, if you're here, do you want to make a presentation?
Steve.
Okay. So we want to have a separate applicant presentation?
Chair Park, are you requesting a presentation from the applicant? Steve Fort with is the agent working on the amendment portion of the project.
I just read James Cleary here in the agenda, but that's fine. I'm not requesting it. I'm providing opportunity for it. And if you've asked me if I request it, do any of the other commissioners request it? No? Well then, if the applicant doesn't want to do one, and if the commissioners aren't requesting it, let's move on to public comment. Is there any additional public comment on this item? And Mr. Sotillo, you've spoken once, but now that we've had a staff report and so forth, I think you're entitled to speak again.
Thank you, Mr. Chair, and I'll be brief. We would ask that the commission does defer action on the 65403-402 decision today until we have seen the full project description. And I would remind your commission that we faced the same situation with the Tahiguis Recovery Project and a 6I-402 determination that your commission considered and elected to defer until the environmental review process was complete. And then that gave the opportunity for an evaluation of alternatives, an assessment of impacts. It's unfortunate from a process perspective that this will be a director's level determination because there is no decorum. It's very limited notice and very limited opportunity for actual input as to the matters that the director is considering, like you would have with your commission. That's neither here nor there. But we would think that it is appropriate, since this will be coming as a package for the director to consider, that the public does, your commission can provide the decorum that we otherwise are not able to get as a result of the director's determination on a development plan amendment. And so we would ask that you defer, allow us to see that so we know what are those areas that are going to be impacted. We don't know that. We just have heard generally that there's going to be underground drilling. And so that would provide, I think, better public engagement and transparency in terms of what the county is proposing to do with lands that were part of a very important bargain benefiting the community with respect to this significant project. Thank you.
Thank you. Do we have other speaker slips for this item? Do we have someone who wants to speak?
If I may, I'm Chuck Landy with Santa Barbara Preserve, and Mark, as usual, knows the facts very well.
Mr. Lammy, let me ask
Yes.
you to do me a favor. When you leave, would you go fill out a slip and bring it
glad to.
here, just so we have it in the record?
Sure, be glad to.
Go ahead.
I'd like to hit a couple points. One, that 200 acres was given as part of the bargain to the county as parkland. And originally, Goleta Water District wanted to serve this portion of the site from the west side of 154, either going under 154 or going across the bridge. What Ms. Liu stated earlier is correct. We are here now, several years later, ready to build it, and they're worried about pressure coming from it. They asked us if we would come up Senegitas and go across. Our first concern was going across potential ESHA areas, and lo and behold, the engineers came up with the concept of this directional drilling, so we stay out of it. So the portions of the site where going through the parkland where it does surface are in an existing road. It's existing today, will be in the future, so we're not interrupting ESHA. There are two places in that road where we drill down through, make a connection, go across another connection, and then drill back up. So we're not hitting any areas whatsoever. Obviously, if Goleta Water District in the beginning would have said, hey, we need to come up and serve it from Senegitas versus the west side of 154, an easement I'm sure would have been retained prior to issuing that land to the county in the first place. So this is just a clean way of avoiding ESHA, avoiding any issues, being able to maintain it long term and go forward. So we think it's a clean process, and that's why staff has addressed it this way.
Thank you, Mr. Landy.
Any other questions relative to this
Commissioner Cooney?
that I could answer?
I think so. Mr. Landy, good morning.
Morning.
What would be the disadvantage to your project if we deferred this for a short time to give the public an opportunity to raise any issues that haven't been raised this morning?
As I have in the past, I'd be glad to sit down with Mark and go through the detail and bring our engineers to do so to show that we're not impacting anything that he is worried about.
That's what I'm thinking.
Quite frankly, as usual, this has been in process for quite a while, and we're ready to go to work. The first phase of the project is being completed now, and we're ready to start this, so it's time. That's the impact.
Ms. Plowman, you look like you have something to say.
I'd like to, Mr. Chair, just contribute something to the conversation. I just want to make sure we don't start commingling the easement and the project. Your action today would allow for the recordation of an easement if the project goes forward and is approved. So the amendment to the development plan. So I think you're not at any risk in allowing for the action today to go forward, that there won't be public involvement in the development plan amendment process. I also want to make a correction to something to Mr. Shatillo said. The noticing is the same as it is for a planning commission hearing. So They get notice 10 days in advance of any action that would be taken by the director. And then we're happy to sit down and talk. He can come in and look at the plans. He can ask questions. So they'll have plenty of opportunity to learn about the project and ask questions. They can meet with the planner, the applicant. So I'm not overly concerned about you taking action today because there's an opportunity for people to be involved in the development plan amendment, and the easement probably wouldn't be recorded if the project were ultimately denied in some form.
Your light's still on.
It is. Just continuing along and with Ms. Plowman's admonitions in mind, I'm not looking to stall the project. What I'm looking for is an opportunity for, as you said, sit down with Mr. Shitello, who knows, at least historically, a lot about the project, and provide him with information about this. As I understand the process, and Mr. Wilson can correct me if I'm wrong, all we're doing is recommending or indicating that it appears to be consistent with the general plan, and the final decision of transferring the easement is not ours, it's the Board of Supervisors. So there would be opportunity to do that if we don't grant any continuance. But I just wondered if there was any unusual, if a little delay was going to be problematic, and I take your answer that you're ready to go. So yes, thank you very much.
Thank you.
Okay, thank you, Mr. Landy. Do we have any other speakers for public comment?
Still have a question.
Oh, Commissioner Briley has a question of you, Mr. Landy.
I'm sorry. You guys, long week already. I'm not sure whether it's a staff or a Mr. Landy question, but I've handled many of these, like in Nicole's chair for the city of Goleta, and it's often coupled with a development plan concurrently. So I'm wondering if there's something from the applicant standpoint that's necessitating this to come ahead of the development plan amendment? Like, is there some negotiation with the Goleta Water where you have to demonstrate that you've gone through this hurdle before they... Anyway, so it's really a process question.
Right. Mr. Chair, Commissioner Bridley, the Planning Commission has to approve the 65402 determination, and the development plan amendment is not coming before the Planning Commission.
That's why it's bifurcated. Okay.
Correct.
All right. So then the question still remains then for the applicant, what is the disadvantage of waiting until, you just don't want to have another couple weeks after the DVP is acted upon to come back to the hearing for this?
Yeah, I mean, quite frankly, this has been in process for months, so we're,
Okay.
everything always takes longer than you want it to, unfortunately.
Okay, any other public comment? Then we'll close the public hearing, move on to commission questions or deliberations. Any questions of staff? Then let's go ahead with our deliberations, and we'll start with you, Commissioner Riley, because it's your district. What would you like to do?
I completely agree with staff that this separation is not dangerous for the public process, to Mr. Shitilla's point. And I know that there's director's DVP pending, and that's also appealable. So there is plenty of chance to have further discussion. And I also recommend, obviously, that staff and Mr. Shitilla sit down before that DVP is even published and try to hammer out some of these issues. I'm sure the applicant would be happy to do that too. So my inclination would be to move for approval of the item as recommended in the staff report today.
And is that your motion?
Yes.
Okay, do we have a second?
I'll second.
Okay, do we have any further comments as part of Commissioners' deliberations? Then we'll proceed to the roll call vote, because Commissioner Blouse in Santa Maria.
Commissioner Bradley.
Yes.
Commissioner Cooney.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
Chair Park.
Aye.
Motion passes 5-0.
Okay. Mr. Villalobos, will you read the, what was item number 1 on our standard agenda?
Yes, Chair Park, thank you. The Planning Commission will receive a presentation from Planning and Development staff on the Cannabis Land Use Ordinance and Licensing Program Programmatic environmental impact report, and the Commission's discretion when considering cannabis projects.
All right, do we have any ex parte or site visit disclosures from commissioners?
Yes, I met with Mr. Clement this week and got a briefing. I've also been on 4 site visits in the last week and a half to try to get myself up to speed. If I have to say where they are, to Mr. Farrar's operation on Foothill and Mr. Van Wingerden's, and I met with the Pences last week, also to get my understanding about the whole cannabis issue. So.
Any other disclosures? This is a hard one because it's been how many weeks since the last hearing? It was 5-6 weeks. So thinking through all the people I've talked to since then, let's see. I met with Mayor Sierra of Buellton and the city manager, Scott Wolf. Let's see. Visited the farms of Mr. DeFriel, and spoke on the phone with Amy Steinfeld, and met with Stephen Janes, the chairman of the board of the Vintners Association, and I hope I haven't left anybody out. Oh, yes. And I met with Sharon Merritt and Judy Stauffer. And countless meetings with staff, but those don't count as ex parte visits of any sort. They're just social. Okay, any other disclosures? Okay, let's move on to our staff report. You ready to go? Eat a lot for breakfast, so this is going to take a long time, right? Go ahead.
Mr. Chair, members of the Commission, I'm going to make some introductory remarks, and then I'd like Ms. Richardson from our County Counsel's office to provide some also introductory remarks, and then we'll start with Erica Leachman and Mr. Clement. So we have, today we've invited Wood Environmental, who prepared the original EIR, to be a part of this presentation and a part of the effort to provide information not only to the Planning Commission but to the public just about the process.
Can I interrupt you for just a second?
You sure may.
And I should have said this as an introductory remark. And this may seem obvious to folks, but we should make it clear about process. This will be a long staff report today by multiple people, but we're still going to have public comment. I know there's a lot of people here, and you're raring to go, and we want to hear you. So there will be public comment following this, even though it's a workshop format. So go ahead.
Thank you. Sort of the genesis of this concept of holding a workshop came about 2 months ago, roughly, when we were in Santa Maria hearing an appeal on cannabis. And there were just a lot of questions about the programmatic document and some, in my view, misunderstandings from the public's perspective about it. And we thought there would be a lot of value, given that the Planning Commission is going to be hearing multiple appeals on cannabis projects, to just sort of get a refresher on the programmatic document, the process of programmatic documents, sort of even some higher level information just about the state of California and the Office OPR, who's been giving guidance about the use of programmatic documents. And then also talk a little bit about what was covered. You know, it was a while ago that the commission, and now we have a new commissioner, that you heard about the types of impacts that were covered, the impacts that were overridden by the Board of Supervisors, just to give you this refreshed background for you. We also want to make sure that the commission understands how we're analyzing each project as it's submitted within the context of that programmatic document, and the process that staff goes through to determine whether or not the impacts were addressed in that document for that particular project. And if it's not, what do we do? And then talk a little bit about the tools that are available to the commission when they're reviewing these applications. because I think, again, it's important to remember that there are other elements. A programmatic EIR or any environmental review is an informational document. So that's one set of facts that the commission has when they're analyzing a project. But you also have numerous tools that are available. They come from the comprehensive plan policies. They come from the community plans, which include policies and development standards. There are findings that need to be made with each permit type, whether it's a coastal development permit or a land use permit, a conditional use permit, or a development plan. And those, you may need to think about conditions that would be added to a project to be able to make those types of findings. And then the development standards that are in the cannabis ordinance. So just so you get this broad perspective of everything that's available to you when you're reviewing a particular project that's in front of you. And then our hope is that we have an open conversation today. We're interested in hearing the public's perspective and hearing the commission's perspective, and we'll try and do what we can to respond to any questions that come up as quickly as we can. So with that, I would like to introduce Erica Leachman, who was with, as I mentioned, Wood Environmental. We also have Matt Buggert here, who has worked with Erica on helping prepare this presentation. And Erica will start, and then Mr. Clemon will finish up. And so, I'm sorry, I did want to have Ms. Richardson provide some information about the process here today before Erica, Ms. Leachman.
Why don't you go ahead, Ms. Richardson.
Mr. Chair, Commissioners, so the presentation will go into much more detail, but I just wanted to briefly go over the legal framework of the program EIR. So the board certified the program EIR in February of 2018, and that action was not challenged in court. So the PEIR is complete and certified. And what that means is that there are no revisions to be made to the PEIR itself. Recirculating the PEIR is not something that's on the table. But the question going forward for your commission on individual projects is whether the PEIR plus a checklist is adequate environmental review. And planning makes a recommendation related to CEQA on projects, but ultimately your commission has the discretion to decide if the CEQA review that's recommended is adequate or if you require something more. And as with most determinations, that must be based on substantial evidence. So today, as part of this workshop, there's no action to be taken by the commission. It's more informative and to allow the commission to provide general direction to staff about where you may stand on future individual projects. And then going forward, for when individual projects are considered by the commission, if you determine that the program EIR and a checklist is not sufficient, then you could direct staff to prepare additional CEQA review, and that's an appealable decision. And additional CEQA review could consist of an addendum to the PEIR, a supplemental EIR, or subsequent EIR. And then just a note, procedurally, if the commission directed more environmental review, that's an appealable decision, but just the CEQA would be heard by the board, not the substance of the project. So then the board would weigh in on the CEQA question, and then the project would return to your commission for consideration of the substance of the project, consistency, and the findings. And then, as Director Plowman summarized, outside of CEQA, the commission also has the usual discretion about comprehensive plan consistency and whether or not the findings can be made. And if the commission, for instance, wish to deny a project based on comprehensive plan inconsistency issues, that would be done on the basis of an exemption in CEQA, so you wouldn't need to decide if the project also needed an addendum or anything of that sort. So that's just the brief overview, and Ms. Leachman and Mr. Buggert will go into a lot more detail, but we're here for any questions.
Well, thank you, Ms. Richardson. I think that was an excellent summary.
Great. Good morning, Chair Park, Commissioners. Thank you, Ms. Richardson, Director Plowman. My name is Erica Leachman. I'm a CEQA project manager with Wood Environment, formerly AMEC Foster Wheeler. So that might be something, in reviewing the document that was published in 2017, our team's name was different. Same team, different name. We wanted to first start out today to just step back from the document that is the county's and talk a little bit about program EIRs in general as a refresher, and also in terms of sharing information about CEQA and the statute and what the requirements are and the framework that we were working within in preparing the document. CEQA Guidelines Section 15168 addresses program EIRs. There's a variety of types of EIRs, project level, program level, focused, there's a range. And in selecting the appropriate document to prepare to ensure CEQA adequacy, several things are considered related to the type of project that you're looking at. In the case of a program, an ordinance amendment, a general plan amendment, a community plan adoption, oftentimes you'll see the preparation of a program document, a program EIR, that assesses programmatically the potential impacts for a range of related individual activities, things that would happen that are similar to each other and happen under the umbrella of that adopted program. There's a couple key checks to make about determining what the appropriate document would be, including ensuring that your project actually is a collection of potential items that are related to one another. Also checking to make sure that they're carried out under the same regulatory authority, under the lead agency. And then generally having the same similar environmental effects. A program EIR wouldn't be appropriate if you're considering a program plus something that's just completely unrelated. The project description is required to be clear about what is involved in the program and what is excluded from that program. So that helps ensure that the mitigation programs, the mitigation and monitoring program that comes out of that document is appropriate for any activity that happens under that program itself. In determining the appropriateness of the document, we then look to the programmatic impacts. Once the document is underway, the document looks at all of the potential impacts that could occur under the program, foreseeable and specific. The mitigation programs are general often and cast the net wide to encompass the range of impacts that could occur under implementation of the program in the future. And the key to a program document is that it is, once it's adopted, those findings then can be extended to the individual components of program implementation, the individual projects that are adopted or considered under the ordinance or the community plan or the general plan that is adopted along with the findings of the document. And the intent of the program document coming from OPR and the state guidelines is to ensure streamlining. So in looking at a document holistically at the program level, several of those issues can be cleared entirely environmentally, and the programmatic mitigations would address any issues that come up on the project level to avoid the need for additional environmental review when it's appropriate. In doing so, saves time, saves paperwork, and is a cleaner process for the implementation of a program. That's right. So there's a few advantages when it's appropriate to use a program EIR. It provides a more comprehensive review of the impacts and probably more importantly, the alternatives to that action. When doing planning at a programmatic level, oftentimes the trade-offs between alternatives are policy trade-offs or approach trade-offs in an ordinance, and the program document gives decision makers the opportunity to test those trade-offs and make a decision in context of the broad range of options that would be available for dealing with whatever the case may be. It also allows for program-wide mitigation measures that would apply no matter where you're working, no matter what site you're focusing on. Oftentimes, I think the most familiar situation for this is in general plan adoptions, where the program EIR applies to the general plan as a whole, the land use map, et cetera, and gives the lead agency the flexibility to review the whole of the plan before considering individual impacts on a site-by-site basis. It also avoids duplicative reconsideration of the basic policy issues, the basic policy framework that decision makers are working within, and puts the project in context of a cumulative setting that is much broader than it would be otherwise with a site-specific consideration or environmental review. And the result, as I mentioned before, is less paperwork for projects that fall within the umbrella of the review. Those that don't may be a different situation, but the benefit of using a program EIR is to have those findings apply to those easier projects that fit within the umbrella of the analysis. So with that kind of broad brush overview of what the statute says about program EIRs, and in practice, I also wanted to mention that program EIRs are common. And the direction and the influence that's coming from the state, from OPR, is encouraging the use of program EIRs when possible to help CEQA streamlining, use them as a tool to facilitate streamlining and where appropriate. I also might mention that they are common throughout the state related to cannabis as well. Our team has worked on cannabis projects across the state: Santa Barbara County, Santa Cruz County, Yolo County, City of Los Angeles. What we've observed is that the County of Santa Barbara is not unique to be dealing with these issues. This is a really relevant topic right now, as I'm sure you've heard from public testimony and past staff presentations. And everyone's dealing with it in a little bit of a different way. Program EIRs have been adopted, certified, or not, actually, in several places. And each jurisdiction is dealing with it a little bit differently. So this approach, having a program EIR for a cannabis ordinance, is something that's coming up elsewhere in the state. So we wanted to shift now to talk a little bit about this EIR, this program EIR that was prepared for the cannabis ordinances. As a little bit of background, the document was completed in 2017 and certified by the board in early 2018. So it's been about a year and a half or so of implementation. And moving through not only ordinance adoption and putting those regulations into place, but then also starting to apply some of these findings and process permits for the projects that would fall under the ordinance. So with that background, just to walk through what the EIR did, it was a comprehensive countywide program document. It looked at what the ordinances would allow in terms of cannabis activities, what could be licensed, what couldn't be licensed in the county, and evaluated that potential countywide. It was prepared by our team. As I mentioned, especially at this point, our experience with cannabis is wide. We've done program documents, we've done site-specific MNDs, we've written ordinances, we've kind of run the gamut of the things that are being encountered in California. And as I mentioned, these types of issues that are coming up for the county are not unique. The EIR also included technical research and modeling of key issues, including air pollutant emissions, such as NOxes, nitrogen oxides, terpenes, odors, etc. And in doing so, in looking at the whole of the county, the unincorporated county, and the more precisely the zoning districts that would have allowed cannabis activities, we took a conservative impact assessment approach. Assuming a reasonable worst case for where and how the impacts from cannabis licensing could manifest in the county. Because as a program document, we didn't have a list of sites. We don't know, in analyzing this project, we weren't able to say, okay, well, this program's gonna, it's gonna land here and here and here, and we can, zoom into that parcel and understand precisely what the impacts would be for that parcel. We had to be conservative and broad brush about what could come up countywide, and forecast what would be the issues that would come up on a site-specific basis. And because of that, the methodology is very conservative, and the mitigation measures are detailed and allow for flexibility in decision making, identifying what the key issues are, what the outcomes need to be, and to allow for those mitigation measures to be implemented on a site-specific basis. Because of our understanding of the project, that we don't know specifically where and how the cannabis projects would have shown up, we also ensured that the EIR was full scope. Full scope meaning that it looked at every potential resource issue under the statute, under CEQA, specifically Appendix G at the time, that could potentially be affected in a significant way per the guidelines and county thresholds. The EIR looked at aesthetics, agricultural resources, air quality and GHG emissions, biocultural resources, geology and soil, hazards, and public safety, emergency response. We looked at hydrology and water resources, both availability and potential for contamination, noise sources, public services, transportation, including the potential trips that would be associated by cannabis operations, and then also the demand for utilities and more precisely energy from different licensed operations. As also to keep the document conservative, we evaluated the potential for population and employment changes. So takeaway being that the EIR looked at the full range of resources that would have been potentially affected. I might note that the only resources that the EIR did not analyze in depth were forestry resources. Meaning forested land, because that resource is not is identified by the state and doesn't exist in the county, and also minerals, because we do not have mining that would have been affected by the project. CEQA requires also, as I mentioned, the consideration of project alternatives. In the case of the cannabis program, the alternatives we're looking not so much at the, at site-specific alternatives, greenhouses versus outdoor, that sort of thing. It was looking at policy changes or programmatic changes that would actually shift how cannabis was licensed in the county. The project, to step back a little bit, analyzed the land uses of cannabis. So within the zone districts that would have allowed cannabis, the EIR looked at all those areas and analyzed the potential impacts within any eligible area. We also had information at the time related to a level of interest in the county. The county had done a registry of interested applicants, and so we had some guidance on the total. It didn't limit the EIR analysis. We acknowledged that there was no cap proposed on the total number of licenses that could be analyzed or could be permitted. But the project did not have a cap on that. It was informational to understand the range and the general location where there could be some intensification of cannabis uses. I should also mention subsequently the county adopted an acreage cap, but not a licensing cap. The alternatives that were considered in the EIR included the required no project alternative. So, the analysis of what would happen if the county did not adopt a cannabis ordinance. Not that the county wouldn't have a cannabis, no cannabis. It's just what if this action, this proposal to adopt a cannabis ordinance wouldn't happen. So that's what that alternative addressed. And we also looked at three policy and regulatory framework alternatives. Alternative 1 considered the exclusion of cannabis activities from Ag 1. Alternative 2 considered the preclusion of cannabis activities from Williamson Act lands in the county at the time. And alternative 3 considered reduced registrants, and that harkens back to my point about the registry. Based on the known number of interested parties in pursuing a permit at the time, there was an alternative considering bringing that down substantially to put a cap on how many licenses would be issued. In the end, the county selected number 1. And alternative 3 was considered. There was discussion of that, but ultimately not selected. As a little bit of background, I mentioned about the era that this document was under preparation. It basically was about a solid year of solid work on this issue for the county. And the document was subject to several public hearings and subject to the public input and the decision maker input through the course of these hearings. There were at least 26 official points of public outreach and public input prior to the program's adoption. And that's in addition to the mandatory EIR outreach, including scoping and the public hearings that occurred on the draft findings and the response to comments that our team prepared. And in addition to that, there were 9 meetings for the Board of Supervisors, 4 with the Planning Commission, and 3 at the Montecito Planning Commission over this time period. So it's a very complicated timeline, but I think the takeaway there is that this was an active project over the course of 2017, and we reached the certification hearings in February 2018 after several public meetings and opportunities for input. To summarize the findings, we wanted to kind of circle back, and this may be familiar for several commissioners, but also informational for everybody in the room. The EIR identified several significant and unavoidable impacts. To explain that a little bit is that in an EIR process, the impacts of the project are identified, analyzed, mitigated to the extent feasible, and then a finding must be made about each impact statement. The finding is after consideration of mitigation. A residual impact after mitigation is the finding of the EIR. And through the course of review, the PEIR for the cannabis ordinance has concluded that there would be significant unavoidable impacts after mitigation for agricultural resource impacts, air quality, including ozone precursors, NOxes, VOCs, and odors. Also, significant unavoidable impacts related to the potential for noise impacts and nuisances, transportation and traffic from new trips on the roads, and then also significant impacts related to visual impacts of potential cannabis projects in the county, and specifically the cumulative effect. So the cumulative effect of this project contributing to overall degradation of visual resources in the county, considering other ag development, other urban development, and as a whole, this project being a part of that degradation. We also want to talk a little bit about the mitigations that apply to these resources, but we will come back to that a little later in the presentation. In addition to those resources and those impacts that were found to be significant and unavoidable after mitigation, there were also several resources that were found to be less than significant after mitigation. So requiring some form of mitigation, often in the case of this program, robust mitigation measures, programmatic mitigation measures, that in the end, if those mitigations are applied on a site-by-site basis, the conclusion would be, yes, we could avoid these impacts. It's feasible, it's reasonable, and the finding could be significant or less than significant after mitigation is applied. These mitigation measures manifest in the mitigation and monitoring and reporting program that came out of this process and was subsequently adopted into the LUDC and Article 2, and we'll talk about that in a little bit as well. I wanted to give a kind of a succinct example of how these mitigation measures manifested and behave. A good example is the mitigation measure for a habitat protection plan that addressed potential biological resource impacts. The protection plan is in its essence a site-specific mitigation because it's required to be implemented on a site-specific basis when a project comes forward with the potential to have the biological resources identified in the EIR on site. And the mitigation is triggered when those resources exist, ESHA, riparian corridor, those types of resources. Those would then trigger the mitigation and require the applicant and the county to prepare a habitat mitigation plan and address those resources on a site-specific basis. Basically, in doing so, it does the precise work on a site-by-site basis that the EIR could never have done given its scope of a countywide document and the inability of the EIR to foresee precise locations and the precise setback that would be required on individual cases as they came forward. So with that overview, we wanted to turn to some key program EIR issues. We've been working closely with Director Plowman and county staff on some of the key issues we know that the Planning Commission has been grappling with and has been presented with. So we wanted to dive into a few, starting with air quality. There's two issues that we understand and are emerging issues, key issues that are coming up. Related to two issues related to air quality. Number one, ozone, potential for ozone, tropospheric ozone, which means ozone down by the ground, and then also odor impacts. So starting with ozone, the EIR analyzed ozone precursors in Impact AQ3 for reference. The EIR analyzed and modeled the potential for volatile organic compounds, or I should actually point this out, or reactive organic compounds. They're the same thing. VOCs and ROCs are interchangeable in the county of Santa Barbara. VOCs are regulated at the state and are criteria pollutants for California and the nation. But locally, for our local APCD, the thresholds and the guidelines refer to ROCs. And so the EIR makes that connection, but you'll see that the EIR addresses this aspect in terms of ROCs. So anytime you see that those terms are interchangeable. And then also analyze the potential for NOxes, nitrogen oxides, as ozone precursors. Not to get too detailed into climate science, but to create ozone, you need ozone precursors plus sunlight. VOCs plus NOx, when they commingle in adequate concentrations and sunlight is present, that's the chemical reaction that occurs and creates O3, which is ozone. When that happens in the upper elevations of the atmosphere, that's a good thing. When it happens at the ground level in the troposphere, it creates air pollution and ozone when it can cause health problems, et cetera. This is all detailed in the EIR. The EIR concluded that this potential for ozone was significant and unavoidable based on CEQA and our local APCD's thresholds, and identified a mitigation measure that would address one half of the equation, the NOxes, because those would be coming from the mobile sources for the project, from truck trips and employee trips, et cetera. The mitigation measure would require a transportation demand management program to site by site reduce the need for travel, including ride sharing, et cetera, those types of things. But because we at the time couldn't consider that an adequate mitigation measure or foresee that would actually measurably bring the estimated emissions below thresholds, it wasn't enough to be able to say it would be less than significant, hence the finding that it was significant and unavoidable. So turning now to odors, and we also addressed odors and terpenes. Odors, being the source of the terpenes being the source of odors for cannabis in Impact AQ5. The EIR concluded that this was also a significant unavoidable impact. That odors, could create an impact that would be significant, and that was based on in-depth research into terpenes as the source of those odors. Terpenes are VOCs. Terpenes are, to be more precise about the term, biogenic VOCs. VOCs, there's two types. There's VOCs that are generated by people, meaning anthropogenic sourced, and those are the VOCs that our guidelines, our air quality standards, those are the ones that those guidelines are trying to address. Biogenic VOCs are not subject to those same thresholds, regulations. That being said, the EIR addressed bio-VOCs as terpenes, as a potential for generating terpenes and emitting those into the environment. Another clarification on this matter, bio-VOCs are also ozone precursors. They operate the same way as anthropogenic VOCs. They react to nitrogen oxides and sunlight the same way. And this issue was examined in the EIR. The existence of the bio-VOCs is not new information, which is not known. All plants emit bio-VOCs. But because the issue at hand was terpenes, the EIR focused on the terpenes as a potential odor nuisance, we addressed it in terms of that, particularly because there are no thresholds on odors other than an odor threshold. So we addressed it through that lens. One thing to mention about bio-VOCs is that there has been recent research on bio-VOCs that our team has reviewed. As this issue has come up and has been recorded in comments and kind of reported on, our team did a lot of background research on what is known about bio-VOCs. The issue has been studied since the turn of the century, and then mainly starting in the mid-century in the 50s. And mostly in terms of trees. Trees are based on our review, the most substantial source of bio-VOCs on the planet. They have the most biomass and have the most potential for BVOC emissions. But all plants are sources of BVOCs, including existing agriculture. I think I'll leave it at that. To deal with the odor impact and the terpene impact, the EIR identified a need for an odor abatement plan as a mitigation measure to mitigate terpene release into the environment. The Planning Commission, you'll recall, recommended stricter odor mitigations than what were in the EIR, meaning filters to keep the emissions from going out into the environment. But the board rejected a zero tolerance policy. The recommendation was to say no odor escapes the property and is not, it cannot go and be perceived anywhere. The board did not accept the zero tolerance policy, but did support odor abatement mitigation for everywhere in the county except for Ag 2 lands. The odor abatement requirement would only be required on Ag 2 lands if it was part of a conditional use permit. If something was being proposed on Ag 2, that would trigger a conditional use permit. So that being said, with that one exception, the odor abatement plan is something that would apply to every other place in the county and offers a range of options for odor control. The options include actual destruction of the terpene molecules themselves through filters or neutralization in other forms. And we'll talk about that in a little bit. So to tie these two issues together and how the EIR addressed air quality and the significant impacts related to air quality, the transportation demand management mitigation addressed mobile sources as ozone precursors, the NOxes. And the odor abatement plan addresses the potential stationary sources of ozone precursors, the VOCs and the terpenes. And taken together, when these issues come up, these two mitigations are available as tools to address these. That being said, even with the available mitigation, the analysis couldn't conclude that we would get to a less than significant effect. And at the end of this work, the conclusion was like, no, we may still have a situation where the project would have a significant impact on the environment related to these two issues, where we would either see significant NOx emissions, significant odor emissions, or significant emissions of both of these pollutants that would generate ozone. So turning now to a couple other key EIR issues, we also want to talk a little bit about aesthetics. The EIR identified significant unavoidable cumulative impacts to visual resources, mainly related to structures. We understood as the program itself doesn't permit structures. Structures, if proposed, would be subject to existing code requirements, development standards. But we understood that that the ordinance amendments would allow for this to happen, and in doing so, the PIR identified mitigation measures to require screening. Understand that in some sites, the proposed cannabis use would necessitate development of new structures that could change the visual setting, particularly in scenic vistas, visual corridors. And the mitigation of screening would help reduce that impact. Also, we recognize that the county's existing development standards would apply county-wide, and that this is also in context of existing regulations, policies, development standards, and otherwise from the comprehensive plan and the community plans. Even within this policy framework and with the added mitigation measure for landscape screening on a site-by-site basis, the EIR still felt that we couldn't say for sure that there wouldn't be a significant impact to visual resources, and so the finding was significant and unavoidable. To discuss agriculture issues, the EIR also identified significant unavoidable impacts to ag, both from the program itself and then cumulatively as well, specifically related to the loss of prime soils. This is related to development, certainly to the direct impacts of development, but then also just the cannabis use of the land that might, preclude the use or result in the loss of prime soils countywide. The mitigation measure for this issue did what it could for prime soils, encouraging the siting when considering the siting of a proposed project to avoid prime soils to the extent feasible. But in looking at the county, the setting for this project, most of the eligible areas of the county are on prime soils. There's some potential sites that we looked at that were all prime soils, so relocation of structures may not be feasible on a site-by-site basis, and because of that, the EIR concluded that it was a potentially significant unavoidable impact, that we may not be able to avoid the loss of prime soils through the implementation of the ordinance. And then also to note in implementation, and we'll come back to this a little bit, that since this topic addressed agricultural resources, this also required a PAC review and the involvement of the agricultural commissioner to ensure impacts and issues related to agricultural land use are reviewed on a site-by-site basis as well. So with that overview of the key issues, the big ones that came through that analysis, the board considered this, the EIR and these findings on February 6th and February 13th in 2018. The board certified the final EIR for unincorporated portions of the county and made findings and adopted overriding considerations for the Class 1 impacts. That's a mandatory requirement of the CEQA statute. The board approved the program as a whole, the subject of the EIR, and adopted the ordinances amending the LUDC and Article 2 to include all of the mitigation measures that the EIR identified. It included the operative date relative to banking and taxation as well. So it basically was a starting point for the county on implementation and has been proceeding over the last year and a half under these findings. I mentioned earlier that we would kind of step back and talk about mitigations, the mitigations as a whole. I detailed some of the specific mitigations related to the significant unavoidable impacts, but we also wanted to just overview the mitigation and monitoring and reporting program. There were several mitigation measures that came out of the EIR and have subsequently been adopted into the appropriate locations in the LUDC, Article 2, and otherwise, the county's permit guidelines, to ensure that the mitigations are implemented on a case-by-case basis, essentially taking those mitigations out of the EIR and putting them in the right place to ensure that they are available to permit applications. Several of, just to overview the types of things that the mitigation monitoring reporting program required, it required compliance with state and local regulations. For context, cannabis is not just a local issue. It's something that's regulated from the state down, and any applicant that is licensed locally also has to comply with state licensing at the time, in place at the time of licensing, and annually. So our mitigation measure ties this local process to the state's requirements as well. The mitigation requires archaeological and paleontological surveys if that's needed for a site. If there's any concern about the potential for cultural resource or impacts, then that's a mitigation measure. The EIR requires an energy conservation plan to deal with potential demands for increased energy and energy conservation, fencing and security, a lighting plan, noise attenuation if there's any potential for a noise generating source such as a generator or nighttime activities. There's signage requirements to align with the county's existing regulations for signs, but then also align with the state's requirements. And in terms of biological resource impacts, tree protection, habitat protection plans, as I mentioned before, a landscape plan and screening plan where appropriate, odor abatement, and lastly, transportation demand management to reduce the trips to the individual sites. As a whole, this whole program applies as part of the ordinance now. It's incorporated into it. Coming to talk a little bit more precisely about a statement of overriding considerations. This is required under CEQA section 15093. Ideally for CEQA, the idea is to identify the impacts and do what you can to mitigate them. And in a situation where you either can't, it's infeasible, unreasonable, or there's uncertainty about whether or not the mitigation measures would, to what degree they would address the impact, CEQA allows a lead agency to still approve a project that will occur in significant impacts if the agency states in writing the specific reasons to support the action based on the final EIR. And that's the overriding consideration, stating that As a lead agency, we considered this record. We've disclosed the impacts, and in the whole of the record, we approve this action with the knowledge of what effect it's going to have. And so for the board, for Santa Barbara County Board of Supervisors, the finding was that the adverse environmental effects of the program were considered acceptable after consideration of the specific legal, social, technological, and other benefits of the program. Oftentimes, adoption and consideration of these large programmatic decisions are met with trade-offs and other considerations in addition to environmental impacts. And the findings for this project were made in context of the whole of the project and the range of issues that the board was presented with. So with that, it provides hopefully a broad overview of the EIR, diving into a couple of the key issues that we're aware of to date. We also wanted to turn now to the current process. The EIR has been adopted, certified, and is available as a tool. And where the county is now is in implementing that EIR. We wanted to talk a little bit about the application of this EIR to site-specific projects that are in process currently. So in implementing program EIRs, this relates to CEQA section guideline, CEQA guideline section 15168. Project-specific review can occur under the umbrella of the program review. The project-specific review that's required under CEQA when a program document has been certified and covers the activities of that individual project is intended to verify the project's impacts would be consistent with the findings of that applicable document. So the exercise in CEQA analysis for a project-specific analysis under the, as I keep saying umbrella, but under the umbrella of the program EIR is an exercise of going through and checking each impact and analyzing whether and how that project falls within that impact analysis. If the forecasted impacts in the program document are directly applicable and it's clear that the mitigation is appropriate for this site and would address all those issues that would come up on a site-specific basis, then the finding can be made that this project, falls within this umbrella, and that's adequate CEQA review for that project. In doing this review, additional environmental review is only required if that later activity, if that site-specific condition would have effects that were not examined in the program document, something that was unforeseeable at that level, or a new issue that was not available at the time. And the CEQA guidelines give clear direction on what to do when that situation comes up. Section 15168, subsection C, subsection 4, address specifically later activities, so things that happen subsequent to certification of a program EIR, and what to do about it. So CEQA says where the subsequent activities involve site-specific operations, the agency should use a written checklist or similar device to document the evaluation of the site and the activity to determine whether or not the environmental effect of the operation were covered in the program EIR. And the county has established a process subsequent to the certification of the EIR that does just this. As a bit of a preview, and for the commissioners, you may have seen this already. This is the snapshot of the checklist for cannabis projects that compels each applicant's case to be reviewed point by point by point, impact by impact, against the program findings to determine whether or not an individual case is consistent with those findings, or if there are unique conditions or project proposals that push the boundaries of those findings. And in going through this exercise, this is something it's included in the record. If the conclusion through this process is that yes, this project is consistent with these findings, these mitigation measures apply, we can make the same conclusions as the EIR, or lesser impacts than the EIR, then this serves as a CEQA document for the individual project. If going through this exercise, any of these questions trigger uncertainty or new information that that wasn't covered under the EIR, then that is a place where consideration of subsequent environmental review would come up. That topic would come up. The CEQA sets forth when additional environmental review is required. Subsequent and additional environmental review meaning a subsequent EIR, a supplemental EIR, and probably more commonly for cannabis projects, a negative declaration or a mitigated negative declaration where additional environmental review is done on those issue areas where more information is available. I'll come back to the biological resources example where when a site comes forward and there's ESHA, an overlay on the site, then that compels some additional analysis. May not require an additional environmental document, but looking at that site-specific resource so that the findings can be more precise to that site is what would be required. A subsequent environmental document, if it's triggered in the review of the case, is required when substantial evidence shows that the new significant environmental effect or a substantial increase in the severity of the effect is possible. And this also is required if the substantial changes occur with respect to the circumstances under which the project is proposed. So if it doesn't fit the project description or if it's in a location that was not covered by the EIR, those are the types of things that would trigger subsequent environmental review. The CEQA guidelines also are pretty precise about what evidence is needed to require additional environmental review. It's related to new information, and including potential significant impacts that weren't addressed, just things that weren't discussed in the EIR. If the impact would be substantially more severe than the residual finding of the impact, that would compel additional review. And in other situations, this is a little bit more rare, but if there are mitigation measures that are identified that were not considered in the EIR because either at the time they were infeasible or not available, but in implementation of the program have become available or have become feasible, then that would be something to analyze to understand what effect it would have on the significance of the impact. And also, if there's a considerably different approach to mitigation that emerges after certification, that's another option. Those cases are generally pretty rare, but it's been known to happen. So in applying the program EIR findings to cannabis entitlements, to the permit applications that are coming in, the EIR provides a detailed review of potential impacts programmatically, countywide, including odor, vehicle trips, et cetera. And in implementation, the written findings need to be made and refined. The analysis needs to be refined to be site-specific and based on the county's checklist that I showed previously. In reviewing the overall findings for the EIR, most permits won't require new CEQA. If it's existing sites, existing lots, the findings were broad enough and conservative enough to apply to most sites. But understandable, there's potential for certain unique applications that may require additional analysis, including things such as projects that have volatile manufacturing, understanding what site is actually being proposed as a site for volatile manufacturing. Or as I mentioned before, sites that may have impacts to biological resources or cultural resources. And I think that provides our overview. Hopefully that's helpful to understand where the EIR came from, what was analyzed, and how those findings relate to individual cases that are coming forward through implementation. I wanted to turn it over to Mr. Kleeman to talk about some project issues and additional PER tools.
Before we proceed, I'd like to get an idea of the sequence of speakers from staff and how long that's going to take.
Yes, Chair Park. So I'm going to be the last speaker. I'm actually going to finish this off. I'd guesstimate that my portion of the presentation will run approximately 15 to 20 more minutes, and then that'll be the end of it.
Okay, then I'm going to suggest this, and I appreciate your summary. It was very good. But I have to look at when we take a break and also when we ask questions. And what we'll do is we'll take a break right now, and then I would like the commissioners, if you'll indulge me, to defer your questions until all the staff presentations have been made. Okay, then you can ask your question, then anybody in the staff that can respond to it, as opposed to asking questions right now and separately. Okay, so we'll take a break right now. 5 minutes, and it always turns into 10, doesn't it? So folks, take your seats.
So Levi, Sunday night, or was it Monday? No, it's Monday. They checked in Sunday, and then it was a 24-hour, you know. Yeah, thank you.
Okay. We are reconvened and back on the record. Mr. Clement, will you go ahead with your presentation?
Yes, good morning, Chair Park and members of the commission. So I'll be finishing out the presentation today. Once again, kudos to Ms. Leachman and Mr. Buggert for putting together this presentation. It was fantastic, very informative. Thanks again. So what I'm going to focus on is kind of the meat and potatoes of how we are applying the EIR standards and other tools that are available to us to cannabis activities that are being proposed now under the program. So just for summary purposes, right now we have 155 cannabis entitlement applications pending. And by pending, I mean they have not been issued. So they're either under appeal, they're approved, or they are currently making their way to a decision. For those who are looking at, for example, the cannabis reports that are posted in our CELA Citizens Access, you're going to look at this number and you're going to say that doesn't match the chart. And that's because the way we report those numbers in a CELA Citizens Access, there's also other entitlements that truly aren't standalone entitlements. They're related to other cannabis entitlements. So this number is going to be lower than what's reported in that report that's available to the public. If anybody has any questions about those numbers, they're more welcome to give me a call and I'll help them interpret what those numbers mean, what we're showing in those reports. So as Ms. Leachman described earlier to you, when we are looking at these applications, we are focusing heavily on CEQA guideline sections 15162 and 15168 to determine first if the project was adequately covered in the EIR, and if it was not, then what sort of subsequent analysis is needed on the site-specific basis. So some issues that have come up, Ms. Leachman has done a good job of summarizing these. I'm not going to go into too much detail about them, but just the common sorts of concerns we're hearing is things with like concerns with odor impacts, the impacts from BVOCs, particularly in areas like Carpinteria, and then also we're hearing it in the Eastern Goleta Valley. However, we do believe that the EIR adequately did address the majority of those impacts. And what I would also like to say is that, and I'll get into a little bit more detail later on, the mitigation measures, as Ms. Leachman indicated, they were broadly defined, but were intended to be applied in a very site-specific manner. And what I mean by that is that they give options to us as the regulators and also to applicants to design their projects such that they can meet the requirements of those mitigation measures, taking into consideration site-specific and project-specific considerations. So for example, when it comes to things like odor control, for those projects where odor control is required, there are a number of options available to you to most effectively address odor control. So for example, if somebody's saying, I'm proposing one buyer system, but you're getting substantial evidence and you're hearing from us that that's not adequate, they're going to need to install a secondary system to adequately address the odors, you may do so. You may require that. That's within your discretion. Also, we're hearing quite a bit about the aesthetic impacts, primarily in the San Ynez Valley. As Ms. Leachman touched on earlier, though, aesthetic impacts, they were considered to be Class 1, unavoidably significant. However, we do have tools available to us to minimize those impacts, particularly with regard to landscape screening. You can make much of the development invisible from public viewing locations with good landscaping. And also site design, locating features of the project further away or in strategic locations so it's not as visible from public viewing locations. That is just the mitigation requirements from the EIR, but as I'm going to explain further on, there are also other tools besides the EIR mitigation measures which will enable you to get at some of the aesthetic considerations involved with these cannabis applications. And then finally, we're hearing a lot about the impacts from cannabis within proximity to residential areas, and then also with regard to agriculture. And what's coming up now, as you've heard through testimony on other applications applications that have come before you, there's great concern right now amongst those who apply pesticides to their properties, and concerns about reactions from the cannabis neighbors, and possibility of them precluding the adjacent farmers' ability to apply pesticides, and we'll get into more of that later. So, with regard to odor abatement, once again, as Ms. Leachman said, for most of the cannabis projects, they are subject to odor control requirements. The exception is the Ag 2 zone, but there's an exception to the exception. And that is if the cannabis operation in the Ag 2 zone requires a conditional use permit. In that specific situation, odor control is required. That was a decision by the board back when they adopted the program. So there are, once again, a number of options available to address odor control, that is specifically the terpenes. You've seen some of the options, particularly with regard to the Bayer system. You don't necessarily need to use the Bayer system if you read the mitigation measures and the development standards in the ordinance. That is just one option available. You could, in certain situations, if needed, and the project is appropriate to accommodate, you could have like a carbon filtration system. However, you want to take a good look at the specific operation to make sure you are selecting the best type of odor control system, because one system may work very well under one situation, but not as well in another. One other item that we also should bring up, one important piece of information that has changed since we did the evaluation in the EIR with regard to ozone. At the time at which we evaluated the air quality impacts with regard to ozone in the EIR, the county was in a status of non-attainment for reducing ozone in this community. However, since then, we have achieved attainment. Okay, so that's important. And go county, that's a big accomplishment. That's the first time in a very long time. We should be applauding, going, yes, go county, that's great, yes, thank you. So, thank you. So, but getting back to specifics of odor, the mitigation measure is really focused on residential areas, and it affords the planning director the ability to determine whether or not an odor control system is effective at eliminating odors as experienced in those residential areas. And then, as you're aware, as part of the consideration of particularly the G&K Farms application, there were additional compliance monitoring components that we added to that project, and we're now adding to all projects that are coming before you. And those additional compliance monitoring components for the director to retain an engineer or certified hygienist to go out and kind of truth check the claims that were made prior to adoption, approval of the applications, and then making sure that these systems truly are working the way they are intended. And we can require, once again, corrections to those odor control systems if the planning director finds that they are ineffective at achieving the mitigation goals. So once again, there are multiple technologies that are available for odor abatement. In the public commentary that was submitted for today's hearing, you saw a really good evaluation of a site prepared by SCS engineers. Last week, I also saw a presentation by SCS engineers as part of a brown bag presentation to our cannabis permitting crew, and the science is very interesting. And unfortunately, I think for some of these hearings, you didn't get the opportunity to allow the engineers to go into the detail of the methodology that they use for these odor studies, but it is very good science from what I can see, and it does give us a lot of good information for evaluating the actual effects from odors and odor control systems. And finally, odor control systems are not allowed to emit hazardous air pollutant or a toxic air contaminant. I know there's been a lot of concerns about the materials that are used in the Bayer system because some of that information is proprietary. However, certain board members were able to work with our air pollution control district such that the air pollution control district was afforded the opportunity to review what are the component parts of those materials. And without revealing what those parts are, they did confirm that the materials that are being used in, for example, the Bayer systems that are being proposed to you do not include hazardous air pollutants or toxic air contaminants. So they do satisfy the mitigation measures. Once again, there's concern particularly amongst those in the San Ynez Valley with regard to the cannabis permit applications that are being proposed primarily along State Route 246, but then there are other areas as well. And there's concerns that aesthetic impacts were either not fully evaluated in the EIR or the aesthetic impact, the mitigation measures are inadequate for dealing with the aesthetic impacts of those projects. Once again, I want to make it clear that the EIR did state that impacts were unavoidably significant, class 1. Okay? But despite that, there were mitigation measures that were set forth that became development standards in the code, which are applied to all cannabis applications. And once again, landscaping screening is your friend. You can use that and require greater landscape screening to reduce the site project-specific impacts depending on where the public viewing locations are that afford views of those sites. So for example, along 246, you can site the structures further away from 246. There are grade differences on these sites. You can locate them in areas where the natural topography blocks at least partially views of the site. You can add additional landscaping and require it to screen those features from the other areas where it is still visible from public viewing locations. But once again, despite all of that, impacts were found to be unavoidably significant. So there are going to be at least some aesthetic impacts that result from the implementation of this program. Okay, there have been a number of comments made with regard to pesticide applications, and the concern is with regard to situation where a cannabis operation is proposed next to existing agriculture, more specifically existing agriculture that relies upon the use of pesticides to control pests. As you're aware, cannabis is held to a very high standard when it comes to things like, well, the types of materials that can be used in the propagation of the plants, and it's very challenging. It's virtually impossible to use pesticides and have cannabis products that can make it into the market. So cannabis operators are highly concerned about pesticide drift and also the effect where pesticides are actually applied to a site. And it's not the drift of the pesticide itself that goes onto the other property, but rather the pesticides get onto soils, contaminates the soils. The soils are entrained in the wind, go off-site, and then pollute the cannabis site. So what we're hearing, at least anecdotally from certain agriculturalists who do spray, is that some of their sprayers are getting nervous and not choosing to apply pesticides because of concerns that they will lose their insurance. That issue is being addressed by the Agricultural Commissioner. She has convened working groups to address this issue. Also, we've heard anecdotally from the Carpinteria Valley, there have been groups there who have been able to get together and talk and come up to resolution with regard to this matter. And our position on this is that this can work, but it's going to require cooperation on the part of the farmers. And we have heard situations where there are existing medicinal cannabis operations adjacent to sites where there are other crops being cultivated which do rely upon pesticide applications, but those farmers have been able to time the spraying and the cultivation of the cannabis crops such that it is not interfering with the spraying activity. Spraying still can occur, and it's not contaminating the cannabis site. So it can work. It's just going to take some cooperation on everybody's part. So now I want to turn more towards the non-CEQA tools that we use when evaluating projects and making sure that we are addressing possible adverse or other undesirable effects of the projects. So you have a broad range of tools available to you, and I want to make it clear, CEQA is not an appropriate planning tool for addressing many of the characteristics of cannabis applications, and I want to encourage you to rely upon your project-specific findings that need to be made in order to approve a project, development standards, not just the mitigation measures that became development standards in the Land Use Development Code in Article 2, but there are also other development standards that just apply generally to development, which you could rely upon to address certain features of the cannabis operations. And then finally, you should be applying specific conditions of approval to these projects to make sure that they do comply with these regulations and are addressing the items that you intend for them to address. So once again, when it comes to things like odor control, the development standard that was included in the mitigation, included in the zoning ordinances
provides you with a lot of opportunities and options for addressing odor control. And if you find that an odor control system is insufficient, we have the ability to require more odor control. Once again, rely upon landscape screening to address aesthetics, and then consider the site-specific features of a project to try to locate, relocate, and design it such that you are reducing those impacts. Many of these project sites are located within community plan areas. And those community plan areas have additional requirements beyond just the ordinance standards and then the county-wide general plan policies. And there are a number of different types of policies that may apply to a project depending on the specific project that's proposed and the specific site considerations, but they address everything from land use to visual impacts to biological resources. So you definitely want to rely upon those when evaluating these projects. When you get your staff report and it has that section that's setting forth the project consistency evaluation with those comprehensive plan policies, hone in on those policies right there. And if you don't believe that what's being proposed or the conditions that we're recommending are sufficient to find the project consistent with those policies, you have the discretion to say what it will take and what in addition needs to be applied to these projects such that you can find it consistent. So just a couple of examples. These are our comprehensive plan policies coming from our land use element, which applies throughout the county. It's not specific to a community plan area, but applies to all projects. And as I'm going to get to in a little bit, all of these entitlement applications have a finding where you must find that the project complies with all of the applicable comprehensive plan policies. So here, a couple of the policies that may apply to a project would be, for example, Visual Resources Policies 2, and it affords you the opportunity to address things like the height scale and visibility of the cannabis development, make sure it's compatible with the surroundings. We also have controls on grading and site landform alteration on hillsides, and there's a particular policy which specifically requires minimization of grading and landform alteration. So you can use that to kind of push project applicants to reduce certain features of the project to make them more compatible and compliant with these policies. So, and the final tool that I'm going to address today are your specific findings for the entitlement application that is required for the cannabis application. First these are the land use permit findings. So this is one of the two types of entitlements that are required in the inland areas of the county in order to conduct a cannabis activity. As I mentioned earlier, the first finding is that the proposed project must conform with all of the applicable policies and standards of the comprehensive plan. If the project site is located within a community plan area, we also must evaluate the project for compliance with that community plan. And then also with all other provisions of the Land Use and Development Code, not just the cannabis standards, but everything else that may apply. So for example, you may have a project that involves greenhouse development. There are very specific development standards set forth in the LUDC just for the greenhouse development itself, in addition to the regulations that apply to the cannabis operation that's going to occur within the greenhouse. So, project also must be on a legal lot. It must comply with all the rules of the LUDC, which is kind of redundant with the first finding, but I guess they wanted to reinforce that when they adopted the standards. If you are in a situation where there is an enforcement action and an open violation case on your property, before we can take action on your cannabis application, you need to pay all of the outstanding zoning violation fees associated with that enforcement case. And then finally, particularly for the area of the Summerland, there's one additional finding for projects that are located within that area, and that is that the development will adversely impact recreational facilities and uses. I will say, with regard to cannabis, the EIR looked at, for example, impacts to public lands, public recreational lands, and there's specific mitigation measures which were actually incorporated by identifying where cannabis is allowed, and they precluded cannabis from being allowed on public recreational land. So it's consistent, at least, with this finding. So now those were the findings for a land use permit in the inland area. Now I'm shifting to the coastal zone and the coastal development permit, and there's essentially two types of development in the coastal zone. The first being non-appealable development. And by that, I mean it's development that is either located outside of the coastal zone geographical appeals area or it's considered to be principally permitted on the property. In those situations, those sorts of projects are not appealable to the coastal zone. So for the coastal development permits that fall within the non-appealable category, once again, similar to land use permits, you got to find that the project complies with all of the applicable policies and development standards of the comprehensive plan. And in this case, it also includes the coastal land use plan because you're in the coastal zone. Once again, you must be on a legal lot. You must comply with all the rules and regulations of the ordinance. And once again, you must pay all outstanding zoning violation fees if there is an open violation case on the subject property. Now, switching gears, now we're looking at appealable development. That is development that either is going to occur in the coastal zone appeals jurisdiction or it is not considered to be principally permitted. There are different findings for those coastal development permits. And more specifically,
Mr. Clement.
Yes.
And by appealable, you mean appealable to the Coastal Commission?
That is correct. Thank you
Not-
for that clarification.
That doesn't mean that it eliminates appealability, if that's such a word, from the Planning Commission, for example, or from the director to the Planning Commission or the Planning Commission to the Board of Supervisors.
That is correct. So, yeah. So all of these entitlements I'm discussing are appealable to the Board of Supervisors. So once again, taking appealable development that is appealable to the Coastal Commission, you have all of those same findings that I just described for non-appealable development, plus these three additional findings, and that is the project will not significantly obstruct public views from a public road or public recreation area to and along the coast. Once again, we're trying to preserve those public views of the coastline, coastal resources. The project must be compatible with the established physical scale of the area, and the project must comply with all the public access and recreational policies of the comprehensive plan. I should say this is kind of misleading when we say comprehensive plan, because technically the comprehensive plan here, the county includes the zoning ordinances, the general plan, the community plan, and all the additional elements. But we like to do things different in Santa Barbara, and this confuses those who work outside the Santa Barbara jurisdiction, because most jurisdictions call this their general plan. So for any of the planning geeks in the audience. All right, now we're turning to conditional use permits, and specifically I'm taking conditional use permit findings for the inland areas, not the coastal zone. A conditional use permit is required for uses and development which typically would not be appropriate for any given zone, but under specific conditions may be allowed. That is different than a land use permit or a coastal development permit, wherein the uses you are dealing with and the types of development you're using is assumed to be compatible with the intent of that zone. That is not the case with a conditional use permit. These are uses which may not be appropriate in that zone, and that's why you're taking a much closer look at the project and making different findings to ensure that you can approve that project in those areas. So what are those findings? You can see them on the screen here. First, you got to find that the site is adequate in terms of location, physical characteristics, shape, and size to accommodate the proposed development. We reinforce the CEQA analysis in the second finding, and we say significant environmental impacts will be mitigated to the maximum extent feasible. This third finding is very important for the projects where we have questionable access to particularly remote cannabis sites. This is going to be an issue for the Tepisque projects. This is also going to be an issue for other projects where they're proposing to use roadways, for example, through the Los Padres National Forest to get to these sites. Many of these roadways were not designed for the level of development that is being proposed as part of these cannabis applications. So what we are asking applicants to do is they need to, one, go talk to the fire department to get the specific fire department requirements for these roadways, because as you've seen in applications you've evaluated, there are slope requirements, there are road width requirements, there's vegetation removal requirements. And also, in order to engineer and design a roadway in some of these areas that have, like, for example, steep topography, you also have to do a substantial amount of engineering and landform alteration to meet those fire department requirements. And that's going to affect other aspects of the project, such as the visual impacts, biological resource impacts, drainage and hydrology. So for those sorts of applications in particular, we're taking a really good hard look at what is going to take to get access to these sites to make sure that, once again, the EIR fully evaluated it. And if not, we're going to call for additional environmental review. So. Finally, on this page at least, you also must demonstrate that there are adequate public services to serve the project. What I will say with regard to this finding in terms of cannabis applications, particularly with regard to police protection is heightened in terms of consideration as compared to non-cannabis applications. And as you're aware, when applicants go through the business licensing process, the Sheriff's Department is doing a very detailed review pursuant to the standards in Chapter 50, the Business Licensing Ordinance, to make sure that these applications are compliant with state law that applies to cannabis, and then also our local standards and mainly our zoning regulations. And I've received a lot of questions from agents, for example, saying, hey, I just don't know what the Sheriff Department wants. If you're curious, we have documentation posted on our website which states what they're looking for. And you're also going to see that a lot of that is just verbatim, straight from our ordinance. So it shouldn't be too much of a mystery as to what is required. And always, if you have questions about what is required, you can see us or the Sheriff's Department will help you out with that. Okay, final 3 findings for inland conditional use permit is that the project will not be detrimental to the comfort, convenience, general welfare, health, and safety in the neighborhood, and will be compatible with the surrounding area. Once again, you got to comply with all the rules and regulations of our comprehensive plan, including the Land Use and Development Code, and if there's a community plan or area plan that applies. And then specifically for rural areas, and this is important because a lot of these applications involve project sites in rural areas, you need to find that the proposed use will be compatible with and subordinate to the rural and scenic character of the area. In order to make these findings, you can use those tools to try to push applicants to be more compliant and more in keeping with what you think needs to occur with respect to these findings. However, ultimately, if you feel that you can't make one or more of these findings, you should be denying that project. That is always an option available to you. Now, switching from the inland conditional use permit findings to the coastal zone conditional use permit findings. The conditional use permit findings for the coastal zone, all of the findings that I described for the inland areas apply, plus these 3 additional findings, because you always have to have 3 more for the coastal zone, right? And that is the project complies with the coastal land use plan, excuse me. Also, the project will not conflict with any easements or other access ways, in general, I'm summarizing, mainly for access to the beach and to the coast. And we want to make sure that conditionally permitted use is not going to impede that. And then finally, the use is consistent with the intent of the zone. All right, so in summary, you've listened to a very lengthy presentation. I appreciate everybody's patience on this, but we have a few key points for all of you to consider when considering the PEIR. And once again, it's staff's opinion that the PEIR, because it was so broad, it was so robust, for most of the cannabis entitlement applications, it's most likely going to be the case that we can rely upon the PEIR for our CEQA analysis. However, as we've emphasized throughout this presentation, there are going to be those exceptional situations where you are going to have to do much more site-specific environmental analysis, because one or more issue areas, it'll be questionable as to whether or not the existing mitigation measures will fully mitigate those impacts to a less than significant level. I also want to use this as an opportunity to talk to the agents in the crowd to say that it's not enough just to submit the minimum required by the ordinance. And what we have been seeing is that there were a number of applications that were submitted early on before we had the benefit of reviewing some of these applications, taking them to your commission, to the board, to see where you are going to land with regard to some of the specific requirements for these applications and how much more you were going to ask for or how much less you were going to ask for. We now have that benefit, and we're now seeing what it takes to pass muster, so to speak. Long-winded way of saying, come talk to us, and the minimum amount required is most likely not going to cut it. And particularly in those situations like where we have a habitat protection plan required, you have unique resources on site. The habitat protection plan is your opportunity to really roll up your sleeves and do that site-specific analysis to demonstrate how you truly are not going to have a significant impact to one or more of those biological resources that exist on your site. And it's not enough just to regurgitate what's stated, for example, in Appendix J of the Land Use and Development Code. You got to do a much more robust site-specific analysis. And ultimately, what we would be doing in those situations, we would not be relying upon the 15168 checklist. We'd be calling for an initial study and some sort of environmental document. So, Once again, 15162, 15168 will do the job for most applications, but not all. Also, we want to make sure that, once again, decision makers, public, agents, everybody's aware that we do not do planning just through CEQA. There are other tools in our toolbox, findings, comp plan policies, ordinance standards that must be satisfied, which afford us a lot of opportunity to address many of the things that those CEQA mitigation measures do not address or were never intended to address. So we should be using those tools. And once again, if additional environmental review is needed, we're going to call for it. So with that said, turn it over to Q&A.
So I'm going to jump in there, and thank you, Mr. Clement. I thought that was a particularly well-organized presentation, and I really appreciate your inventory of the non-CEQA planning tools. I think that's something we all need to pay attention to. Now, what we would normally do here is have questions of the planning commissioners from staff, because I understand there's no further staff presentations, correct? I want to caution my other commissioners. I'd actually like to hold some of the questions until after public comment, and here's why. It's sort of a chicken and egg thing. You know, we ask our questions, that gives the public a chance to know what we're thinking about, helps them for their public comment. But if we got a lot of public comment, it's useful to hear the public comment before we ask a lot of questions. What I think will work best here is that we not ask all of our questions right now, because if we do, it could take hours, and it will cause the public to just have to wait for all of that. What I think we should do now is ask questions that are procedural, process, clarification, things that can be answered quickly. Things that can't be answered quickly, we should hold off on that. I'm going to give an example of what I think can't be handled quickly. I made a list of 8 issues where I'm going to want you to show me chapter and verse where these things are covered in the PEIR. I mean, that's what we have to do, and that's what I'd rather do here in an open hearing than privately. I have issues about how the different planning tools work together. I think those should wait. On the other hand, and something I'd like to clarify now is, are you able to go back through your excellent PowerPoint presentations and annotate them with where these things are covered in the PEIR? So that's a question right now you could answer right now.
Chair Park, I don't see any reason why we couldn't.
Yeah,
that's fine.
and that doesn't mean it has to be done today, because as you've both pointed out, we don't really apply the knowledge that you're giving us today until we hit specific projects. We're not going to vote on anything today. So it'll help when we get those projects to, and when we make that determination of whether the PEIR covers things, it'll be really helpful to have that in chapter verse. Okay, so that's my initial questions, and I hope what I said makes sense to the other planning commissioners about holding some of your more substantive questions until later. So do any of the planning commission members have questions now of staff to clarify things before we go on to public comment? I didn't mean to intimidate you or scare you away. Okay. Then let's move on to public comment. As usual, I encourage people to take shorter time than they might think. We will have the traditional 3-minute time limitation on speakers, but those speakers who can limit their comments to 1 minute get to go first. Today, you've heard a very specific, focused presentation, and I hope that that's mirrored in the public comment, that we're not just talking today about whether we like cannabis or don't like cannabis or whatever, but the issues you've just heard. So, starting with those who are prepared to go 1 minute, if you are ready to do that, then why don't you line up against the far wall, and we'll start with you. Do we have any takers? Looks like no.
I'm here, taker in Santa Maria.
Oh, there we go.
I'm here in Santa Maria.
Is this Mr. Clary?
Yes, sir.
Well, good. I was going to call on you first anyway. So you had an issue about whether we should be doing this today, or what was your issue?
Well, it's a little late for that, but I'll make a real brief comment. And that is, last week my wife called Villalobos to find out when we get in details about what happened.
Could you do me a favor of speaking right into that microphone? I'm having a hard time hearing you, maybe others
Sure.
are too. Thank you.
Yeah, well, yeah. That's
Oh, that's a lot
important.
better. Thank you.
Anyway, last week, my wife called or contacted Mr. Villalobos and asked when we get more information about what was going to happen today, because we just had that brief paragraph, and the staff was still working on it apparently. So we actually got it after we got back from the Board of Supervisors meeting yesterday at about, I think, 2:00 p.m. 54 pages of a PowerPoint presentation and an enormous number of letters. And the letters, a lot of us read them. They're very important. And so I just wanted to make an objection to such short notice. Due process is not just a mandatory issue under the Brown Act. It's a philosophical idea of fairness. And this does not meet the standards of adequate notice in terms of what's happening and an opportunity to respond. So that's all. Thanks.
Okay, thank you, Mr. Clary. But I'll remind you and others that when we get to specific projects, they aren't before us today, then you'll have full and ample opportunity to comment on those. So, okay, any other 1 minute folks? Then we'll jump into the 3 minutes. And I will take a lunch break today because there's about, last count we had about 30 speakers. That's probably going to take, you'd say 3 minutes times 30 should be 90 minutes, but it won't. It'll take 2 hours. And so we'll go for a while, then we'll take a lunch break. First speaker, Peter Dugray, to be followed by Al Wagner. Peter?
Yep. Good morning, Chair Park, Planning Commissioners. My name's Peter DeGray. I'm here representing Carp Growers. Big letters, CARP, C-A-R-P, Cannabis Association for Responsible Producers. Our members operate at 12 properties, all within Carpinteria Valley, and they must all adhere to strict membership requirements, chief among them being the use of vapor phase odor abatement technology. Our message today is that we are appreciative of the clarity of the county ordinance and the protections it offers for the community. We all know very well that Carpinteria Valley, as a center for agriculture and plant production, has never seen the level of scrutiny that's now mandated through the county ordinance. And as a land use matter, it's worth mentioning that members only operate in pre-existing infrastructure to grow a new plant. So all these properties that have historically been the leaders in cut flower production across the United States were turnkey ready to convert significant space to cannabis farming. And this conversion provides the county the opportunity to get onto all these properties and be proactive enforcers of a new ordinance that sets standards that are far above any oversight model applied to any other flower or vegetable product. And every step of the way, CARP member farms have met the challenge of compliance with all the rules and have welcomed both inspectors from the state and local regulatory bodies. So cannabis farming is an open book. We regularly tour hundreds of neighbors through farms and continue to offer educational walkthroughs for anyone who emails and asks. And that's the best way, really, to peel away any of the suspicion that's rooted in the stigma of this new plant. It's also worth noting that UCSB recently released preliminary findings from economic studies of cannabis farming in Santa Barbara County. That study found that cannabis brings over $450 million annually in commerce to the county. That means hardware stores, farm suppliers, contractors, a whole web of benefactors rely on this agricultural revival that we've experienced. And that's who we are in Carpinteria. That's what the local economy is built on. So to be clear, changing the ordinance in ways that some have asked for would put cannabis farmers out of business in Carpinteria. On CARP member farms alone, there are over 900 employees working the best ag jobs that there are in the region. Employees get benefits, their families are happier and healthier. Our teams work in environments that are free from dangerous pesticides. So our recommendation today is to allow the model of strict enforcement to continue, target the non-compliant farms, continue to get everyone under the umbrella of the legal framework provided through the county ordinance, The fact remains that the success of cannabis farming is a community issue and an economic one that supersedes any debate about individuals liking or disliking plant. Thank you very much.
Thank you. Okay, Mr. Wagner, to be followed by Robert Fedor.
Good morning. My name's Al Wagner. I'm the Vice President of Agriculture for Foley Family Wines, and I oversee farming in 9 California counties, 3 Oregon, and 1 in Washington. Foley farms over 1,500 acres in Santa Barbara County, 1,000 of which are in Santa Rita Hills. Foley operates 2 wineries, 4 tasting rooms, 4 very large vineyards employing 125 people and 100 seasonal workers. We believe that granting these permits will significantly discourage people from visiting our tasting rooms and thereby negatively affecting tourism in the county. Foley saw this firsthand last season, experienced a 20% drop in visitation to the Foley tasting room during harvest. When the cannabis grows that operated behind the Pence Ranch and Deerberg, the smells emitted from there were atrocious. Our biggest concern is on the proposed 200-acre medical grow located on Hapgood Road, and we own the farm that adjacent 500 acres to it, and we appreciate that this application is not presently before the commission. We believe that far more research needs to be done before what the current EIR covered in order to address the many unanswered questions of groundwater, erosion, drainage, and endangered species. About 40 years ago, the series of levees were constructed by the RCD and the flood control districts to prevent severe erosion and flooding of farm ground in many areas of Santa Rita Hills. Several parcels and ours and the Hayes Ranch that are currently had those units installed. The watershed that feeds this series of levees is in excess of 10,000 acres. And a development of this size will be no different than a commercial development and will increase water flows by 25% or 5.6 million gallons per inch of rainfall in recent studies conducted by Stantec Engineering. Foley has spent in excess of $200,000 over the last 3 years to repair the damage by the increased flows from minimal strawberry and hoop houses that exist up Hapgood Canyon. This will severely impact our compliance in the Irrigated Lands Program and sustainable certification programs. And any development, including hoop houses and commercial buildings, should require to have full erosion control plans. Medical cannabis should be grown the same as other medical products in California in a clean, sealed environment, and it is incumbent upon the grower to prevent contamination. We currently have buffers with organic growers and have had never issued. Most of Santa Rita Hills is also designated tiger salamander habitat, and these facilities will have negative impact on them. Cannabis is currently not required to provide an in-depth study on the tiger salamander, and while neighboring landowners are. Foley is in the process of undertaking on several redevelopment projects in excess of $15 million to 2 of the vineyards in Santa Rita Hills. However, we are currently reevaluating that investment due to the lack of protections to the current landowners, and it's a great concern. Foley is a long-standing taxpayer farming operator in the county and has been for decades and wants to continue as such. But with the lack of protections to us and similarly situated landowners are cause for great concern. Thank you.
Mr. Wagner, let me make a suggestion.
Yes, sir.
Because I would guess with these different projects that will come in front of us, you'll appear again.
Yes.
I think it would be very helpful to support your comments with some mapping, just some graphic things that show the levees, and also you mentioned the location.
I
of
have
these
all that, and we'll be happy to
different
bring
things.
up to those things.
It'd be great to have
Absolutely.
it, so much appreciated.
Yes, definitely. Thank you very much.
Mr. Fedor, and then we're going to move to North County to, is it Tracy Farhad? Yeah. So, Mr. Fedor, you're next.
Okay. Chairman Park, members of the Planning Commission, my name is Bobby Fedor. I'm a cultivator in North County, specifically on an over 20-acre 1Ag 20 property in Sabata Canyon. I'm legal nonconforming prior to January 19, 2016, have a current provisional license and a local Santa Barbara County authorization. I've had a legal dispensary in Los Angeles since 2007, and we've been United Commercial and Food Worker Union Local 770 employers since 2012. We signed the first collective bargaining agreement in the history of the Central Coast with UCFW 770 for cultivation. I currently have an accepted CUP application for cultivation in with planning, and hopefully my application will be heard before this board early next year. I look forward to inviting you all to a site visit at the farm, and I'm excited to personally show you our site plans and vision for the project. I'm here today to specifically support staff's PEIR findings. Not supporting our own county's PEIR will do nothing more than make our current administrative logjam even worse. The idea that staff's PEIR hasn't taken into account what's best for the county is not credible. It seems the closer the county and the cultivators get to permanent licensing, the more desperate the arguments become. And it seems the arguments are always changing and ever more desperate. Please listen to the facts and your own staff's findings and not the personal agendas of a few wealthy landowners. Thank you.
Thank you, Mr. Fedor. So, Tracy Farhad, are you there in the North County? Okay, to be followed by Stephen Janes here in Santa Barbara.
Can you hear me?
We can. Go ahead.
Thank you. I'm Tracy Farhad, and I'm representing the Santa Barbara County Coalition for Responsible Cannabis. We are a 501c3 nonprofit organization of citizens, farmers, business owners, and parents for the protection, education, advocacy for all, and we are not just a group of wealthy landowners. So thank you for presenting this workshop today and for the opportunity to speak before you. We believe strongly that CEQA, the California Environmental Quality Act, plays a central role in protecting the public health and environmental quality of our communities. Adequate CEQA review is essential to guiding good decision-making, and we remain extremely concerned that such review has been inadequate so far for a lot of different projects. No one could see all the impacts coming down the pike a year and a half ago. In the Board of Supervisors' own words, they didn't and couldn't anticipate the breadth of concerns and impacts, and it continues to evolve. So CEQA is our tool, so please use it to ensure all impacts are studied and considered. I also want to mention that the CDFA published today an update on cannabis cultivation licenses in the state. Just the small outdoor licenses, not even the medium, issued as of today are 935 total in just 8 California counties. 477 of those, 51%, are issued to Santa Barbara growers, and the remaining licenses are spread out over 7 counties. But the 477 are all within the central part of Santa Barbara County. In those other 7 counties, licenses are issued to between average 1 to 4 licenses each grower, with a max at 8. Well, for our county, our licenses numbers, as reported this morning, per operator are staggering, in the realm of 31 licenses, 39, 58, 87, and 86 licenses per operator. This is what we call uncharted waters. So please use all the tools in the toolbox. Use CEQA for impacts not captured by those development standards presented as tools for enforcement, and existing policies are not capturing those. Commissioners, please put the onus on the applicants, not on our neighbors and our businesses trying to work well together. Thank you.
Thank you, Ms. Farhad. So next we have Stephen Janes to be followed by Ted Fox.
Dear Commissioners, I'm speaking today because Santa Barbara County is completely out of step with the other 57 counties in California in how they implemented Proposition 64, and therefore the PEIR is completely insufficient and inadequate with the realities of what has actually happened here. You are the guardians and stewards of the people, and you have the power to change the situation. The Board of Supervisors is looking to you to help fix this. This all started because we allowed license stacking in the San Ynez Valley, which creates high-density, industrial-sized grows clustered together. You can see the CNBC live reporting from last week for proof of how large these grows are, and are now creating the largest proposed grows in the world. This license stacking has had serious ripple effects that goes against many of the PEIR's assumptions. It did not account for the enormous visual blight from a sea of plastic from clustering an intense concentration of industrial-sized grows and its cumulative effect. It did not account for the proximity and incompatibility to food agriculture like vineyards, where known oils and terpenes are airborne and drift onto neighboring farmers, ruining their crop. We are not talking ozone, but oils and gases that fall into neighboring agriculture. It did not account for the 24-mile-an-hour average wind speeds in our wine regions, nor fog drift, nor fog inversion, and waft, which further exacerbates the above terpene drift problem. It did not account for the year-round odors and stench in Ag 2 coming from these high-density industrial grows, which will kill the tourism industry that contributes almost $1.8 billion to the local economy. It did not account for the enormous water runoff problem created by these large hooped grows when it rains. In closing, while this all may sound like the wine industry is anti-cannabis, we are not. Like anyone, we are against any industry that takes advantage of the system and creates serious and significant environmental problems for the rest of us to deal with, which ultimately could destroy our very existence as an industry. I urge you to revisit the PEIR for the Santa Ynez Valley and account for the realities of what has actually happened here in Santa Barbara County so the damage can stop before it is too late. Thank you.
Thank you, Mr. Janes. Ted Fox, be followed by Peter Candy.
Can you put up the slide, please? My name is Ted Fox, and I'm the compliance officer for Pro Farms, a North County cannabis cultivator. I've been attending these public meetings of both the Board of Supervisors and the Planning Commission for over a year now. At those meetings, I've heard public opposition for North County. Mind you, most of it has come from the wine industry, railing against monster cannabis grows that threaten to overrun Santa Rita Hills. Nothing could be further from the truth. These are your numbers. These are from the county. Let's examine the data. This is from the 2018 Santa Barbara County Crop Report census, and it noted that there were 168,000 acres of crops planted in the county. That doesn't include the grazing land. As you know, the county has a combined cannabis cap of 1,761 acres. Comparing the cannabis cap figure to the overall crop acreage in 2018 shows that our cap, the 1,700 plus acre, the monster grow, represents less than 1% of the entire crop acreage grown in the county. Taking a closer look at the data, in the 2018 crop report, your information, you find that for every acre of cannabis planted, 10 acres of wine grapes were grown. For every acre of cannabis planted, 7 acres of broccoli were grown. The same holds true for lettuce. In the case of cauliflower, 5 acres of cauliflower were planted for every 1 acre of cannabis. And so it goes. Using this fact-based public information from the county, the myth of the monster cannabis farms needs to be put to rest once and for all. Thank you very much.
Thank you. Peter Candy, to be followed by Hannah Brand.
Good morning, Chair Park, Planning Commissioners. Appreciate the opportunity to address you. I represent several cannabis growers, both North County, South County. Interesting discussion today. Appreciate staff's presentation. No mystery that cannabis opponents argue the program EIR did not examine the full range of environmental impacts one can expect from site-specific project applications. In the letter I submitted, I tried to go through chapter and verse how the program EIR addressed each of their concerns, primarily in the areas of air quality, adjacent residential and agricultural land uses, and aesthetics and visual resources. The opposition, of course, has had plenty of time to come up with several nuances that were not addressed in the PEIR. One of these is pesticide drift. Pesticide drift, again, no mystery, it's illegal in California. The law requires applicators to know when environmental conditions are appropriate for spraying and when they are not. The inversion that occurs in certain areas of the county, if it's such a prominent force exacerbating drift, the law requires applicators to know when it will occur and to avoid spraying during these times. An EIR is required to evaluate only the environmental impacts of a project. Environment is very specifically defined as land, air, water, minerals, flora, and fauna. Environment is not the economic consequences of nearby landowners' illegal spray operations. The pesticide drift is important. It's one that most certainly requires a comprehensive solution. However, CEQA is not the appropriate context. The other nuance opponents raise involves contamination of wine grapes through airborne exposure to cannabis terpenes. The one reference source they point to studied the effect of eucalyptus terpenes on wine grapes in Australia. The study found that it was not airborne terpenes, but instead eucalyptus leaves coming in direct contact with the wine grapes that had the greatest effect on the taste and the quality of the wine produced. The study is simply too limited and speculative in nature to be considered substantial evidence for purposes of claiming further environmental impact review is required. The opposition claims that circumstances have changed and or new information has come to light since the program EIR was certified. They claim there was no way for the county to know or anticipate that cultivation applications would be concentrated in certain areas of the county. They also claim there is no way for the county to know or anticipate that operators would combine multiple small cultivation licenses to amass large grow operations. They seem to ignore clear discussion in the project description describing cultivation sites tending to be concentrated in specific areas of the county and predicting these patterns would persist. They also seem to ignore discussion of average canopy size being over 34,000 square feet, with the largest cultivation operations ranging from 12 to 25 acres.
Mr. Candy, you're out of time. Could you just summarize in a couple of sentences?
Absolutely. It's difficult to see how the opposition can claim with any credibility that these issues were not known and could not have been anticipated at the time the EIR was prepared and certified. Thank you very much.
Thank you, Mr. Candy. So we'll have Hannah Brand, and then we'll go back up to, how many more do we have in North County? Just one. Then we'll go up to Courtney Taylor in the North County.
Good morning. Well, almost afternoon, everyone. My name is Hannah Brand, and I'm one of the owners of Autumn Brands in Carpinteria. I have been in agriculture my entire life, growing up on an avocado ranch and spending my summers working in the flower greenhouses and on the bouquet line. This drove me to attend Cal Poly and get a degree in agriculture and environmental plant science. Throughout my 4.5 years at Cal Poly, I was able to learn an extensive amount about agriculture in the state of California, including different laws and regulations put into place to balance environmental impact and the ability for farmers to grow. Cannabis in Santa Barbara County has reduced farming impacts, environmental impacts. Greenhouse growers are using pre-existing structures. We reuse our water and recapture it, recycle organic waste, and refrain from the use of pesticides. Also, the semi-trucks aren't driving up and down the foothills anymore, and this is reducing the air pollution, the deterioration of roads, and reduced traffic. We first submitted our coastal development permit application in January of 2019, and we are diligently working towards an approval. We are committed to following the process the county has set out for the last year and meeting these standards. This meant demolishing several key pieces of infrastructure on our farm to comply with the regulations. Throughout our process, we have remained transparent and invited neighbors to come to our farms and see our greenhouses. We believe our growing practices are setting a new standard for clean agriculture. Please leave things how they are and we are making great progress and believe the environment and our employees are the big winners. Thank you.
Thank you, Ms. Brand. Okay, Courtney Taylor up in Santa Maria, to be followed by Eric Edwards.
So good morning, Chair Park and Commissioners. This is Courtney Taylor. I am representing appellants in 4 of the pending cannabis appeals. When examining whether an impact was studied in the PEAR, you not only have to look at if the impact was discussed, but how, in what context, what conclusions were made to really accurately determine whether an impact was truly examined in the PEAR. Simply stating it was covered as a general issue does not necessarily mean it was examined in all contexts of all impacts. I first want to note, as far as substantial change in circumstances, since the PEAR was certified in February 2018, the Right to Farm Ordinance was amended on May 8th, 2018, 3 months later. The EIR assumed in its analysis of odor abatement, specifically for Ag 2, that ag was protected under Right to Farm, and thus it would be legally improper to require odor mitigation on the very large, mostly agricultural projects in Ag 2. The PEIR thus did not assess how the impacts to changes to the Right to Farm in terms of excluding cannabis would thus change what odor mitigation should be required in Ag 2. So we do, I think, have a change with regard to Right to Farm and what that looks like in terms of assessing potential odor mitigation in Ag 2, which we know is a potential issue. Second, I know you've heard these before, but the PER really did not adequately address the incompatibility with adjacent ag uses. You've heard them listed by other speakers, but looking at this post-application pesticide drift that I think is sometimes mischaracterized, there is in fact drift that occurs after application. That does not necessarily mean the applicator was irresponsible or in violation of the Ag Commissioner's rules for pesticide application. There are the issues regarding inability to obtain insurance, get contracts for spray services, and then we do have these potential impacts to terpenes on wine grape quality. We do have research and evidence that terpenes are airborne, and we presented that evidence in the first appeal on August 8th. We're continuing to develop that research and get confirmation of how all of that is interacting, but we do have evidence that that is occurring, and it is a huge concern for wine industry members, particularly in the Santa Rita Hills. Obviously, these impacts are exacerbated when the projects are concentrated, and they do create physical impacts that are impacts to land and are pursuant to CEQA in the environment definition under CEQA. If these lands are no longer feasible for farming and using long-standing farming practices to continue growing existing crops. I know the Ag Commissioner is looking at some of these issues now, so these are clearly real impacts and impacts that were not in the PEIR. So I think it really comes down to the question of, is it really a potentially significant impact to lose avocado and wine crops in Santa Barbara County due to all of these impacts from cannabis sites that are very large without setbacks right next to existing agriculture? Thank you.
Thank you, Ms. Taylor. Eric Edwards, to be followed by Winifred Van Wingerden.
Good morning, Chair, Commissioners, and staff, and thank you for the opportunity to comment. My name is Eric Edwards, and I'm the Director of Compliance for Headwaters, a licensed cultivator and active member of CARP growers. Headwaters was and remains a strong proponent of the county's cannabis regulations, and we continue to support all of the county's endeavors to expeditiously review land use permits and business licenses to bring every local business into compliance. This meeting concerns the PEIR and is foundational to our efforts in moving forward with our project and to meet the standards the county has set forth for the industry at large. I'm here this morning to not only voice our support for the county's cannabis ordinances, but to also provide some context and insight into the permitting process and Headwaters' efforts to gain county approvals and sign-offs necessary to operate in this highly regulated industry. Headwaters has been involved in the county permitting process and licensing journey for over 2 years. We participated in seemingly countless county meetings, and we've actively and consistently demonstrated our willingness and desire to satisfy the county's extensive regulatory concerns and to abate and alleviate the concerns of our neighbors. Throughout this process, we have relied on the PEIR and believe it to be both comprehensive and adequate. To date, and to gain the privilege of working in this historically maligned industry, Headwaters has contracted and employed the efforts of land use consultants, biologists, hygienists, architects, civil, mechanical, structural, and electrical engineers. And at each step of the way, we've done so with the hopes of complying with the county's ever-evolving regulatory framework. One single fact demonstrates the complexity of this process. Not one operator has successfully navigated the totality of the county's stringent requirements. Part of this relates to the complexity of regulating historically black market crop clouded in nearly a century of misinformation and anti-cannabis propaganda. But part of this also relates to the complexity of the myriad county land use regulations, including complying with the Carpinteria agricultural overlay, where Headwaters currently finds itself. Stemming from a single crop change, we've been asked to demolish pre-existing infrastructure, remove and relocate necessary agricultural equipment like boilers and water tanks, and to essentially revive crumbling and dilapidated greenhouses, conditions which have existed for decades and would likely have remained so absent the county's endeavor to regulate commercial cannabis. As an operator that finds itself in the middle of this complex and painstaking process, and who pledges to work with the county and its constituents in good faith, we urge this commission to continue processing cannabis land use permits with the intention of effectuating the county's suite of cannabis ordinances. Thank you.
Thank you, Mr. Edwards. Winifred Van Wingerden?
That's Winfred.
Winifred, okay.
Winifred's my aunt, actually. So, well, good morning, or it is still good morning.
Still is.
Board and staff, we're almost there. My name is Winfred Van Wingerden, and I want to thank you for this opportunity to be here. Believe it or not, we've been here for 50 years. I still have my accent, but we love farming here. We've been in the Carpinteria community for half a century, growing carnations, growing mums, growing alstroemeria, roses, Gerbers right now. We're still doing Gerbers. We're still promoting flowers in the national market. But most important is that we've also found another crop that makes it possible for us to survive. You know, if we didn't have cannabis, I wouldn't be able to grow flowers anymore. And so by having cannabis available to us, we are able to continue our flower operations also. So they're somewhat subsidizing it to a small extent, but it's working. And we want to continue with the flowers. We are definitely working, of course, on our coastal development permit. We applied in February of 2019, and we're looking for speedy approval. We have an amazing level of cleanliness in agriculture here. I mean, I'm sorry to say, but no other form of agriculture can claim this, that we take all of our water, recycle it, every bit of fertilizer. We don't spray pesticides. We take our CO2 from our boilers and put it back into the greenhouse so that the plants can grow better. So there are so many positive points here. And not only that, we're also working with the avocado growers in the Carpinteria Valley and saying, we're not going to sue you. We're not interested in liabilities and, you know, getting into court. We want to farm and work together. And it's been suggested by, you know, the staff here that cooperation is possible. We can make this work for everybody. Okay, we're not big. Cannabis is not big here. We're as the gentleman stated, 1,700 acres. Carpinteria Valley is going to have 186 acres. Okay, out of 4,000 to 5,000 of other forms of agriculture. So we have an amazing opportunity here to keep agriculture alive. Let's use our common sense here today and in the future to make sure that cannabis is going to stay and prosper, because it is one of the most wonderful crops you can imagine. Thank you very much.
Thank you, Mr. Van Wingerden. We're going to take our lunch break. Take an hour. We'll definitely reconvene at 1:05. Be ready to go. And when we get
Commissioner,
back,
Can I interrupt you for a second?
Commissioner Blau.
Yeah, thank you. I have some medical appointments this afternoon, so I'm going to have to leave. I'm real curious. I will watch the rest of this hearing on tape, and I'm real curious to see your 8 questions, Commissioner Park. I'll just make my one comment now. I really appreciate the staff's presentation this morning. And however, I mean, my concern and the reason that I raised an issue with this at some prior meetings was it's now been, I think, 1.5 years since the programmed EIR was done. My concern is it necessary to go back and review and perhaps amend or supplement that EIR, because it doesn't seem to me to be working the way it was intended. And again, I'm going to rely a lot on Commissioner Park's comments at some prior meetings and look forward to those 8 questions you're talking about, but I think that's what it might point out. So I was a little confused with County Council's earlier comments saying that this couldn't be amended, and I think I heard later on that staff concluded that it could be amended, and that's the direction that I'd like to see the commission weigh in upon. I'm just one of 5, but if there's 3 or 4 other ones that think it is necessary to go back and perhaps revisit the program EIR, so be it. I think we need to communicate that to the board. But those are my concerns and comments, and like I say, I will view the rest of the hearing on tape, and appreciate your patience with my medical issues. Just hopefully they get over with here pretty quick. Thank you.
Well, Commissioner Blau, thanks for hanging in there. And I think what we should do is you'll be able to watch this on video, and we won't have any actual decisions on these things until October 30th at the earliest. And I think what we should do is schedule a meeting with staff, with you up in the North County, to go over some of this stuff before we have those hearings.
Actually, I'm good to go with just hearing the hearing, and I will do that as necessary. But I just think it's an issue I realize we're not going to make any decisions today, But, you know, when I first heard about this meeting and the briefing, it was my intention to take a look at the information to see if it does need to be amended. But that's an issue for another day.
Okay. So we'll take our break, make it 1:10, not 1:05. And when we come back, the first two speakers will be Whitney Colley and Barry Brand. And our first two speakers will be Whitney Colley and Barry Brand. Whitney, are you here? So.
Hello. Good afternoon, commissioners and staff. My name is Whitney Colley. Change is inevitable. The advantage of the budding cannabis industry in Carpinteria is that not much has changed since the crops have switched. Farmers are using their pre-existing infrastructure for cultivation. No major developments have been started for this. Water usage is not affected since water is used, captured, and recycled. Odor mitigation technology has been proven by an SCS environmental engineer study to be between 98 and 100% effective in reducing odor. Additionally, the APCD has deemed that EcoZorb is safe. So safe, in fact, that it is being used in hospitals. The things that have changed are high-paying jobs for younger generations, a highly regulated industry to ensure the safety of consumers, pesticide-free growing, legal and readily available relief for people with medical problems, and increased tax revenue for the state and county. I feel that the environmental impact report adequately covered all of the effects of the cannabis industry. Thank you for your time.
Thank you. Next, we'll have Barry Brand, followed by Blair Pence.
Good afternoon, Chair Park and Planning Commissioners. My name is Barry Brand, and my family operates several cannabis farms in Carpinteria Valley. I've lived in this community for 32 years and have a long history of growing a variety of crops, including cut flowers, kosher, romaine, and herbs, conventional herbs, organic produce, and now cannabis and organic avocados, of which the kosher crop used the most chemicals and the cannabis the least in the greenhouse. Our family, we had to make changes to the crops, and this happened a few years ago. In 2014 we started, because we could no longer compete with low labor cost products from Mexico and South America. Two of my four sons, they work with me today in a plan to pass on the business to my children. They will be in this community for a long time. We're also members of the Carp Grower Association, and I made the decision to invest in odor control starting in 2014, being the first to have these systems at the farm I was involved with. Originally we used carbon filters, but we could not control the odor or the heat in the greenhouse. Then we bought peon odor systems like Marburg uses at the city lots. And now we have our third generation system, the Bayer odor system. Multiple state and local officials have personally experienced that this system works very well. 5 feet outside my greenhouse, they can't smell a thing. They walk through the door and then you can smell it. The SCS test confirmed this. Having grown several crops in my greenhouse throughout the years, I can tell you that cannabis is the most sustainable grown, at least environmentally impactful. We use predatory insects, and all products we grow are sold through the state metric system after being tested by independent labs on pesticide levels. We had to spend a lot of money and time to clean some of our greenhouses. They had cut flowers in them for 30 years, and the pesticides residues were showing up on our crops. For example, we recycle and reuse all our water. Our cannabis business generates less truck trips and use smaller vehicles. And as part of the business license process, we have to demonstrate a reduce in energy use. We're currently urgently working through the county's land use permitting process. But bringing our farms into compliance with the Carpinteria Agriculture Overlay has a long and difficult process. For example, since we are in Area B, the Carpinteria Ag Overlay, any development that was unpermitted, sometimes by 2 or 3 or 4 owners back, has been completely demolished, and even sometimes as small as a water tank that has been on a farm for 20 years. And one of the things that's kind of interesting, 20 years ago, I was on the Ag Advisory Committee, and at that time, the new wine growers came into the county, and they were bulldozing large areas of land and oak trees. We had to spend 2 years at that time discussing this and making recommendations to the committee for that. And now everything works out and people love grapes and wine, but it was not 20 years ago. I think there's a way for us to work together, and this could be a good industry for our farmers and our community. Thank you very much.
Thank you, Mr. Brand. So next we have Blair Pence to be followed by Ivan Van Wingerden.
Good morning. Thank you for the opportunity to speak with you again. I'm Blair Pence. I'm a farmer and vintner. I've been in the San Ynez Valley for 20 years, and I grew up working in ag in Bakersfield. Just want to touch on a few things that I don't think were really understood today. First, pot threatens legacy agriculture. They talked about terpenes and their effect but on ozone, but not upon grapes. Secondly, the drift, they talked about insurance policies. This isn't about insurance. There's already lawsuits that have been threatened to the tune of $20 million on one and $10 million on another. Those have happened. They also they talk about concentrations, but they don't talk about concentrations along scenic corridors. 246, we already knew of 3 winery projects, including my own, that have been put on hold, and now I hear that Foley has 3 more. I added up, it's about $35 million worth of winery projects that are now on ice. And then also the effects on drainage, stormwater, riparian habitats. You heard from Foley on that. I can tell you from my own experience what those hoop structures can do to a neighboring property when it rains. Health concerns were not addressed. The headaches, the respiratory illnesses. And what other concerns are going to be happening? We don't really know. And then finally, they say also about acreage, and they say, well, it's a small part. But the Ag 2 is the vast majority of the acreage that we're talking about. So these areas that are not really being controlled, that's where all the acres are. And that the assumption to right to farm was applied, which it doesn't. Finally, I just want to say with respect to scale, one of the comments you heard today was that comparing to heads of lettuce and broccoli and cauliflower, cauliflower is that big, lettuce is that big. A whole plant, it takes a whole vine to produce 1 bottle of wine. Okay, so how many joints do you grow out of 1 cannabis plant? So it's all off in terms of scale. You can't make those. You just cannot make those comparisons. They're not valid. Thank you very much for your time.
Thank you, Mr. Pence. Okay, Ivan Van Wingerden to be followed by David Van Wingerden.
Good afternoon, Planning Commissioners. Thank you for this opportunity to speak with you today. My name is Ivan Van Wingerden. I've spoken here in the past, but I am a cannabis grower in Carpinteria as well as an organic avocado grower. Our family, we have about 60 acres of organic avocados. The agriculture industry employs more people than any other industry in Carpinteria. Avocados, lemons, cannabis, and cut flowers being the main crops grown today. My father bought the Everbloom property in 1979, and we do continue to grow there. We just celebrated 40 years since my dad first put a shovel to soil. And our greenhouses that we have to this day were built in the 1980s. And many different crops have cycled through these greenhouses. Cannabis has fit this greenhouse mold just much the same as tulips, mums, carnations, and many other flower crops. We pulled out the Gerber plants and we had planted cannabis in the exact same system. We utilize the same closed loop system, the same nutrients, a little bit less water, 0 pesticides, and the same great team of workers. We are proud to be clean. We pass the rigorous state mandated tests for over 70 toxins week after week. And we are grateful to pay competitive wages and to offer holistic benefits to our hardworking people. And we are thankful to live in Carpinteria and be able to give back to our community. On the avocados, we have been seeing record prices per pound year over year since July of 2015. This is another industry that is thriving in Carpinteria. The unfounded claims that cannabis and avocados are not compatible is neither supported by the data nor by the leaders from each industry. The avocado industry is still booming. We have been and continue to diligently follow the complex process through county land use and towards approval. We are committed to following the process that the county set out for us last year and meeting these standards. The PEIR is adequate as it is now. We have had to hire many experts to guide us through this complex process, including biologists, traffic engineers, and consultants to interpret the requirements and interface with nearly every department of the county. As reported by the county staff at the board hearing in July, this is from the CEQA report, all of the current state licensed operators is under 0.02% of all ag zone property in SB County. So as a percentage of actual canopy, it is quite small. Through this process, we have remained transparent, at times to our own impediment from detractors of cannabis. Our business has essentially been wide open to the county and state agencies, and we continue to remain compliant and cooperative at every step. We've also been hosting tours to about 50 community members each month on Saturdays, regardless of whether they like us or not. We let everybody come through. These tours are key opportunities for our neighbors and friends to learn about our family business and ask questions about a cannabis operation. I would encourage anyone in this room to join one of these tours and see just how clean and organized and compliant our operation is. We are an open book and committed to transparency with the community. Thank you for this open, productive dialogue and your patience through this incredibly detailed process.
Yvonne, while you're at the podium, let me ask you a question, because you have both cannabis and avocados.
Uh-huh.
So how did you treat your avocados for thrips and similar pests this year? What's your experience?
So we do not use helicopter spraying. We use ground application. So we have a team of 2 guys, usually 2 to 3 times per year, depending on when the thrip fly in. And then we use either we use Trilogy, which is a label, it's a neem oil, or we use Pyganic, also OMRI certified, or we use Empede, which is just a fatty acid. And all 3 of those do 2 things. They clean the trees, which prevents spider mites, Persea mites, and then they also do kill the thrips. So ground application is quite inexpensive. If people don't want to go through the hassle of doing it themselves and getting the certification, they can just hire someone like Shade Farm Management, or there's quite a few other pesticide applicators that'll do the work. Yeah, it's quite effective, and it's quite a bit cheaper actually than conventional sprays.
Okay, well, thanks.
So, sure.
David Van Wingerden, to be followed by, where are we? Nathan Eady.
Good afternoon, Commissioners. My name is David Van Wingerden, owner of CVW Organic Farms. My family has been farming in Carpinteria for almost 50 years. We decided to transition into cannabis because the flower industry is no longer profitable. Cannabis allows us to support our 3 children and continue operating our family farm. We are here to support the PEIR and the county's cannabis program as a whole. The PEIR and associated county ordinance is a model cannabis program as it implements stringent development standards not previously applied to other types of agricultural crops, including cut flowers. We know this well as we applied for a CDP to convert our flower greenhouses into cannabis, and it took us months to receive a CDP. This month, we submitted a complete business license application. As a part of the process, we hired a land use consultant and architect to help us navigate the complex process of obtaining a CDP and a business license. As a result, we'll be making numerous improvements to our greenhouses and facilities. We've also developed an energy plan, an odor mitigation plan, site management plan, water conservation plan, transportation plan, and security plan, and so on and so forth. In sum, we urge the Commission to satisfy the project objectives that were set forth in the PEIR to encourage commercial cannabis businesses to operate legally and secure a license to operate in full compliance with county and state regulations, maximizing the proportion of licensed activities and minimizing unlicensed activities, and to provide an efficient, clear, and streamlined commercial cannabis licensing and permit process and attainable regulations and standards to facilitate participation by commercial cannabis businesses in the county. I'd like to also add that we also have avocados on our property. We also neighbor 2 avocado orchards. We have had 0 problems working with them to coordinate pesticide applications, nor have we had any problems with contamination. Growing cannabis next to existing agriculture does work. Thank you.
Thank you. Nathan Eady, be followed by Jay Higgins.
Sorry to break up your Van Wingerden role there, Chair, but Nathan Eady with SES Engineers out of Santa Maria, California. Just wanted to show up today and offer my presence to follow up on any commissioner questions or questions from the public about the public comment letter that we had submitted relating to some of the odor studies that we'd done. So as a bit of background, because oftentimes commissioners are used to seeing staff from my firm show up for oil and gas firms or something, and there's a parallel there. So our firm, which has 1,000 employees nationwide, specializes in supporting those land uses that can create environmental issues that need appropriate mitigation measures. Particularly for air quality, we've been trusted by both the private industry, but just as much municipal agencies. We build and maintain and operate ambient air monitoring stations for APCDs across the state of California. We recently expanded that service to Hawaii. We studied air quality for the airport authority at LAX, and the state parks hired us to do the PM management for the dunes related to the off-road, which is a pretty big air quality issue in the region as well. So we've got a tremendous amount of experience to pull from, and when it crosses over into the specific issue of odor, we also provide ongoing services to manage almost 400 landfills in North America. So we've been dealing with odor as a specialty topic for over 40 years and have a lot of expertise to bring to bear to that. And that's why carp growers reached out to us to look into this specific issue, because as we saw in those early hearings, the PEIR adequately identified what were the leading odor abatement technologies available. But in those early hearings, whether it was the commission or the board of supervisors or the general public, they really want to see more raw data that supports that those systems were actually effectively working. And that's precisely what we did. So we went out and did a case study on the Berries greenhouse in Carpinteria that had 3 acres of active cultivation ongoing. We really designed the case study to test the veracity of the system to deal with changing meteorological conditions. We strategically took those samples when the roof vents were open, which is a common concern that we get from the public, saying the roof vents are open, isn't that just a massive release of odor that you can't control? And the findings were incredibly strong. The odor control system is successfully abating 99 to 100% of the odors released from the greenhouse, and that remaining 1% is imperceptible to the public because it is so low. Related to our methodology, while it's our staff that goes out and collects those samples, they go to a laboratory in Connecticut, and the odor panel that evaluates them is completely blind, not literally, but figuratively. So they are never told the geographic location or the potential malodor that was collected. So when they evaluate those samples, they have to come to their own conclusion about what that malodor is and what is its relative intensity. So it's a very third-party, independent evaluation of the field collection that we do. So other than that, I've tried before unsuccessfully to give the whole presentation in 3 minutes. It can't be done. So if you have any questions or you'd like follow-up meetings or anything, we're here as a resource to everyone.
While you're there, do any of the commissioners have questions of Mr. Eady? Commissioner Cooney.
Mr. Eady, thank you for coming, and I read the report, very thorough. What I couldn't discern is whether there was any testing of longer range exposure than just the grab samples that you used and sent back. How do we determine if it makes a difference to someone who is exposed to those odors for a longer period of time?
So Chair and Commissioner Cooney, let me see if I understand the question, and please clarify if I don't. So when we plan odor studies like this or any air quality, we look at meteorological conditions, what is the source of the emissions, and we plan the sampling points carefully. So this is a good example where we looked at almost 2 years of meteorological data to figure out what are the predominant wind patterns or meteorological conditions unique to Carpinteria before we select the location or the distance. So when we do similar studies like this for landfills or other facilities that have much more persistent odors, sometimes we're taking samples literally miles away. In this circumstance, it's really about what happens to that odor in that first 50 to 100 feet, because where the proximity of these greenhouses are, if we don't have effective odor mitigation that can knock out that odor almost immediately, then we need to start looking at a different technology. Some of the projects that you'll see in front of you are going to have greenhouses within 60 to 80 feet of residences, and so we need to have a mitigation method that can work that quickly, almost that instantaneously. And that's why some of these samples were taken as close as 20 or 30 feet outside of the greenhouse. So we were really testing the limits of where the odor should be the strongest as it exits the roof vents. Now, when it comes to some of the other air quality issues that have been brought up, VOCs, health issues related to buyers, we've taken a variety of field sample data and looked at research, and we just don't find any scientific validity to any of these air quality issues except for odor. That's a very real issue, and it needs very real site-specific testing and application. But everything else is just a lot of statistics and data being thrown around out of context to try and kind of wage a larger battle. No problem.
Mr. Eady, your reports have some controversy just because it was late filed. And that means it's not a matter of the record today unless we vote on basically a unanimous 4-person vote to admit it, which I suppose we should do right now. And in fact, I'll make the motion to do that. And I'm making that motion because we're not voting on anything today, so the fact that it was late filed doesn't really harm anyone, I don't think. And if it's going to be discussed, it might as well be in the record sometime. If we rejected it or if we didn't accept it today, you could simply file it Monday for the purpose of the next hearing that's going to be heard on this. So that's my motion. Is there a second?
Second.
Okay, and since Commissioner Blau is not here, we can actually vote by voice. All in favor, please say aye.
Aye.
Aye. Do we have any noes? I don't hear your voice. No. No. Well, then the motion does not carry, and so it's not accepted into the record for today's hearing, and you'll just have to submit it for later purposes. That being said, here's my question. The findings of your study, and I don't know what they are because I didn't have time to read it, do they distinguish between it being an indoor grow or an outdoor grow? Are they equally applicable?
Chair, correct. So this was focused on a typical cultivation operation that we see in Carpinteria, which is an enclosed greenhouse with operable roof vents. So if we were to study an outdoor grow, that would require a different case study.
Okay. Well, very good. Well, thank you. I don't have any further questions. Anyone else?
I do. It actually tags on to that in that, have you ever done an outdoor assessment for cannabis anywhere?
Chair and Commissioner Bradley. So we're working on cannabis-related case studies throughout the state right now. So we don't have any case studies that are so complete that we're ready to present the data.
Thank you.
And the one last thing to note, I guess, related to whether or not our public comment is submitted to the record. We submitted an almost identical version of the presentation as part of the G&K Farms project that was heard by the Board of Supervisors a couple weeks ago. So it's out there, and we've been trying to make it widely available to all members of the public since the results were ready, basically. Yeah. Thank you very much.
Very good. Thank you. So next is Jay Higgins, to be followed by Nick, maybe it's Bubruff.
Thank you, Mr. Chair. My name is Jay Higgins, and I just wanted to offer a slightly different perspective on the adequacy of the EIR from a practitioner's view. The objectives in the PEIR include statements like the program is to develop a robust and economically viable legal cannabis industry. The words robust and economically viable are interesting now at this juncture because we have a cap where only a select few will potentially make it to the finish line, and whether or not they're eventually economically viable is anybody's guess. I see a lot of threats on the horizon with respect to appeals and CEQA lawsuits that all come after the process to determine land use compliance with the permitting. Another statement in there is to promote energy and resource efficiency. We were just advised last week that the use of ground-mounted solar panel arrays are not possible in the Carp Ag Overlay District, especially in Area B and in other areas you need a development plan, which is, a couple $100,000 trip to the Planning Commission in and of itself. Another statement is to provide efficient, clear, and streamlined process and attainable regulations. So I could dwell on this for a long time, but as an example, I want to say, despite today's proceedings, things are starting to settle out with regard to the process. Lots more interest by other departments, lots more continuity with respect to how staff is interpreting policy, but there are some road bumps nonetheless. A couple of interesting ones that are undoubtedly viewed by, as viewed as obstacles by the industry, but at the end of the day could be viewed as opportunities with a public interest perspective. Just two quick examples. The fire department has come out and said we want to review cannabis projects against our commercial development standards. So that is very expensive and very rigorous, and it's going to cause a lot of investment opportunities for properties to come up to fire code safety standards, roads, fire suppression equipment on site, maybe inside greenhouses, emergency water sources and supplies and fire hydrants. Another is APAC. I won't get into that, but that's the process where properties can get kicked out of the Williamson Act. On one side, that's bad. On the other side, that's good for the property tax base. So finally, because this is a CEQA discussion, I thought I'd bring up a quick report done in 2015 about CEQA abuse. I won't get into it. I'm sure you've heard it. But it found that projects designed to advance California's environmentally policy objectives are often the most frequent targets of CEQA lawsuits. Transit, renewable energy projects, and infill housing. And I'm hoping we're not going to add organic farming practices to that list. I could go on in this regard, but it's not news to you all. Yet we're here in Santa Barbara in one of the worst housing and homelessness crisis we've ever seen, and we'd be remiss if we didn't make note of the fact that CEQA abuse by NIMBYs is has major culpability in that regard. So I just encourage you to keep your feet on the ground here today. Recognize that all the projects out there that are coming to you all get very special treatment by roads, assessor's office, public works, planning, building, and to name a few. And the industry's compliance post-review always ends up upgrading neighborhoods. Thank you.
Mr. Higgins, I had a question for you. I kind of missed your point about the ground mount solar. I didn't understand.
Well, there's energy saving objectives in the business licensing procedure. So we have a major conflict with regard to how much energy the Edison can deliver to Carpinteria in a timely fashion. So those two things are turning a lot of growers to look for solar panel energy solutions for their projects. And it's difficult to put them on the top of a greenhouse, although not impossible, but there's some constraints there. Certainly it's an option to ground mount them in arrays, but you have the CARBAG overlay ordinance, which if you want to add agriculture related development structures, et cetera, is not possible in Area B if you're already over 20,000 square feet of development. So you just can't do it without taking your existing greenhouse maybe down to 18,000 square feet and then saving 2,000 square feet for solar panel. It doesn't make any sense. A lot of the greenhouses in Area B are already over the 20,000 square foot limit, and maybe we need to have a CARBAG overlay discussion one day about that ordinance. But in other instances, if you can add square footage to your property in CARP, it's still additional development that requires a development plan application, not a CDP, but now you open up your project to a discretionary process. If only to add solar panels, you got to then come to the Planning Commission to add solar panels. That's the net effect of the code.
Well, to show that these things can be a mystery to all of us, I'm putting in ground mount solar behind my barn, and that means that I had to replace my septic tank 150 feet away.
Well, it's a good thing you're not in CARP.
There you are. Okay, Nick Bobruff, and I'm sorry for massacring your name. You can tell us how to pronounce it. To be followed by Jack Usaferi.
Good afternoon, Chair Park, Commissioners. My name is Nick Bobruff. I'm representing the City of Carpinteria. I wanted to commend your staff on an excellent presentation, very thorough in terms of covering the history and overview of the program EIR.
What's your department, Nick?
Community Development.
Got it.
However, your staff did leave out one small but seemingly important detail, and that is back on February 6, 2018, when the board considered adopting the EIR, they did not certify the EIR for the coastal zoning ordinance. They only certified the EIR for the inland portions of the county. Instead, the board adopted a statutory exemption, essentially passing the responsibility for environmental review on to the Coastal Commission to do as part of the LCPA. The Coastal Commission also did not certify the program EIR for the coastal zone. So despite there not being a certified EIR for the coastal zone, county staff has continually been citing and tearing off of the EIR for the individual coastal development permit applications on cannabis projects. And so this poses an important procedural CEQA question. If there isn't a certified EIR, how and why is the county continuing to tear off of it? We believe that at minimum, if the county thinks there is a legal basis for doing this, they need to spell that out in their CEQA findings on all these individual cannabis CDPs. To date, they have not done so. Failing that, we believe that it may be that the county would need to complete individual standalone CEQA analysis on every CDP application for cannabis in the coastal zone. And so really that's what we're here today for, is to try to get an understanding from staff on how procedurally this process complies with CEQA. Thank you.
Thank you. And say hello to Mr. Goja for me. All right. Jack Yousseferi, to be followed by Mark Chatillo.
Chair Park, honorable commissioners, as we all saw this morning, the PIR is the product of a very robust and public process that we went through as a community. It was presented, discussed, deliberated upon, ultimately approved by the Board of Commissioners. I want to emphasize a few things. The deadline to appeal the adoption of the PEIR has long since passed without anyone filing an appeal. The proper process was followed, and now cannabis opponents are simply trying to take a second improper bite at the apple. Relatedly, the PEIR specifically addressed the issue of odor, and the County Board of Supervisors made overriding considerations that the benefits of cannabis cultivation for the county outweigh any impacts. The legal window to contest such overriding considerations has long since passed. Regarding concentration of projects, which was brought up earlier, I'm not the first to recognize that farmers want to farm crops in the microclimates where they do best. That's what all crops do. That's why there are farmers growing a lot of avocados in Carpinteria and Goleta and not so many in Buellton, and why strawberries grow so well in the Santa Maria Valley and not so well in other places. Opponents of cannabis object to the idea that there are nearly 500 acres of cannabis cultivation proposed near, not in, the Santa Rita Hills AVA. By comparison, in that same area, there are 4,000 acres of grapes right now. So even the largest possible outcome that opponents of cannabis that are alarmed about cannabis we would ever see would never total more than 12.5% of the amount of grapes in that same area. Thank you so much for this consideration, this conversation that the community very much appreciates and clearly needs. Thank you.
Thank you. Mark Chatillo, to be followed by, is it Derek Duncan?
Good afternoon, Mr. Chair, members of the commission. I am Mark Chatillo. I want to first clarify that I am personally not anti-cannabis, but I am pro-land use compatibility. Cannabis as a product or as a crop has the biggest footprint of any agricultural product. I think we all realize we're dealing with something different. My goal, I think our goal here is to get it right. There needs to be a full disclosure of the impacts. There needs to be a process that first avoids all significant impacts and then mitigates those that cannot be avoided. And there needs to be full conditioning of all projects, and it needs to be done through a public process. And I would flag the plan, the county's permitting process's reliance on the plans, odor abatement, traffic, landscaping. Those are not subject to public review, and that's something that I think would benefit them if there was an opportunity for public review of those mitigation plans. That's only a staff function. I think that the standard needs to be that there would be no impact from cannabis cultivation on adjacent and surrounding land uses: odor, visual, lighting, agriculture, and public health. And these are facilities that should be away from schools and sensitive populations. It's my opinion that the programmatic EIR is fundamentally flawed. One of the key flaws is what is identified by Mr. Higgins, the project objectives. The county did not engage in a scoping process with the public to identify what should be the project objectives in the EIR. So as your commission contemplates how to revisit CEQA compliance, I think it's important that we go all the way back to what are the objectives of our cannabis program in the state, in the county. This process was approved at a time when our county was in substantial stress. In December of 2017, we were all under federal emergency from the Thomas Fire, followed by, during the dates of the approval by the Board of Supervisors, we were literally digging for bodies in Montecito. So there was a lot of people that didn't engage in this process when there was a final approval. The EIR looked at issues. The Planning Commission made some good recommendations, but the board changed those in ways that we're now struggling with. And now, as we face these first generation of permits, we have a number of issues that are needing to be addressed, and I would underscore Mr. Clemens' advice for applicants to do as much as you can and to make these projects far better than the minimum required by the standards. There are gaps in the analysis of the EIR, and there is new information. And the third piece, and we didn't really get into that in the presentation, but the third piece that I would like to underscore is, in closing, is that of the use of the checklist. CEQA's guidelines provide that the checklist is supposed to be used to identify potential project impacts. The way it's being used in the county is as a scorecard for whether a mitigation measure may apply. That's not the way you're supposed to do this under 15168, and as a consequence, we're finding considerable problems with the projects that are being brought to you, hence the appeals and so forth. So I think there is a way to clean up the CEQA process, and I would encourage your active involvement in that. Thank you.
Thank you, Mr. Tittle. Derek Duncan to be followed by Kathy Duncan. We have any Duncans? Guess not. Tara Steffen, be followed by Peggy Brierton.
Good afternoon, Commissioners, and thanks as always for listening to our comments. My name is Tara Steffen, and I'm speaking on behalf of Cresco, a cultivation farm down in Carpinteria. Within the EIR, there's consideration of 53 separate potential impacts across 14 categories. Of those, 47% were determined to be Class 3, which means insignificant or no impact. For a controversial EIR, to have nearly half of the impacts considered Class 3 is a really high percentage. With regards to the other Class 1 and Class 2 impacts, if you read the document, you'll see everything can be mitigated with a plan. Habitat protection, energy conservation, traffic demand. We as cultivators are already creating less impacts than before. We have far less operational emissions than the previous ag, and we're utilizing once unprofitable and pre-existing greenhouse infrastructure. This is sustainable economics. Simply by introducing cannabis as the new crop, we are providing a decrease of prior pollution, traffic, emissions, light, and we're fulfilling all of this without the consideration of the various SOPs and best management practices that we constantly develop. I worked in the editing department for an environmental consultation firm who has 13 offices throughout California, including one in Santa Barbara. I regularly reviewed PEIRs and project-based DEIRs and FEIRs. This EIR definitely meets the accepted general content and form requirements that satisfy several key compliance points for a CEQA report, so it's very hard to listen to inaccurate criticisms. There's even section 1.7, areas of known public controversy, and it will show you right there all of the concerns that they knew going into this the public would find polarizing. Number 1, objectionable odors, zoning, compatibility with existing residential communities. These are all the big ones that we've been listening to for the last couple years. This report did take into account all of those considerations when drafting the document, but the case for feasible land use and working regulations is proven in the text. Thank you.
Thank you. Okay, Peggy Brierton, followed by Reverend Mary Moreno Richardson.
Good afternoon, Chair and Commissioners. This EIR did not consider impacts of clusters, density, and size of grows. That's the number one problem. Every other county in the state of California does. They have a limited per parcel amount that they can grow. We need to do the same. This has led to heavy concentration at open grows on Ag 2, which have no odor abatement requirements. And according to state statistics, according to state licenses as of 8/20/19, 44% of cannabis cultivation would be grown in the 246 corridor. This is just unacceptable. We heard just recently about how the air quality for greenhouses seem to be on their way of getting resolved. Setbacks, still think, are important on those, but they're getting resolved. Open grows, nothing on Ag 2, everything in the open grow. Appropriate setbacks need to be done, not just to protect the EDRNs, the rural boundary lines, the wineries. There's so many areas that need to be fixed with this. The boundaries on the lots that are cultivating cannabis, the boundaries should be there, and the boundaries should be appropriate for the EDRNs, the communities, the residents that are out there. And EDRNs really do need your protection. They were allowed by county to exist. So those are little mini communities out there, and they need more protection than they're getting. And conditional use permits, maybe everything needs to go through a conditional use permit, and that way it could really be looked at. I think this problem could be solved if we go to per parcel lots. So those are my concerns, and I've got a few more minutes here, just another minute. So just to recap, my 3 suggestions for this would be per parcel cap of 3 acres per lot, per parcel, appropriate setbacks for boundaries as on cultivated lots, and setbacks from EDRNs and rural boundaries. And coastal valleys are windy valleys. This has to be acknowledged and considered. And cups for all Ag 2 properties. By the way, this, I believe, should not be transferable and renewable within a 5-year time period. And one of the reasons is that I live in Buellton, and in 2025, we're going to be looking at our UGB again. We may be expanding. And so I think that we need to keep those things in mind. I don't know if we will or not. It's going to go to the voters. But that's why the 5-year renewable conditional use permit, non-transferable, is what I'm recommending. Thank you.
Thank you. Okay. So Reverend Mary Moreno Richardson to be followed by Tina Frontato.
Good afternoon. I'm here in support of our cannabis growers in Santa Barbara County. I'm a retired Episcopal priest, and I also serve as the Commissioner on Behavioral Wellness. I'm not here representing the Commission at all, but I am here to say that one of the things that we look at over and over again are the resources for all the programs and our schools and all the need that we have in our community. And I really believe that cannabis, bringing cannabis into our community and the resources that can come in are going to help us tremendously. I've been speaking with a lot of our growers, and as you all know, the mandate is to give back to the community. And so many of them are committed and excited to fund different programs, from our homeless population to jobs to different resources, to all our nonprofits. I also serve on other boards, and as you know, if you serve on a board, that's your main goal, is to find out where you're going to get the money to keep all these programs going in our community. And as we know from the fires and the mudslides, we are going to have to make some tough choices. The other point I'd like to make is that if we can remember, the wine industry 20 years ago, or plus years ago, was also met with a huge opposition of fear, of pesticides and water use and traffic and DUIs, and all of it turned to be out fear, and it was not reality. County staff, with contact professionals, have developed the most comprehensive and regulated county ordinance ever, an ironclad ordinance to regulate the cleanest and most environmental friendly plant ever grown in our county. I've also served on the board of directors for the National Organization for Clergy Against Prohibition, and for the last 25 years I've served as a chaplain in different prisons and detention centers from San Diego County, LA County, and San Francisco County. And as you know, because of prohibition, there has been mass incarceration, and that's affected in the impact of our communities of color and the poor. So I really believe that having our growers here in our community is going to be a win-win situation for all of us. And I invite anyone who would like to tour these different farms and find out, have your questions answered and everything. I think that if we really look at this and see what this can do for our community, it's going to be fantastic. I'm very grateful that there's this incredible plant that's been given to us by our Creator. Thank you.
Thank you. Tina Frontato, followed by John DeFriel. Tina left, okay. John DeFriel to be followed by Carmela Beck.
Hello, Planning Commissioners. My name is John DeFriel. I'm a farmer in the San Ynez Valley. I'd first like to start off by thanking staff for the thorough presentation. It all rolled right off their tongue and clearly was very well practiced and very informative and covered all the bases, had a good flow. So thank you for that. I'd also like to mention that we have formed a working group as part of our Good Farmers, Great Neighbors, which is a marketing initiative from the North County Farmers Guild, where we have a contingency of winemakers, cannabis farmers, tourism companies, vineyard operators, organic vegetable growers, and local restaurants working together to create a tourism and marketing initiative in the San Ynez Valley. We hosted an event a couple of weeks ago that had over 200 people in attendance. Some of the people in this room were there. And it went very well, and it's a way to build a network between neighbors. Similarly, an effort for North County Farmers Guild is developing best management practices that go above and beyond what is asked of us. So we're focused on developing odor mitigation approaches. For example, at our farm, we freeze all of the flowers and don't do any drying on the facility. All that product then gets shipped off-site to a manufacturing facility where it's extracted for oils. We're working closely with our neighbors to plan spray programs, mitigate drift issues. We did have one neighbor that did not want to work with us and repeatedly drifted onto us, and we did have to bring the county in on that. The main reason was we were testing positive on the windows of the houses that our staff live in for pesticides drifting on. At no point in time was a lawsuit threatened. We're just working on figuring out how we can mitigate those issues and not have it happen anymore. Additionally, through our manufacturing process, is part of why we're not terribly concerned with drift onto the plants is through manufactured oil products you can actually remove pesticides, so there won't be a total crop loss. And additionally, we support taking the plastic off of hoop houses and putting cover crops in ground during the winter time, dry farming cover crops, which mitigates erosion and water runoff. And at the state level, recently SB 527 was passed, which is the state acknowledging that hemp and cannabis are compatible with the Williamson Act. So you're starting to see the state take a bigger and bigger push towards recognizing that cannabis is an agricultural crop. And additionally, there's been a lot of talk that we couldn't have foreseen a lot of these measures, a lot of these issues when the EIR was developed. We participated in the baseline study for the EIR. We had the authors of the EIR out to our facility and several other colleagues' facilities. Cannabis is not new to Santa Barbara County. It's been growing for a long time, and we have had ways to study this. And additionally, it's considered that it's a bad thing that Santa Barbara County has a large number of licenses. All that demonstrates is we have more compliant operators here. We might have more licenses than Humboldt County, but Humboldt County estimates they have in excess of 15,000 operators that haven't even applied for licenses, which far exceeds anything we're doing here in Santa Barbara County. So a large number of licenses is actually something to be proud of. Thank you.
Mr. DeFriel, I have a question or two about your comments.
Yes,
you
sir.
mentioned the Guild preparing a list of best practices.
Yep.
Will that be in written form, and is that something that can be disseminated soon?
Yeah, we're in the process of drafting. It'll be disseminated in the next few weeks.
That would be excellent. It'd be great to have that before any of the actual hearings on projects.
Okay.
And because that includes such things as drying. You mentioned freeze drying.
Yeah, so we do flash freezing, and then we would encourage operators to add mitigation techniques if they do choose to dry in the fields to ensure that they have drastically mitigated any sort of odors leaving off-site.
And you bring that up because that shows that there are ways to affect the emission of odors other than after the fact odor control systems, right?
Correct. In our experience, the live plants themselves don't actually emit a large amount of odor. It's the drying process itself. So since we freeze live plants in the field versus and then extract them versus extracting a dried plant, when we extract the oils from a live plant, we end up with 10 times greater terpene content in the finished product. Then when we dry it, you lose about 90% of the terpenes through that drying process. The only place they can go is evaporating during the drying process. So that's the place you need to focus on mitigating your odor. It's not actually in the plants growing themselves.
Well, I look forward to seeing the dissemination of the best practices as soon as possible, because I think the education of what you actually do and how things actually work will really help us evaluate particular projects. Thank you.
Chair Park. Thank you.
One more thing, Mr. DeFriel, or a couple more things. Thank you for bringing all of the positive points out that shows you guys are really working on how to help move the cannabis world forward.
Thank you.
And start to relieve some of the unknowns with the knowns. On that, on the odor issue, and what you're doing sounds really outstanding from many points of view. But do you have any data that would show like a graph or the curve of the smell production? In other words, over the cycle of the crop, when does that smell get the highest, or the escaping terpenes or evaporating terpenes?
We haven't done a full time series study. We have done one study, and we're doing a follow-on study to show in full production what the actual smell is on a field where we're not drying anything and where everything is in production. And the preliminary studies show, very similar to the SCS data, that there's been a lot of talk about the great winds in the San Ynez Valley. Ironically, the winds are one of the things that really mitigate the odor, because the winds create mixing. And so when you have a bad odor problem is when you have a pressure system that just sits on an area and you don't get any mixing, so the odor compounds stay close to the ground. If you get a strong breeze, you get a lot of mixing vertically throughout the air, and that dissipates the odors. And so that's actually what we see on our farms, is that just even on our fence lines 30 feet away, 100 feet away on the other side, there's virtually zero odor. And we've brought in the people who actually do the litigation for odor studies in Colorado. They're a firm out of Florida and they use the Nasal Ranger, which I believe the county has also purchased to do its own odor inquiries on. And so what it is it's a device you put over your nose as a carbon filter, and you can set dilution ratios. Because one thing that's a misconception about odor, which I only learned through this process, is like, just because you can smell something does not actually make it an odor or a nuisance. It has to be at a certain threshold. So they can set this dilution to blend incoming air with carbon filtered air and determine where it's detectable. Using that device at our fence line and all throughout the perimeters of the city of Buellton and all around our property, we took like 100 plus data points. There was no detectable odor. I hope that answered your question.
Yeah, so would you relate that then to your specific process? The reason the odor's not there is because you're removing the buds?
Yeah, as soon as the flowers are ready for harvest, we go in, we chop them, we cut them into branches about this big. Those branches go into vented vegetable baskets. Vegetable baskets get palletized, forklift to our freezing facility. There we dump the flowers out on a table, move the flowers through a 30-foot liquid nitrogen cryogenic freezer tunnel. It all gets frozen in the tunnel in about 4 minutes, comes out the backside, scoop it into 5-pound bags. They're food-grade Mylar bags. We nitrogen purge and vacuum seal the bags, five 5-pound bags into a wax romaine lettuce cardboard box, 36 boxes to a pallet. Pallet gets forklifted into a Sealand shipping container stored at negative 30 degrees Celsius. That whole process takes about 45 minutes. The only time you're really emitting odor is when you start cutting the branches, because so like the way the terpenes are made in the plant, they're made in what's called a glandular trichome, which is a mushroom-shaped gland that's on the surface of the flower, and it's actually a waxy cuticle. So the wax is actually holding the terpenes and the cannabinoids inside of there. the terpenes can't really evaporate at very great rates unless those glandular trichomes actually get destroyed, which can happen if like a really strong breeze blows through and the leaves whip the flowers and break the glands. You'll get, a little of that is always occurring, and that's where the odor is coming from. So as soon as you go out in the field to start harvesting, you've got people handling flowers, bumping it with their arms, breaking glands, making cuts in the plants with scissors, and that's when the initial odor emission would begin. Now, the first thing that happens though is this is essentially like distillation. Energy comes in from the atmosphere, the water evaporates through those cuts and abrasions. The water begins to evaporate first, and then the odor doesn't actually really start to pick up until around like day 3 or 4 when it's drying. Because at that point, so much of the water has left. The water has a lower boiling point than the terpenes do. So once the water's gone, now the energy goes to boiling the terpenes. So if that's, that happens around days, day 3, 4, 5-ish, depending upon the conditions you dry it in. At that point, the terpenes will actually start to leave. So since we do it in about 45 minutes, you get a little bit of emission from the initial abrasion and destruction of the glandular trichomes. But once it's all frozen and vacuum packed, there is zero chance for the terpenes to escape. And the main reason we do that is since we're selling oil products, the terpenes are one of the commodity products that we sell. And if I let it evaporate, I'm just letting money go in the atmosphere.
Thank you. Appreciate it.
Thank you.
Thank you. Okay. Carmela Beck, be followed by Matt Allen.
All right. Good afternoon. My name is Carmela Beck. I work in compliance and production on a cannabis farm in Buellton. I recently left a decades-long career working for a large conventional and organic berry company. I moved specifically from Santa Cruz County to Santa Barbara County to work in cannabis. I'm thrilled and I'm extremely grateful to work in cannabis, and I look forward to having a long career in this field. I'm here today to show my support for the county's extremely robust PEIR. I want to thank the staff for their excellent presentations. Y'all did a great job at outlining the PER timeline, the process, the requirements, the public comment opportunities, and the number of meetings to arrive at the PER that we have today. And I absolutely need a copy of that. So the presentations are proof that legal cannabis farmers are highly regulated. The planning commissioners have a plethora of adequate tools at their hands to evaluate good legal cannabis farmers. There's no new information at this time to warrant a change-up in the current process. We'll continue to support your work in regulating cannabis, and we also look forward to continuing to do what we do best, and that is farming legal cannabis. So thank you for your time, and we look forward to continuing this process with y'all.
Thank you. Okay, Matt Allen, to be followed by Sarah Rotman.
It's okay if you don't skip it. John covered odor for me.
Okay, thank you, Matt.
Thanks.
So Sarah Rotman, be followed by Andrew Rice.
Good afternoon, members of the Commission. Thank you so much for listening to us today. My name is Sarah Rotman, and I am the co-founder of the North County Farmers Guild, as well as farmer and owner of Busy Bees Organics, together with my husband, who you've heard before is a third-generation avocado farmer. We live and operate on our farm in Buellton. I'd like to thank the county staff for their thorough presentation today, which supports the detailed PEIR. And I'm grateful for this opportunity for the Planning Commission and the public at large to revisit what is required for all cannabis farmers operating legally in Santa Barbara County. I hope the information presented today will be taken to heart. It has been troubling to hear once again the inaccurate statements that pervade our detractors' comments. Today we heard firsthand the strength of the PEIR and the cannabis ordinance itself. Remember, it took 30 public hearings, including a scoping process, and copious public comment to craft an ordinance and a PEIR that considered everything we are discussing today, including terpenes, odors, and concentration of farms. The North County's Farmers Guild, as John, my colleague, just was speaking about, is committed to best practices that go above and beyond what is called for in this ordinance. We support the PEIR, including all of the regulatory state and local agencies whose sign-off is necessary to obtain our entitlements. And I'd just like to run down a very brief list, but certainly not an exhaustive one. We have to go through the State and Regional Water Board, California Fish and Wildlife, the Sheriff's Department, Health and Human Services, the CEO's office, the CDFA. We are compliant with metric states track and trace systems, and of course, we have to work with the Planning and Development Department in order to obtain our objectives. Everything, notwithstanding, even with all of these agencies overseeing every aspect of our efforts, our members go above and beyond by substantially adding to the requirements, much as Mr. Clements had mentioned. We have additional environmental analysis and reporting that we have included in many of our land use permit applications, not required by the land use permit application. We have included things like county-approved biological assessments, hydrological reports, archaeological reports, architectural review. We, of course, are subject to the county's weights and measures, and also the necessary requirements of our energy use, just to name a few. I'd like to sort of say also anecdotally, as it was brought up, I've been troubled to hear all of this conversation about the compatibility. Our farm, for one, has enjoyed an incredibly positive relationship with the two conventional agricultural crops on either side of us. We farm right up to the allowable edge of our property, and we live next door to conventional broccoli, and they spray a great many things that are not legal in our crop. However, they work with a very conscientious third-party spray applicator, and they are very conscientious farmers. We have never had a single problem in any of the years that we've been operating. We have been legal non-conforming for quite a few years, and we have had a fantastic relationship. All it takes is a little bit of communication. And so I'd like to say that, at least in our experience, there has been no conflict. And I just want to add that, you know, everyone on the North County Farmers Guild and in our legal cannabis community remain committed to supporting our community that we all call home through our ecologically sound farming practices and to offer the economic strength that we bring to our employees and the local economy. Thank you for your consideration.
Thank you. So we have Andrew Rice, to be followed by Jesse Zaragoza.
Hi, Commissioners. Thank you very much. My name is Andrew Rice. I'm with the North County Farmers Guild. First of all, I just wanted to thank staff. That was a terrific presentation. I know I learned a lot. Great work. The main thing I wanted to say today is that in hearing the comments opposed to the EIR and opposed to cannabis, they seem to focus on two things. Number one is speculative effects like terpenes getting into grapes, where we've seen no science. No science has been presented for that. An EIR can't foresee a speculative effect that no one can prove. So I just want to say that. The other one is there's been criticism of this EIR in that it didn't foresee the exact location of projects, the exact number of acres. Everybody knows that an EIR is based on the best available science, best available research and information at the time it is written. It is not supposed to be a crystal ball. And every EIR, in hindsight, missed something or has something that would be different. That is by no means a reason to throw it out or to consider it inadequate. I think we saw what a thoughtful process this was, what a robust public process it was. All appeals periods have gone by. No one appealed them in the moment. And as staff also demonstrated to you, folks up there have tremendous other tools if you want to influence the process at this point on a project basis. Thank you very much.
Thank you. Jesse Zaragoza, be followed by, okay, Jesse's not here. So then we have, is it Kayvon Bagby? I don't, you have to tell us what your first name is.
Kayvon.
Kayvon, okay, I was sort of close.
I have a PowerPoint presentation. If there's somebody else that I need to load a PowerPoint.
Okay. I think I have no more speaker slips. Do we have any more? Actually, we can recall those others. Now, did Kathy Duncan or Derek Duncan come back? Okay.
Well, while we're waiting, I'll start by thanking the staff and Planning Commission to be here today to help clear up, obviously, a lot of these issues. I'm here basically just to go over some of the topics that were brought up in opposition to the projects that are coming up in the North County. Just going to rip through them pretty quickly here. But first, there was the talk of the Australian study, which stated that there was a terpene from a eucalyptal tree. When you actually pull up the study or read the study, basically it came to conclude that it was the eucalyptus leaves that were in the bins when they were processing the grapes. That's what I read. That's what I found. Actually, on the end of the study, they have a contact person. I decided to contact them and just confirm what I read. They said, yep, that's correct. Basically, if it's not in the bins, you're not going to have it tasted in the wine. Next topic that was brought up was the size of the grows that are being proposed. If you go to, obviously, California, it's a new state. There aren't a lot of grows that are completely licensed and up and running, but if you look directly to our north, Oregon, there's large grows all over the place, that are definitely comparable in size and scope. But what I found, even more interesting, which I think the Planning Commission should kind of consider when we're talking about this terpene and taint issue, is in Oregon right now, there's 46,000 acres of hemp that's being cultivated. Now, hemp actually has identical terpenes to the cannabis plant. Same terpenes, same plant, same aroma, same smell, same potential contamination from what the wineries are I guess assuming is potentially out there. So I went actually up to Oregon and visited some of these wineries, talked to them firsthand, and they're living in harmony with these hemp growers and these cannabis growers. It's not like the sky's falling. They're actually working together, living as neighbors. Here I found an actual post from one of the wineries on their Instagram talking about, look at this beautiful sea of green. And this is an actual hemp field that abuts a winery. Same terpenes, side by side, plants growing together, no issues on the winery. I spoke to the winery, asked them, how do you guys navigate the spraying? How do you guys deal with the pesticides that you guys use? They said, we mind our pesticide spray. We're careful that where we apply it and when we apply it, but there hasn't been an issue on either side of it. So there's ways that we can actually work together and not, be adversarial. When we got our project appealed initially, we called the appellant, tried to, talk to them and see what exactly was the issue, but we weren't able to get anywhere, weren't able to actually even get a phone call back. So I think that maybe, if we were able to have some dialogue and be good neighbors, as staff is suggesting, there's a way to do this, as we've seen. And the talk of the wine industry, being ruined or having to move, Oregon, like I said, 46,000 acres of cultivation of hemp and cannabis, and their wine industry is thriving right now. I mean, it's not like the sky is falling. So I just want to say, let's rely on facts. Let's make actual decisions based on real information and not just assumptions or maybe misconceptions that may be out there. Thank you.
Mr. Bagby, will you remind the commission which is your project?
Santa Barbara West Coast Farms.
Okay.
Thank you.
Thank you. Well, we're out of speaker slips. Are we out of public speakers? Looks like it. Okay. Then we'll close the public hearing. Oh. Okay. And now is the time for commission questions, not deliberations, because we're not deliberating on anything. But we're going to take a break. 5-minute break. And before commissioners chime in with their questions and comments, we should allow staff to respond to anything they heard in public comment. Is there anything you want to respond to?
Good afternoon, Chair Park. Yes, I have a few points that I'd like to raise at this point, and for my colleagues, go ahead and chime in here if you have other items to add. The first point I want to make is I want to make it clear the distinction between a legislative policy decision and an adjudicatory decision on entitlement application. And what I mean by that is that your commission and the board had the opportunity to consider the legislative policy considerations of this ordinance back when it was going through the hearing process. And in a second, I'm going to bring that chart back up that shows all of the hearings that occurred. And there was extensive consideration of the various policy options that were available to your commission and ultimately the board when it came to cannabis. And as Ms. Leachman discussed this morning, we purposefully wrote the EIR to be broad enough to capture all of those various options, which we felt were feasible, viable, very legitimate policy positions to take, but were very disparate. I mean, we had everything from a complete ban on commercial cannabis to a completely unregulated environment with no caps and everything in between, so to speak. Once again, that was intended to give the board the most policy options, and that is the forum at which we should be discussing how the legislation and the ordinance regulation should be written. Okay, now that decision was made, and I understand that particularly for the opponents to cannabis, that was very dissatisfying with regard to specific aspects of this program. And now you're in the position of adjudicating these entitlement applications under the umbrella of that program. And I understand that many of you may not like where the board landed with regard to some of those policy decisions. And my response to you with regard to that is you are going to get the opportunity to take another crack at those legislative policy decisions when the ordinance amendments that the board directed us to present to your commission are in fact presented to you, and we're estimating that that will occur late fall or before the end of this calendar year. That will be the start of, once again, hearings at which you'll be able to list all of the items that you find objectionable in the ordinance and tell us what you would like us to do to address those items such that you can make a policy recommendation to the board. Now, you have these applications that are going through the process right now. You don't like some of the regulations. I get it. And that's a very frustrating position in which to be. That was the point for me to get, that was why I was emphasizing all of the tools that at your disposal to try to make these applications more palatable given the fence posts within which the board has allowed you to play when it comes to cannabis. That is, the board has adopted the regulations. Now we're in the implementation phase. Now you have tools to address the specific aspects of the project such that it is more palatable to you, yet within the confines of those policy decisions that were already made. So just wanted to emphasize that point. Now, going with regard to some of the specific points raised in the testimony, with regard to concentration. So once again, as Ms. Leachman stated this morning, there was no cap assumed in the project description. There was a project alternative that did consider caps. So that policy option was available to the board. The board chose not to go there. But there's been critiques that the EIR did not sufficiently analyze the impacts associated from concentrations of cannabis operations in certain locales throughout the county. This is figure 2.2 on the screen from the EIR. What you'll notice here is there are clusters of cannabis operations that existed at that time. And those were existing cannabis operations that was in the medicinal environment. And it's actually on page 2-2 and in table 2, 2-2, and in table 2-1, we documented where these locations exist. And for the impact analysis, for their methodology, what AMEC Foster Wheeler, now Wood Group, did is they said, this is where we've seen the concentration of the applications. It's very likely that we will continue to see concentrations of applications in these locations. And in fact, if you count up what was shown there, about 80% of these applications are located in the South Coast area, San Ynez Valley, and Lompoc. There's also a cluster up in the Tepiscay area. Where are we seeing applications right now? South Coast area, San Ynez Valley, Lompoc, Tepiscay. So in other words, the EIR did predict concentrations. We are seeing those concentrations. And now it's our opportunity to address the site-specific aspects of these applications to make them work to the best degree possible in these concentrated environments. If you cannot make the findings for approval, ultimately you may deny the application. But once again, this scenario was envisioned and predicted in the EIR, and it is in fact what we're seeing today.
Can you blow that one up?
I don't know. Yeah. Okay.
Or do you mind breaking your flow? You want to do that afterwards, after you're done?
More concentration. So. Okay. Just let me know what you'd like to see.
Centered right about where you are.
Sorry.
Buellton. Pick Buellton.
I'm sorry, this is a little bit clunky to navigate, but I'll do my best.
I'm just curious, the western end of the San Ynez Design Overlay D, where does that show up there? Where would it show up?
Yeah, excuse me, I don't have the precise boundary, but it's right about in here, I believe, roughly.
And those were existing grows at the time of?
Yeah, existing and past grows. As of that date.
You said existing what?
And past grows as of the date when we prepared these figures and collected the data.
Okay.
Okay, so a couple of other points I'd like to raise is that the PEIR did evaluate the specific meteorological conditions that affect air emissions and odor distribution and dispersion. Particularly if you go to page, for example, 3.3-1, there is a general discussion of, for example, the effects that inversion layers play in air emissions and dispersion. So that was evaluated. And also you want to take a look specifically at section 3.3.2.1. Don't worry about this, Commissioner Park. We are going to give you an annotated presentation, so we'll provide all the references to the relevant EIR sections for your review so that you can go back and take a look at these sections again and take a look at the analysis. But the point is that the various meteorological conditions throughout the county in these locations was considered when we were evaluating the impacts, and it was assumed, for example, that you would see air inversion layers in areas like Carpinteria Valley or the San Ynez Valley where we have seen those conditions exist, and what are the types of effects that would result in those areas. So it was evaluated. Next point I'd like to make is with regard to the right to farm ordinance. I didn't quite understand Ms. Taylor's argument, but regardless, I want to just clarify what actions the board took with regard to the right to farm ordinance and also the Williamson Act, because there appears to be some confusion out there regarding this. The board adopted ordinance amendments to specifically exclude cannabis operations from the right to farm ordinance, such that the board would have the ability to regulate odors from cannabis operations, unlike the situation with other types of crops which are protected under the right to farm ordinance. We saw that there was a desire to address odors, so we proactively proposed those amendments, and the board did adopt those. So once again, cannabis is not subject to the county's right to farm ordinance. However, when it comes to the Williamson Act compatibility guidelines, the board directed us to amend the Williamson Act such that cannabis does count as a qualifying crop for Williamson Act contracts that involve cultivation. In other words, cannabis can count towards your minimum cultivation requirements of a cultivation contract. So just want to clarify that just so everybody's clear on whether or not it's ag or not ag, because that was a raging debate throughout the preparation of these ordinances. Commissioner Park, you did ask some clarifying questions of Mr. Higgins with regard to the solar arrays. I think the message got a little bit muddled. We are not saying you cannot install ground-mounted solar arrays at sites. The particular case he was discussing is one in which it's in the Carpinteria overlay. There's a cap of 20,000 square feet of greenhouse development, and in that situation, the operator is having a difficult time because there has already been a certain amount of development that's exceeding 20,000 square feet. how can you now install solar arrays to meet your energy conservation requirements under the business licensing ordinance, given the fact that you've already exceeded the amount that's allowed. So in that particular case, you either got to redesign what's already on the ground, or you're going to have to come up with a different way to come up with your energy conservation requirements, because that specific site has some other non-cannabis related requirements which are preventing the installation of solar arrays in that specific situation. But once again, solar arrays are actually encouraged as one of the energy conserving potentials with these operations. Finally, I'd like to go back to the presentation, slide 11. There was the claim that the EIR did not go through a public scoping process. That's false. I want to point your attention to the green diamond right here, July DEIR public meetings. Those were the scoping meetings right there. And then we also had the meetings after we published the DEIR in October. Those are the public meetings right there. And then you'll also notice all the various informational meetings that occurred throughout this process. So this was a very public process. There was a lot of opportunity for input, and I'm very glad that some of the commentators got up here and discussed, like, for example, the areas of controversy that were identified in the EIR, because they're the exact same issues that are coming up right now. This is not new information. These impacts were evaluated in the EIR. So no new information here for the majority of these items. So with that said, I don't know if any of my colleagues have any other points to make. We'll turn it over to you for your questions. Thank you.
Very good. So do any of my fellow commissioners have questions of staff? Looks like some do. Let's start with Commissioner Briley.
Okay, well, just on that last one about the scoping meeting, I guess maybe by the way, there's a great chart on the timeline, and I'm new to this topic, so I have been overwhelmed trying to catch up. You know, I mean, I've done the best at trying to get through this document. I still haven't completed it. I've done a ton of site visits. I'm going on your website, and I probably need to do it all over again because it's a ton of information, right? So this timeline is really helpful. I thought what I heard, it was Mr. Shatillo said that there wasn't a scoping meeting. So in the July DEIR public meetings, that implies to me that the draft had already been drafted. No, so that really should be scoping.
Yes,
okay.
That's correct.
And then later, when you had the October public meetings, that's on the draft document. Okay.
It seems unbelievable because that's an extraordinarily short time frame to prepare a DEIR of this size. So
Yeah,
it's understandable.
I'm glad you said it first. It's been light speed on that track. I had a couple other questions. Should I just continue on, or how do you want to do this? All right, thank you.
Take your time. You couldn't possibly ask as many questions as your predecessor did. So.
Because I
and
probably
we
have
all
the
adored
most.
her. So.
I probably have the most. Yeah. No. This actually. Thank you. On slide 36 of your PowerPoint, there is reference to the Ag Commissioner's process, and I'm not sure I really understand that. I think that came from the Board of Supervisors, excuse me, and I'm just wondering what exactly that's involving in its timeline. 36 slide. I need more information about what exactly is hoping to come out of that.
Mr. Chair, Commissioner Bridley, it was not actually directed by the board, but the Ag Commissioner took it up, and they have put together a stakeholder group that includes 5 representatives from the cannabis industry, 3 pest control business reps, 1 pest control advisor, a row crop agriculturalist representative, and vineyard management representative, citrus and avocado representative. So they've tried to create this cross section of farmers and then pesticide applicators. And they are going to be meeting to discuss, and it's also from throughout the county. It's not just North County, South County, whatever. They have a mix of people. They're going to be meeting these are private meetings, so they can have open conversations amongst themselves about the conflicts and the issues that come up with this and ways to resolve it. So they're starting their meetings here shortly. I think either this week or next week's their first meeting. And they have a series that will be held, It's facilitated by some professional facilitators, and they're only focusing on the ag pesticide conflict.
Oh, okay. Thank you. That helps. Okay, on page 38 of your PowerPoint, well, this is where you talked about odor control, and it's probably in several areas where Mr. Clement talked about the other tools in our box to use in dealing with the current applications going through the appeal process. So my question is, I think I heard you say that if odor control is insufficient, the Planning Commission can require more via the LUDC findings. I guess what I'm struggling with is, obviously the world didn't understand that odor was going to be as bad as it is, because I think that's explaining why we're having such a boomerang reaction from members of the public. And I've heard equal angst on both sides of the issue, so I'm trying to figure out where the middle ground is. So if we have an application and we've got these findings, but we don't know that the odor is going to be that bad because they haven't started growing. It's one thing if it's a legal non-conforming and they're coming in, or they're in a pre-existing site, or if it's new outdoor grow. How do we know? I mean, I know in the good old days of conditional use permits, you threw on conditions that had permit compliance, and you made them come back every 2 or 4 or 5 years, and then the county moved away from that because it's burdensome on the applicant, it's time-consuming for staff, etc. So I guess that's the tool. I'm wondering, how would you advise we try to get our arms around that?
Yeah, so through the chair, Commissioner Bradley, good questions. So, and I want to make the link more clearly. So in order to make the finding that the project complies with whichever ordinance that you're dealing with, LUDC or Article 2, you need to find that the project complies with the development standards of the cannabis ordinance, as well as others. And it's in the cannabis ordinance standards where it sets forth the requirements for odor abatement. And it's, once again, it was written very broadly. There's a number of options available. But in addition to that, the responsibility for mitigation, monitoring, condition compliance, that falls with us. And as part of actually the G&K appeal that went through the commission, ultimately made it to the board, there were additional condition compliance requirements placed on odor control, whereby the director, within that first year after installation and operating the odor control system, she's then going to have an expert come in and verify whether the efficacy of those systems, and has the authority to go back and make revisions if needed to basically improve the system if she finds that it is deficient. And then there is a monitoring component, and ultimately, if they find that odor control is not effective and it's not meeting the standards of the ordinance, we would then have to take action on the entitlement. And that there's a number of things we could do.
So in other words, even though we're not dealing with CUPs per se, we're just dealing with LUPs on appeal, that's available to us if that's something, okay.
That's correct.
Then I actually don't have any more questions, other than I think that the issue that Mr. Bobroff brought up about the certification of the EIR for coastal was pretty interesting. Did you guys have a reaction to that?
Yeah, I'll say that a week and a half ago, I think it was, I was in discussion with Mr. Goja at the city with regard to this issue. We're looking into it. We disagree. I think it's demonstrates a misunderstanding of how the Coastal Act works with regard to CEQA and the CEQA equivalent process of the certification process for local coastal programs and local coastal program amendments, because we did take all of the actions that are required, given the fact that it is a Coastal Commission certification process and is an LCP amendment that was being approved, and the rules are different with regard to how you treat that process as compared to EIRs that apply to the inland areas. The CEQA and CEQA guidelines consider the Coastal Commission certification process and adoption of a local coastal program to be the CEQA equivalent. So there's specific rules that apply to that process. So we are looking into it. With that, I'll turn it over to Ms. Richardson, see if she has anything else to add.
Mr. Chair, Commissioner Bradley, I don't have anything more to add other than we'll look into it and check into the legal authority more and have a solid answer. Probably, well, definitely by the time you see another coastal individual project in the coastal zone.
Commissioner Cooney.
Thank you, Mr. Chair. I had several questions, but I'm only going to ask one because it outweighs, in my mind, the import of the other two that I can get answers for later. I wrote down the word discretion when Mr. Clement uttered it in connection with tools of the decision maker, because it's been my understanding that in the case of a coastal development permit, which is involved in many of the Carpinteria projects that are granted and on appeal, that we would have limited discretion with regard to adding conditions. And I've been an advocate for a conditional use permit process as opposed to mere coastal development permits. On the other hand, it seems that there's some more flexibility in applying a coastal development permit than I thought. And CEQA is quite clear that if you have a project that's that the decision maker has some discretion to apply conditions as opposed to just ministerial according to an ordinance list, that the entire project is discretionary. And that implies the potential, if not the requirement, of environmental review. And so I was trying to picture how we're going to go forward in these hearings, because they're much closer to what we're applying in the case of a conditional use permit in the inland area. So using the G&H project as an example, I recall that we were concerned about the efficacy of this new odor abatement system. And so the question in my mind was, how are we going to prove it to be effective or not? And we developed a process for having the director true up the system before it actually goes into operation, and potentially could lead to denial of the project actually growing. Now, as I recall, I thought we were real close to the edge of what we could do in that case, but staff said we could, and we went ahead and did it. So using that case as an example and that condition we had of direct review, is that an example of use of a tool that we have in the CDH context?
Through the chair, Commissioner Cooney, yes, that is a perfect example of a way in which you could come up with a site-specific method for ensuring in that particular case that the odor control system does in fact operate in the way that it's purported to operate by the applicants prior to actually installing it and see it operate. Because I understand the reluctance to allow these operations to occur because there's skepticism about the efficacy of these systems, but you got to give them a shot. And if we have substantial evidence in the record and we have to show that it will work, we got to give them a shot. Yet, we must verify that those claims were correct and the efficacy of the system is functioning at the level that the code requires. Once again, the planning director cannot smell the odors from a residentially developed area. Okay, that's the standard. That's a strict standard. So, once again, by the use of either an engineer or a certified hygienist, those people will assist Director Plowman in making that determination about the efficacy of those systems. If they fail, there's a series of measures we can take to get them to actually achieve compliance with the standard. And ultimately, if they can't achieve compliance with the standard, then we're going to be looking at revoking their permit.
Or changing the ordinance, which I can't imagine happening. But that's very helpful. And encouraging in the sense that as these appeals come to us, I'm focused on those in Carpinteria because those are the ones I hear the most about. But throughout the county, I think it's important for us as we identify through public comment and representatives of the parties, we identify a good condition that could be added to make the project palatable or improved or mitigate the environmental impacts, we're not frozen out simply because of the label. It is a ministerial permit.
Yeah, and for what it's worth, for the applications since the G&K application where we did receive that direction from your Planning Commission, we are writing into the conditions for odor abatement the compliance monitoring components that you applied to the G&K project, because it's good monitoring. That's how we'll ensure the efficacy of those systems.
Great. Thank you very much for walking me through that.
Commissioner Freeney.
Thank you, Chair Park. Mr. Clemens, while you're up to bat here, I think I have understood this from you in the past, the discussions, that the Ag 2 lands are exempt from any smell ordinance.
Through the chair, Commissioner
Or not
Freeney.
ordinance, excuse me, but
So just to
regulation.
clarify, so everybody's clear, so odor control requirements do not apply to cannabis activities in the Ag 2 zone unless a conditional use permit is required for the activity.
So standard LUP that's been coming before us, it's currently not a topic of discussion.
In the Ag 2 zones, that's correct, yeah.
However, it seems to be quite an area of controversy. And I think that's where I'm stuck, is I'm very uncomfortable with the whole situation. I understand that was a decision the board made, but yet here they come to us and I hear compelling arguments from both sides. So that's going to take me to you, Ms. Leachman. And
By the way, I have follow-up on that. When it's my turn. No, you keep going.
Okay, all right.
And you might
Or we
find
can
that,
tag team it. I'll tag out for a
No,
little
no.
bit.
You go ahead.
Okay. So now we're in the EIR and a tremendous effort and contemplating everything that we've heard today. I don't know how you would do that, but you did and in record time. So we thank you for all of that. One more thing on this, when the annotated one comes out, that's going to be a very valuable tool, I'm sure, for many others. Will that be posted on the website for public to have access to? Yeah.
Through the chair, yes, we could post that. For example, we could do so on the planning development website.
I think it'd be helpful for all. So thank you for doing that.
Or actually, excuse me, now that I think about it, probably more appropriate if we post it. I could work with the CEO to post it on the county's commercial cannabis regulations website. 'Cause
There you go.
it's better audience.
Super. Okay, so I'm not a lawyer, but I may try to sound like one, and these other guys can
Go for
do the real deal. So one of the things was we looked at the map earlier that showed where the existing production spots were and how that was contemplated in the EIR. Not saying it's fact, but somebody earlier said there was over 40% concentrated on that 246 corridor of outdoor large grows. So in your EIR, did you discuss acreages and those effects on quality of life as they could? In other words, did you think, hey, 50% of the acreage could be right there?
Chair Park, Commissioner Farini, thank you for the question. There's kind of two things that are important to know about the overall methodology to the EIR. One aspect of it is what Mr. Clayman presented up here, that we had access to a registry of information of existing conditions and past conditions that helped us understand where and how. Every county, every place is different. If you look at City of LA, you're looking at an application list of only warehouse grows, really. In Santa Barbara County, the mix of potential cannabis uses was very different. A mix of outdoor, greenhouse, and indoor was primarily what we saw in the registry data. We knew that the registry data does not represent the project. That's not the assumption of the EIR. The EIR studied the potential for cannabis uses to occur in any of the areas that are legal. So the Ag 1, Ag 2 zones, and I believe it's figure. I could look it up for you. Actually,
The dots? Or
the areas of eligibility.
2-1.
Okay. Thank you. We'll bring this map up. Essentially, that figure depicts the areas of the study the areas of the county that we studied. It's areas where cannabis is eligible, and so the findings of the EIR apply throughout that area of eligibility. The registry gave us the leg up on what could happen and helped focus our analysis so that we weren't going down the wrong path and studying a bunch of warehouse grows when that wasn't what the data showed us that we should be looking at. So the fact that the registry data showed about a distribution, and forgive me, give me 1 second while we pull up.
41% outdoor.
Right, do you have that?
The breakdown between, yeah, 41% outdoor.
Oh, here, Matt. Here, just pull it up.
Yeah.
Thank you.
It was the page that we were on before.
Sorry about that. There you go.
41% outdoor, 3% indoor, and 57% mixed light grows. Oh, that's
yes.
Microphone. Sorry. On page 2-23, we have a breakdown of the different areas of the county that were looked at, along with the types of existing cultivation types. And in here, we remark that the mixed light grows, the greenhouse grows, are mostly concentrated within the Carpinteria area, whereas the outdoor grows are mostly in the areas of the county that provide that amount of land, or at least don't have that infrastructure at this moment.
So you saw what percentage would be outdoor grow?
41.
41%.
41%.
Right.
And that breakdown of the types countywide, as Matt described, we saw indicated in the registry data that outdoor was predominantly in the North County, and greenhouse grows were predominantly in the South County, and that was based mainly on land use and former land uses where infrastructure for greenhouses is already in place in Carpinteria and not so much in the North County. It's a different setting. So those assumptions, I would actually call them more indicators. The registry gave us an indicator of what would happen under the project, using cues from what has been successful in the past for medical facilities, and kind of, like I said, narrowed and focused our study to make sure that we were making the right assumptions in the different areas of the county. The EIR attempted to acknowledge that there's difference in these areas. The setting for cannabis in Carpinteria is quite different than the setting for cannabis in Lompoc and Santa Ynez Valley, Santa Maria. And for our team, we hear that echoed in the comments today as well. When we hear comments on Carpinteria, the issues are much more focused and aligned with the way that the issues are described in the EIR compared to the issues that are coming up in North County, which similarly in the EIR were addressed uniquely and identified uniquely.
So then, sticking with what we're hearing from the public, okay, if 90% of the terpenes are escaping during drying, is that contemplated in the EIR? And then is there also in the EIR this discussion of freezing to avoid those terpenes escaping into the air? So were those alternatives discussed in the EIR?
Sure. Chair Park and Commissioner Farini, the specific technology of freezing cannabis to contain terpenes so that they don't escape, I don't believe our team was aware of that technology at the time. That being said, the mitigation measure that set up the odor abatement requirement that now lives in the Land Use and Development Code in Article 2 identifies a range of options, including but not limited to active vapor control systems, carbon filters, and other technologies that may emerge through consideration of these sites. The idea with the mitigation measures is that the analysis identified the potential impact. It puts the burden on the applicant to bring forth a system that will work on a site-specific basis to achieve a particular result, which is protection of sensitive receptors from those odors, and to the extent feasible, containing those odors on site. So that's where it came from. The solution to achieve that outcome is 10 years from now we may have an amazing technology that isn't available on the market now, and it creates that flexibility so that it's a mitigation measure that is long living and is flexible to accommodate technologies that come forward. And then to also address your question about whether the EIR contemplated the escape of terpenes, i.e. odors, from outdoor grows, the answer is yes. So in Impact 5, Air Quality 5, we acknowledge that when terpenes escape, when that happens, that's when the potential for odor, nuisances, and also health effects can be experienced from sensitive receptors. That is one thing that we wove into this. Given that we don't have a threshold necessarily for public health, we do acknowledge that one aspect of odors is an inherent public health concern in addition to the nuisance concern. So the impact analysis and the narrative address those two issues, acknowledge that by odor control you're doing something for it, but it's, when you're dealing with an outdoor grow, there's little that you can do to actually control the odor, hence the finding that it's potentially significant and unavoidable.
Well, at the time, there was little you could do, but
Correct.
There has been
correct.
new evidence.
Correct.
Heard that.
That's right.
That there is a viable alternative, and so that's the challenge to me, is that there is an alternative to reduce those smells, and it's not discussed, and it is new information, and I don't know where to go from there with that.
Mr. Chair, Commissioner Farini, I think I'm not sure that we have enough information about Mr. Jafriel's process and whether or not it can be applied in a broad range to all the different type of cannabis grows. I've heard differing information about that. But if it is an effective tool and works with how a particular grower is processing, then I don't see why we couldn't discuss that as a possible additional tool to further reduce potential impacts.
Because you look at what CARP has done, and they've been very proactive in their approach to trying to reduce odors and do everything to be good stewards of where they live, eat, and breathe.
Sure.
And it seems that if we don't put some pressure on the outdoor grows, and we don't find a way to do that, it's going to take a lot longer, and we're going to hear a lot more of the same problem. So I'm encouraged by what we heard, and I'm encouraged by what you've said, and I hope that we can come up with a solution there. Thank you.
Are you done? Yes, sir. All right, batten down the hatches. Buckle up, you bet. I want to make some preliminary comments. One, I consider the ex parte disclosures we make, the disclosures of ex parte contacts, to be extremely important to the fairness of this process. And I realized watching public comment that there are a few that I left out. And I spoke with Mr. Titillo. I should have disclosed that. And after the Cannabis/Wine Tourism Forum in Buellton a few weeks ago, I spoke with a whole lot of people, but at length with Sarah Rotman and Aaron Weber. So I hope I haven't left others out. Something I want to point out today is that I'm extremely proud of our public comment. Those of you still in the audience that spoke, you did a good job, raised a lot of really important issues, gave us some very useful information. And I think that information is part of a conciliation process. This is not a binary solution kind of process where somebody wins all the way and somebody loses all the way. If you're naive enough to think about that, or to think that, well, what can I say? This is something that's a community issue, a community problem, and the community is looking at us in this room, including all of you, to solve it in some communally acceptable way. And I think that the kind of comments you made today are really useful for doing that. And I'm equally proud of staff. Mr. Higgins is still here. Are you still here? Yeah, and he heard me at the APA conference say that a way to be independent in the Planning Commission, and I think we have to be independent to help solve this problem. We have to work this one, folks. We have to work hard, do our homework. That a way to be independent is to utilize staff and get staff support if you earn their trust and respect. And I think that staff has delivered in spades here today. I think they see we need to go off and figure some things out, and they've given us the tools to do it. I'm really proud of you all. This is really good. Moving on to my questions. I take this part of it, the CEQA part, really seriously. Maybe not for every project, because not every project really demands that, but some do. And some of you were here for the first oil hearings, or maybe you heard about them or watched them. And I poured through that EIR with a fine-tooth comb for days before the hearing. And I presented a PowerPoint presentation at the hearing. And I disagreed with staff as to whether things were covered or not. And I appreciate all your efforts, but I may disagree with you this time as well. And I will go through this PEIR. And I appreciate you saying what's in it, what isn't in it. But where the rubber meets the road is to show us where it is. And that's why I asked for that annotated version. But I'm going to ask for the same thing with regard to my specific questions. Where are these things? Show me where they are. Don't just tell me they're there. Show me where they are, and then I'll read it myself. And then we'll be really prepared for these upcoming hearings. Fair enough? Okay. So the first one, and by the way, when I enumerate these issues, this doesn't mean that I've come to some kind of preconceived notion of where I'm going to vote on it, or that I even think it's an issue. I think it's an issue because people brought it up, not necessarily that it shows my own conclusion, because I don't have conclusions. But actually, I should address something else that's preliminary to this. I did hear some public comment today. The drift of it was that opponents of the PEIR were wrong. Well, that's okay to say. But, when we had our first hearing where this was brought up, I had just finished a trial the night before the hearing. I had no time to read any letters of public comment. So when I asked questions about the PEIR, that was all from me. It wasn't from anybody else. It wasn't from opponents of cannabis or anyone else. So we can explore these issues without being opponents of the cannabis industry or opponents of the PEIR. I think I'm a proponent of the industry and a proponent of the EIR, but I have these questions. So let's not make this a them versus us type of thing as much as we can. So to my issues that I think are some of them that we're going to explore. One is the concentration of operations in between Buellton and Lompoc. We discussed that at that prior hearing. One thing that one of the appellants, Sharon Merritt, has provided in her public comment letter was an analysis of the number of licenses that have been granted statewide and where they are. And if this is correct, it basically shows that over 10% of the licenses in California that are applied for are in between Buellton and Lompoc. And most of those are in my district. So that's an example of real concentration. Is it a problem? Is it not a problem? Well, that's what we'll be discussing. So the concentration of operations in that area, is that discussed in the EIR, and where? Give me a site. I would. We're here. I mean, I put aside my part of the day to come here and do this, and you're all here. And so, I could say, here, give me a list, and then call me Monday, and we'll have another meeting. But here we are with the public. Let's do it.
So there are 3 places within the EIR.
Can you put them on the screen?
Oh, sure.
I told you.
Well, yeah, great. The first one's going to be in the existing setting, which was that map with the general location of the existing operators, which was that one, 2-2.
Well, that was existing and past, right?
Those are existing and past,
Right.
which then inform, as my colleague had said, our assumptions, if you will, which then goes into the methodology section of the EIR, which on page 3-6, where we talk about where cultivation license types would be. In that first paragraph, the data from the registry indicates that cannabis cultivation tends to be concentrated in certain regions and communities.
Can you blow that up? I personally can't read it.
It's 3-6 under cultivation in the middle of the paragraph. Yes.
Can you blow it up?
Your cursor is over it, yeah. Yeah. 3-6. Yeah, the data from the cannabis registry indicates that cannabis cultivation tends to be concentrated in certain regions. Certain regions and communities, starting in the South Coast region and secondarily within the Lompoc and San Ynez regions. And the reason why it says secondarily is because in the existing settings / project description section, we had, before even doing the data point analysis, we had decided on 5 different regions of the county. And so that concentration that you're talking about is somewhat divided between those 2 areas, particularly Sabata Canyon, Tepiscay. They ended up in different data points, and Buellton ended up just in the way that the data went, a little bit split between the 2. That said, it still highlights the proportion of sites that we anticipated within that area.
Okay, well, that's a good example of what it says, and then the commissioners and people in the audience can decide whether that's sufficient or not, read it for themselves, so. Okay, so 3-6, and where else? You mentioned some
I
other.
was going to suggest on page 2-22, I believe it is, I'll get there, and 23.
And where was the map that you're referring to? What's
that's on page 2-19, that's this map right here.
Map.
So it shows the distribution, once again, of the existing operators at that time and past operators. And then on page 2-22, this is where there's a textual description of what's shown graphically in that map. And what you see here is the distribution of cannabis activity sites based upon those 5 regions that Mr. Bugert just described. So once again, you can see that between the South Coast, San Ynez, and Lompoc, that accounts for about little over 80% of the operations. And as I mentioned earlier in the rebuttal, that's exactly what we're seeing right now in terms of the number of applications and where they are focused in those 3 areas.
So that table 2-1 at that page, is that what you're referring to?
Yes, table 2-1 on page 2-22.
Got it. Okay, anywhere else where this issue is addressed?
I might, Chair Park and Commissioners, just offer that also in our methodology section, so section 3.0, which introduces the methodology of the EIR, we commit to this approximate distribution of locations as the basis of our assumptions about where things will happen. So we say, this is our best indicator of where and how cannabis licenses will manifest under the program. We carry forward this approximate distribution as part of our assumptions for what will happen in the future as well. So that's an important tie-in to our analysis of the existing registry data, because it formed our assumptions for what would happen in the future as well. And that's clearly stated in
Is
section
that in
3.
front of us right now?
It is, it's on page 3-4, the paragraph that we were looking at formerly. It is 2 sentences disclosing that the registry data identifies that the concentration of cannabis activity would occur in the South Coast planning area, Carpinteria, and then also the Lompoc and San Ynez areas, which are, as Mr. Bugert explained, 2 different areas that constitute that concentration along 246. Those assumptions about the locations of where cannabis would manifest under the program are carried forward. We disclose that in the following sentence.
Okay, so that's at 3.4. Okay, let me move on to another issue, and I'll go back and read those, and everyone should. This is one that I described at that hearing in August, I think it was. Just a question I had. It appeared to me that we had a real cluster of potential operations, as well as one that's existing, at what I call the western gate to the valley. You know, that's my old country lawyer talk, but that's really the western terminus of Design Overlay D. But you know what I'm talking about? Okay. And I wonder if that is addressed in the PEIR, the clustering of those operations at that point. We can all argue whether that's significant or not and what it means, but I'm just curious if it's discussed in the EIR.
All right, Chair Park and Commissioners, the answer is yes. So the clustering that was depicted in the figure, in Figure 2-2, and the identification that the San Ynez and Lompoc areas would experience that clustering is kind of the overarching assumption for the EIR, and those assumptions manifested uniquely depending on the resource that we were discussing and analyzing. So, for example, in the case of aesthetic impacts, the aesthetics resource impacts for the program itself identified that there would be a potential for cumulative effects of all the cannabis happening plus other development in the county. That could have an impact on community character, on visual resources, including vistas and gateway views, channelized views over scenic areas, those defined by the county and those that are identified through the course of implementation, and then the appropriate mitigation would be to hide that effect. And that's the screening requirement. So using landscaping
or setbacks.
Exactly. So, at the end of the day, particularly cumulatively, we could foresee that would be a potentially significant impact when this much change, is foreseeable, especially in clustered development, that there wouldn't be enough screening or site design that could actually avoid the collective change in character or visual quality. Because we couldn't say that for sure, the finding is significant and unavoidable, but the tool is there to minimize that effect to the degree possible, site by site. Correct.
So I hear you saying, yes, it's there, but I'm skeptical and want to look at it myself, so let's get those citations and show me.
Terrific. All right, Chair
Like pulling
Park.
teeth, isn't it?
Oh.
It's good for you.
It is good for us. Thank you, Chair Park and Commissioners. On page 3.1-23,
Okay, can you go there?
and this is in section 3.1, Aesthetics and Visual Resources. We discussed the impact of cumulative development under section 3.1.4.3,
Blow it
cumulative
up
impacts.
so old people can see it.
And I might draw your attention to the second paragraph addressing cumulative impacts associated with the project would include potential changes to scenic resources and existing visual character associated with increased canopy cover, hoop structures, greenhouse build-out, and additional acreage for ancillary development combined with proposed development. And that this collectively together would be potentially visible from a public area or within proximity of a scenic road or highway.
Anywhere else to support your conclusion that it's covered?
Mr. Chair, I'd like to suggest that we identify as many as we can now, but that we have the opportunity to share additional information once the hearing's over, because...
Exactly. I'm
Yeah.
not going to stop thinking about it.
Okay.
And we won't have our first hearing until October 30th. So I have plenty of time.
Okay, great.
But this gives me and the public the chance or an opportunity to learn what you've got and verify it. Okay. Was there another place?
Absolutely. On page 3.1-19,
point?
In context of the programs, the program-specific impacts, we address the impacts of outdoor grows in the Lompoc, Cuyama, Santa Ynez, and Santa Maria regions.
Are you on that page right now? Can you blow it up so that, like I said, old folks like me can read it? Great.
Mm-hmm. This analysis, yes, this analysis is just generally, what the potential changes could be in the different regions of the county, acknowledging the different site settings for South County versus Lompoc versus Santa Maria, and then identifies impacts associated with different types of cannabis, including outdoor grows versus greenhouses, hoop houses, et cetera, because they're quite different. And how those impacts would manifest in terms of impacts to visual resources, which include scenic vistas, scenic roadways, public areas, and the like.
Anywhere else?
Just to tack on to what Ms. Leachman said. So what I've brought up here, this is further down on page 3.1-19. This is where it specifically goes into outdoor grows. And as you can see in the first sentence, outdoor grows are expected to be more common in the Lompoc, Cuyama, Santa Ynez, and Santa Maria regions, as these regions contain the greatest acreage number of parcels eligible for cultivation. And then it walks you through the types of impacts that you're likely to see.
Yeah, and I'll read that and see if that addresses what I believe are some impacts and see whether that applies or not. Let me move on to one that I haven't discussed before with this group, I don't think, but it's one that's become of concern to me, and I'll explain a little bit. As I drive along the river, of course we're talking about the Santa Ynez River, I see some areas that are cultivated currently in cannabis that I've never seen cultivated before. Remember, I've lived here forever, meaning my life, and I can remember what it looked like before the '69 floods and afterwards. And we have some areas that are river terraces that are just nothing but sand, and nobody's been planting those, but there are cannabis operations down there right now with that are covered with hoop houses. And I know that when we looked at the hoop house ordinance, we really didn't get much of a rise out of flood control as to whether in floods that the plastics would be a problem. But I see all that infrastructure, and I wonder if there's another flood where that stuff will go and where it'll hang up and what bridge and whatnot. But I also wonder about the effect on the riverine biology of planting in places that really no one else plants. And it raises this odd dynamic to me of a crop that has got such tremendous crop value being grown in the cheapest possible places in some ways. So I'm just wondering if this is addressed anywhere in this, because it's something I'm going to want to give some more thought to.
Let me just generally address this first. So Chair Park, I do think it's important, first off, to make it clear that, well, I don't know the specific location you're looking at, and second, I don't know whether or not that is an operation that is operating under the new regulations or if they're operating under a legal non-conforming status. And the reason I bring that up is important because the rules that apply to legal non-conforming medicinal operations are very different, much more limited than what applies under this new regulatory regime. And with the new regulatory regime, we would, if we got an application for a cannabis activity in the location like you described, there'd be a number of requirements that come into play. So the first thing we'd be looking at is we need the biological analysis of, what are the impacts of doing this cultivation activity within proximity to the Santa Ynez River. We'd also be looking at the visual impacts. I gotta say though, with regard to the flooding hazards associated with hoop structures, you are correct. The flood control district did look at that and found that the installation of hoops would not be a significant flooding hazard. However, what I would say is that in the case of cannabis, there are setback requirements that apply to, for example, the Santa Ynez River that do not necessarily apply to hoop structures, which are for the purpose of cultivating other types of crops. Once again, there are specific requirements just for cannabis to address biological resource impacts, and we'd be looking at, once again, the analysis of those biological impacts and making an evaluation as to whether or not, one, we got to do new CEQA because you have new impacts that were not evaluated sufficiently with this programmatic EIR, and then second, do you comply with the standards and is it supportable? So I bring that up because there's been a lot of confusion between the mostly unregulated, and I say unregulated in the sense that it's not subject to the current cannabis regulations, medicinal environment, which has mushroomed since 2016. People are looking at that and they're saying, ooh, that's the problem with the new regulations, but they're confusing that mostly unregulated environment with what is allowed through this program. So I want to make that clear. So
I get it, and it's, I'm one of those confused people because members of the public, and I'm one of them, we're generally going to assume, okay, if I can see it from the road, so can you, so can somebody else. And that if there's an unregulated illegal grow, that somebody ought to do something about it. And so when I see something like that, and by the way, I'm not going to name names right now, and it's more than one operator, and it's not any operator that's in this room, or has been in this room today. It makes me think, well, gee, it must be something that somebody thinks is allowed, and it leads me to my question here: is that kind of thing, that riverine grow on those kinds of soils, is that something that's discussed in this EIR? And it's just something I'll be looking for, and if you know whether it is or is not, then let me know. If you don't know, then you don't know, and we'll move on.
Mr. Chair, before Ms. Leachman and Mr. Bugart respond, one thing I just wanted to bring up, which I think is a little bit confusing to the public as well, is that previously being cultivated as a medical marijuana operation included preparation of the ground. So you may not have seen a cannabis crop there, but they had been prepping it for the cannabis medical marijuana. That was counted as part of something that would have been considered legal nonconforming. So you might be seeing things that you hadn't seen before, and you're wondering, like, how did that crop up all of a sudden? But they presented information that indicated they were prepping the ground, but they will have to get their permits. They're non-conforming, and they're in the process to get permits. And so setbacks to the river and those types of potential biological impacts will be studied in those particular circumstances. But I'm sure the biological section of this document discusses growing cannabis adjacent to riparian corridor and other biological resources. So, Ms. Leachman, would you like to take over?
I think it would be bound to, but...
Great. Thank you, Commissioner Park and commissioners. I think I would point you as I think my bigger answer is that we address the potential impacts to ESHA, water bodies, riparian corridor, and other biological resources throughout the biological resources section, which is chapter 3.4. Specifically, I would point to page 3.4-44. In context of the cumulative impacts analysis for biology and biological resources, where the EIR discloses that the
Show me on the screen while we're talking.
Oh, thank you. 3.4-44. Great. At the top of the page, we discuss the potential impacts to a range of riparian habitats and ESHA, environmentally sensitive habitat area within the county. We give a few examples. It's not an exhaustive list. If we identified every area, it would be a pretty long list. But acknowledge that ESHA it's mapped in the county in many places and defined by the general plan and the comprehensive plan. The EIR discloses that the cumulative impacts associated with the project would include development near water bodies and ESHA that may include grading and paving, which have the potential to result in vegetation clearing, soil erosion, and pollution, sediment pollution in downstream water bodies. And also I might also refer this analysis, that because of its relationship to flooding, hydrology, water quality, to section 3.8.
Can you go there?
Great. And specifically page 3.8-32. The analysis specifically identifies not just cannabis operations, but the potential for structures, including hoop houses, to change hydrologic conditions on a site, including groundwater infiltration and the potential for sheet flow off the site. We identify an impact, HWR-3 and HWR-4, that cannabis cultivation could potentially have adverse effects on existing drainage patterns, so surface drainage and then also percolation rates. That being said, what the EIR analyzes is that with at least with structures, with hoop houses, in terms of infiltration, the coverage of hoop houses doesn't appear to actually prevent percolation, that the spacing and there's enough ground surface to allow for percolation on site. That being said, this issue was also reviewed as part of the county's efforts on hoop houses to address the potential impacts of hoop house and its effects on hydrology and the other effects that could occur related to water bodies, ESHA, and riparian corridor areas. Oh, thank you. And Mr. Brugger just pointed out that issue, and because the hoop house project was considered a cumulative project for this project, we knew it was on the horizon. We acknowledged it where we could in the cumulative setting and in the cumulative projects analysis for both of these resources, that hoop houses permitted under a separate section in a different process would be subject to the regulations applicable to hoop houses to protect these resources, in addition to the regulation that is applicable just for cannabis projects.
Do you have any other page citations you're aware of right now that I should review to address my concern? Then let me move on to another issue. And Director Plowman spoke about some of the non-conforming uses. And as I'm sure you are all aware, there are members of the public that believe that there were literally false affidavits filed as to whether uses were existing or not. And the question is, are there going to be consequences from a planning point of view? Okay, from a planning commission point of view, at least that's a question I have. And so I'm wondering if this is addressed in any way in the PEIR, where you have non-conforming uses, where affidavits that were not truthful, accurate, whatever you want to call it, of prior cultivation were filed.
Yeah, so Chair Park, I want to clarify. So at the time the registry occurred, which formed a lot of the data on which the analysis was based, there was no self-certification process envisioned at that point. That was something that came a little bit later. And so it's not really addressed in the EIR, but that really does not change the EIR analysis, because what the inventory did do is it did take an inventory of everybody who was operating up to that point. And in order to continue operating after the ordinance was amended, which required the self-certification process, those who wanted to continue operating, which were captured in the data, had to come in at that point to get the self-certification in order to get their state temporary license initially, then provisional license in order to keep operating. With regard to a question about if somebody falsified their affidavit, how would it affect the planning aspects of this program? It wouldn't. However, it would definitely be a consideration for the business licensing aspect. This summer, the board amended the business licensing ordinance such that if there's any violation of the business licensing ordinance, including but not limited to falsifying your affidavits, that could be grounds for denial of a business license application. So,
and some of these questions, if somebody does ask them with regard to a given project, I want to make my own determination. I just want to see if they're addressed anywhere in the PEIR. So that's something I should be looking for.
Yeah, Mr. Chair, that's not an environmental potential environmental.
So you wouldn't
impact.
expect it to see.
So you wouldn't expect it to see it in the PEIR. But I do want to point out that there are circumstances where we've identified violations of people we believe provided misinformation on where they had medical marijuana being grown, and we have pursued that in circumstances where it's been we've had the available information to be able to make that determination. And we have required that they remove plants from sites and contain it in the area where they were originally growing the medical marijuana.
Okay. So my last general topic here for this part, I'm going to have some specific questions in a moment, is impact on other forms of agriculture. And that could vary from land prices, impact of BVOCs on grape products and things like that, and impact on the AVA, the effectiveness of the AVA. I mean, so is this topic, either those issues or otherwise generally, where does that show up in the EIR? So I'm not talking about air pollution control district and pollutants. I'm talking about impact on other forms of agriculture. $10 minutes. Maybe 15.
Mr. Chair, Commissioners, thanks for your patience while we flip to the right location. I would draw your attention to page 3.2-20 as the primary discussion of this topic and its relationship to other county planning bodies, including the APAC and the Planning Department. We acknowledge in the analysis that we have this cannabis use and this agricultural use intermixed with other agriculture in the county, and address this in both a land use compatibility way or approach, and then also a potential agricultural approach. When we're analyzing ag impacts, as we mentioned in the presentation, the impact to ag resources, including prime farmland, prime soils, was identified as the key issue related to agricultural resources. But the setting for the resource it goes into detail about this issue specifically and how it's addressed through existing county regulations.
So this is this language you've got in front of us right now?
Yes, I would suggest those two paragraphs. I could read them.
And I can't see the page. It's 3.2 what?
20.
Anywhere else?
This is the main nugget.
In addition to what Ms. Leachman contributed, I also want to just point out that some of the issues you generally discuss during comment, those are social and economic issues, and in CEQA you only evaluate those to the extent that there's a corresponding physical impact to the environment. So the social and the economic aspects aren't what are evaluated in CEQA. You look at the resulting physical impact. So to look at social and economic issues like the impact on the AVA, you then need to make the next step to show that there is a consequent adverse physical impact to the environment. That's what would be the subject of the CEQA analysis. You would address the social and economic issues elsewhere. Like, for example, when the board was considering whether or not to adopt the program, they're taking into consideration the social and economic impacts on the community. Once again, that's not a CEQA issue, but it was considered when considering the program.
You know, I think you're literally correct, but consider if you find an unavoidable impact, and now you're looking for overriding considerations, then you might look at those social and economic issues, because it's social and economic issues that supply the overriding considerations, so you might look at the social and economic negative impacts, so to speak. So,
and I would say that was definitely evaluated when considering the statement of overriding considerations. I was just describing in the CEQA context in terms of an impact under CEQA. Social and economic impacts are not in themselves a CEQA impact. So that's my only point.
So that's an example of some things that I wanted to find out in the PEIR. I think you've been very helpful in showing me where to look. I'm going to turn to some more specific things relating more to the other tools that Mr. Clemon explained are available, other than just looking at the PEIR. I'm not sure how to phrase these. Well, I'll phrase this first one as a question. Does the lack of a specific requirement for an odor abatement plan in the ordinance for certain areas mean that the County Planning Commission cannot, 1, consider odor as an impact, and 2, consider mitigation of odor? Because I think that, yes, it's appropriate in places that the ordinance requires an odor abatement plan. This goes to Mr. Farini's questions. But I think even in the absence of a requirement for an odor abatement plan, that we can still consider odor as an impact and consider mitigating it. Am I wrong?
Well, the determination of the impact was already made under the EIR. It was, once again, cumulative class 1, unavoidably
I'm not talking about
significant.
EIR, I'm talking about...
I know, I'm getting there. So, but
Good.
now the task is, number 1, you ask, is this activity within the umbrella of the PEIR? If the answer is yes.
I'm not.
Okay, so you're saying
I
then
might
no.
be using all those tools that you explained, and some of those tools are going to be consistency with the general plan, and I might find that in my discretion as a planning commissioner that some of these things, regardless of what the PEIR says, are inconsistent with the general plan in some manner.
That's a different question. Yeah, so-
but that's the question I was asking.
Okay, so that one, that's correct. Then the answer is
And
yes.
so I believe that just because the ordinance doesn't require an odor abatement plan for Ag 2 properties inland, okay, that are not subject to CUP, that we still might find that it is an impact of that's in relation to policies, including the general plan, or rather, what do we call it here in this county? The comprehensive plan.
If
and
you
that,
can-
and that we can consider mitigation of that.
In that context, I would say the short answer is yes, but more precisely, you want to tie that to your authority under the ordinance to make the findings. I would not recommend you characterize that as a CEQA impact, because once again, the CEQA aspect of it was already addressed by the EIR. But you do have, once again, other findings.
I'm getting that. I'm just sort of, I don't want people to think that just because it's not in some parcel that requires an odor abatement plan, that the Planning Commission cannot consider the issue, okay? And that may give hope to some people and be depressing to others. I don't know.
Mr. Chair, just if I might add something, I think what it has to be tied to is some requirement in the Land Use Development Code or the comprehensive plan or community plan. You'd have to tie it to that.
Right, and we know that one of the required findings is that it's consistent with the comprehensive plan. So these
Right.
things kind of go in a circle, don't they?
They can.
So a good example of what Ms. Plowman was describing, in the San Ynez Valley Community Plan, there's a general odor control policy standard in there. And if you find that the project doesn't comply, let's say it's Ag 2 and it doesn't require a conditional use permit, but it's still subject to that policy or standard of the San Ynez Valley Community Plan, you may find the project inconsistent with that policy or standard, and that may be the basis for a denial. So.
Yeah. Let me move on then, but this also on odor abatement. We've had a lot of discussion today, and we've had discussion, when did we have it? On the G&K appeal about odor abatement. And what we focused on was what I call after-the-fact odor removal or neutralization. You know, once you've gone through your whole process of whatever you're doing at that facility, then what do you do to keep any resultant odor from migrating and being offensive to people? Okay? And I think that some of the folks in the industry have made a very good job, done a good job, including Mr. DeFriel today, of pointing out that there are things you can do all throughout the process that will affect odor. And it's appropriate to look at those things. And it might be giving credit to those who do those things, and it might be requiring it in some way. But it's I guess that's a statement or even a question. Does odor abatement necessarily include only after-the-fact odor removal or neutralization? I think not. Am I wrong?
Mr. Chair, Commissioners, I'd be happy to point out a couple things related to the requirement for an odor abatement plan. The most important thing is that the measure requires odor abatement. I can just read it verbatim. Odor abatement strategies within the cannabis activity site that would be implemented to prevent persistent, intrusive, or pervasive odors outside the property boundary, particularly within any nearby residential neighborhood, including but not limited to, a range of suggestions, including activated carbon filtration systems, vapor phase systems, which are neutralizers, odor neutralization technologies, and also other odor control systems or agricultural practices that can be shown to be effective in controlling odors. And I might come back to the presentation where this measure was designed to put the burden on the applicant, to come in and present a solution to the odors that could and will emerge from the site. In a site where odor is not a concern, then the strategy might be pretty minor, maybe nothing, maybe it's not needed. But in a situation where odor has that potential, that first potential to be persistent, intrusive, and pervasive and perceptible outside the property boundary, that's what triggers the requirement to do something, including the specific technology, something active, as you mentioned, something that happens in response before everything escapes the property site, but also leaves that flexibility to come forward with a menu or a palette of options that in concert would work to create that result. I guess the last point I'll just make about that is that that one other tool is an adequate distance. So that's built into the measure as well, that an adequate distance from residentially zoned neighborhoods could be maintained to avoid the odor impact, and that the permitting officials have the discretion to determine the necessity of the system.
And just to tack on to what Ms. Leachman said, and I also want to say that the development standard that was adopted as part of the ordinance, it's actually I would say more restrictive in the sense that it did not limit odor control to just the situation that's described in the mitigation measure, that is the pervasive, intensive, and consistent. I'm muddling the adjectives that are used. Those adjectives do not exist in the development standard. We did that on purpose because the board wanted to broaden the odor control requirements such that we don't want to get into a debate as to whether or not the odors met those three criteria, those adjectives, before applying odor control. They just wanted it to apply across the board, so to speak, with the exception to the Ag 2 zone.
Well, don't get me started on the drafting of this ordinance, but I'll point out that the ordinance seems to say that you don't actually have to show that you're eliminating odor. You just have to show that you got an engineer that says that you're using best practices. And you remember my comment about that report that was before us on the G&K appeal. It said the least amount that it could say on the subject without saying nothing. Were you done, Mr. Clement?
Oh, I was just going to say, actually, I'm looking at, well, this is the LUDC, and the same language is in Article 2. This is on page 4-53. Gosh, don't ask me to read the section number. It's way too long. But subsection 6 states, in pertinent part, the odor abatement plan must prevent odors from being experienced within residential zones as determined by the director. There is the standard. So it's not that you just prepare a plan. You need to prepare a plan that will meet that standard as approved by the director.
But the way it gets enforced is when there's absent the G&K style condition of approval we added, was basically something that didn't get enforced until somebody complained after the fact and after it was installed, and then it's up to the golden nose to decide whether it really exists or not. And you didn't want that responsibility. That's why we came up with that condition of approval. But getting back to this thing about is it only after the fact systems or not we're looking at, in general, I want to get away from check the box planning where, okay, this comes into play, check the box, and then it's not a problem. The public's complaining about odor. They're complaining it's a public nuisance. I think that those growers that come up with practices that throughout their whole operation eliminate or minimize it, they should get credit for that, and it should be something we consider, and it should be something considered for the public. So that's a statement, I guess. That leads me to my last thing. It fascinates me, this potential interplay of conditions of approval, project descriptions, findings. So let's say somebody tells me, gee, I've got a whiz-bag thing for eliminating odor, and this is how I operate it. Okay, Mr. DeFriel has mentioned, for example, the freeze drying, the flash freezing of the product. And I've also heard from different folks in the industry that there may be a kind of industry drying facility in Lompoc that may come up. And so there are things that are practices that may make this odor problem much less of a practical concern. How do we incorporate those kinds of things? Do we put it as a condition of approval, say, well, then thou shalt do flash freezing, or do we say, well, that should be in your project description, you know, we approve that, so we expect you to live up to it? Or is that something that shows up in the findings? Explain that to me if you can even understand my question.
Yeah, so Chair Park, this is a great example of why we want to keep our options open, because that specific procedure works for Mr. DeFriel's specific operation. I don't grow cannabis, I'm not a cultivator, but I have discussed this with other operations where it doesn't work. So for example, if you're in the business where you're doing extracts, that process works very well. However, for those who want to have a product that consists of a pretty flower, you're selling the bud, that process does not work as well. So you could not just say, hey, just use that process to come up with your product, because it doesn't work. Once again, that's why the mitigation measure was drafted to be open to come up with various options depending on the site and project specific characteristics. Now, with regard to requiring
I'm just asking generally how we incorporate these things, because people will come before us, and I don't want to have a one-size-fits-all kind of plan for every cannabis grower saying you must do this and that. That's kind of invasive, and what do I know? They know a lot more than I do. But if they come up, I'm going to expect them to give me their best description of their best project to get approval, and then I want them to live up to it. It's fair enough. So how do we do that?
So then, as I explained earlier today, then you'd be looking at the specific development standards, policies, findings that apply to that specific project to see if any of those provide you the discretion to impose such a requirement. And then if so, you can go ahead and ask for it. And I'm being rather general.
So I'm assuming that I find a way that they do, then do we do that as part of the project description or in the conditions of approval or in the findings? How do we do it?
So the way, actually, I'm assuming that all of these are on appeal to your commission, and that's when you'd be considering it. So when we provide you with the staff report that provides the analysis, for example, of the project's consistency with the comp plan policies, when we're describing the evidence to support the findings that are made, it is there that you provide substantial evidence to support why you are applying any given condition of approval. If you feel that what we have provided in the staff report is insufficient, you can set forth in the record specific considerations that you believe afford you the authority to impose those sorts of requirements. But once again, you always have to have that nexus back to some sort of requirement in the comp plan which affords you the authority to do so. And as Mr. Cooney was touching on earlier, the degree of discretion is going to be dictated in part on the type of entitlement that's required for the project. As I described earlier, conditional use permit findings, there's more considerations that go into it as compared to a land use permit. But even in the case of a land use permit, you do have discretion when determining project consistency with those findings that apply to the land use permit.
Mr. Chair, I just wanted to add one thing, and then Ms. Richardson will add something. But I think it's possible that we'll be in a process where there'll be a permit before the Planning Commission, and there'll be a proposed odor control plan, and they'll implement it, and it won't work, right? It won't work to meet the standard that's in the code. Then it's going to be an iterative process with that applicant to get it to work, or to implement some other technology that does work. And if they can't get it to work, like we talked about in the G&K appeal, then they're not going to be able to continue to grow. So I think we just have to be...
And you're speaking specifically to the ones that are required to have odor abatement plans.
Correct.
Yeah.
Correct.
I think that concept, I might even broaden the concept, and we'll look at that.
Mr. Chair, Commissioners, I just wanted to clarify one thing. So for something to be enforceable going forward, it needs to either be in the project description or the conditions. And the project description is proposed by the applicant, and the county doesn't have the authority to make changes to that. Sometimes an applicant maybe hears the commission's feedback and proposes a change. But if they're not willing to, then whatever you're describing, the appropriate area to put it would be in the conditions of approval.
Well, and that's what I thought. And it might come, we come to a hearing and think that something's important, and it gets continued and the applicant may decide to want to modify their project description, or because they don't want to see it as a condition of approval, or maybe we do it as a condition of approval. We'll do those on a case-by-case basis. But I just think it's important to discuss this now in our discussion of tools, so we can do our best to process these. And I think I've exercised this horse enough today, so I'm done.
Mr. Oh.
Oh, okay.
There, there is one step that I think we need to take. I mean, basically, today's proceedings have concluded. So we're happy to entertain additional questions either today or as they come up as we work through the process on the different permits. That's unless there's some other questions that the commission has that they need us to respond to, and there's some interest in continuing an item beyond today, maybe to the 9th. But if we're, I don't see any burning reason today to do that, but it's up to your discretion. If we don't do that, we need to cancel the 9th.
Yeah, I think so. Commissioner Cooney thinks so. You think so?
Okay. So I'm sorry, I thought we had done questions and then we were going to have deliberations. So have we just finished deliberations too? Because
No,
I had a couple other.
If you have other comments, then we're not finished, and we'll field those.
Okay. Because I don't know, you're going to go back to you're developing adjustments to the program to go back to the board. The Ag Commissioner is doing their outreach with the Blue Ribbon Committee, for lack of a better term. So there's various things in play, and we're being asked to do anything in terms of the programmatic things, or making any recommendations to the board about it, only via appeals that might be before us, is where we're going to be struggling with it, right?
Separate path. The legislative piece, amendment of the ordinance, okay, is not before us today.
Right.
We're not doing anything about it today. We will get it at some point, maybe late fall, I'll bet, sometime this year. But that's not in front of us today. What we're talking about today is just having a better knowledge of the PEIR and what to do with it, and other tools for application to the specific projects that'll start coming to us as early as October 30.
Okay. So my frustration with this is that I think that the county did this in light speed. I've never seen a programmatic EIR drafted. It's very good, by the way. I think, if I was going to pick it apart, I could probably find some stuff about baseline assumptions and all those things that have changed since the time it was published. But as a practitioner, if someone hired me like Mr. Chatillo, I could probably pick it apart. I am philosophically opposed to using CEQA in that way. It bothers me. It's bothered me more and more every year, the more lawsuits are done by that. But that said, I think today's session was really helpful in pointing us to the places where we can tag on conditions, because the part that I think was missing in like the Pence appeals, and I think that's the only one that I really heard from start to finish pretty much, is that there was a check off the box. It's consistent with CEQA per the programmatic EIR, and then you had no way to address public comment or concerns or new information like Mr. DeFriel's method for freeze drying bud or whatever. So I guess I want to fix the system. I want to because right now I feel like it's broken because what you have is a constant cycle of appeals. Someone actually does this under the programmatic EIR, check off the box, you get an LUP, it's appealed, it's here. We do something one way or the other, it's appealed up to the board. That's going to be a circular situation until we figure out some way to give the Planning Commission something to hang their head on that says, okay, we can approve this project, but here's the additional conditions, right? Here's the odor control that we want to see applied. So before today, I was thinking the only way we could do it is ask your staff memos to have more analysis in terms of compliance with the programmatic EIR, or just go into a little more detail about, how is the project going to happen? Here's what the site-specific conditions are like. Here's why the programmatic EIR addresses this, and therefore we can concur with that or not. Because what I'm hearing on the street is that a lot of the things in here, it is so broad. I understand why you had to do it, but then when I'm getting down to people like crying to me about being sick over cannabis smells in the middle of the night, I'm not sure where I find that here. So you told us that we have these other tools to try to address the permitting on that micro level, right? And I guess the discussion today is just more informative for us, but we're not expected to give you any feedback for you to take forward to whatever other adjustments are going to be going to the board straight away. But I did hear you correctly that they're going to be routed through us for comment.
Mr. Chair, Commissioner Bradley, yes, we will be bringing back some set of ordinance amendments that the board directed us to return to the Planning Commission, work with the Planning Commission on, and then we will be going back to the board. That's going to be starting in late fall, that process, late fall, early winter. It was added to our work program. And so we'll have an opportunity to talk about some of these issues. And there were sort of what drove that process were questions about buffers next to places like Los Alamos, where you have these Ag 2 grows, and ways we might incentivize people to set back from those urban boundaries, things like that. So we're going to be developing a variety of tools that we can bring back to the Planning Commission as a method to try and resolve some of the concerns that we're hearing in the community.
Okay. I think that's all I have. I just want to make sure. So this was kind of an interim. Here's another playbook for you to use on the interim for the cases that we're going to be seeing on appeal, because we know there are lots. So this is just keeping us at bay until we see what the next version of the ordinance is.
Mr. Chair, Commissioner Bradley, I think that's correct. I think I don't want to be a pessimist because naturally I'm an optimist, but I think the appeals are going to continue to come because there are probably some issues that are going to be really hard to resolve. And that has been by some of the policy that was adopted. Mm-hmm. Some people just, they don't feel comfortable with it. Mm-hmm. And so that process is probably going to continue, unfortunately. Maybe as time evolves and this particular type of agriculture, if you will, is more integrated in the community and the market settles out, things will be, and we will get our permits in and we will have odor control where we can. Maybe things will improve over time. I mean, that is my hope, that things will improve over time for people, and then we can try and solve some of these problems.
Okay, well, through the chair, I really appreciate that. I just, I've said to everybody that I've talked with, pro and anti, I've never seen anything like this in land use. In fact, I had this conversation with Mr. Clement. I said, this is the most bizarre case. He had a mushroom farm that beat my recollection, but because even the cell phone towers of the 1990s, it was a longer fuse before you are at this point. Right now, we've got an urgency on the part of the applicants. I don't want to waste their time. I don't want to waste their money. And yet you've got this reverberated reaction from the public that is just as passionate and concerned about it. And I can see both sides. So it's truly bizarre. I think that you guys did an admirable job on the EIR. And I love the concept of programmatic EIRs. I explain it to people it's like the Orchid Community Plan. You want all those key sites to bounce off of your foundation and go through the process easily. It's just that this thing has been so dynamic and so lately understood by the public that it's not a straight path. So thank you for your patience.
Okay, so that leaves October 9 hearing. I don't think we need that hearing for more of this, what we're doing today. I don't think staff does. I hope you don't regret that you suggested this in the first place. Good. And so, Commissioner Cooney, do you have a motion to cancel October 9 hearing?
Quick as I can. I move to cancel the hearing of the 9th.
Who's going to chime in with a
Second.
second? There you go. All in favor, please say aye.
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 Okay, we ready to go home and adjourn?
Mr. Chair, I just wanted to say I really appreciate the patience of the commission and the public today. I thought it was, I thought staff did a tremendous job in preparing for it. And I think refreshing everybody's memory about what was covered and what tools are available to the commission, I hope will make the process a little easier for people and the commission in particular.
And kudos to Ms. Leachman,
Yes.
Ms. Leachman, Mr. Buggert. Consultants do not get the recognition that they deserve at times, and we really appreciate their help on this. No joke.
Very good. Job well done by everybody. Meeting adjourned.